कालके तो हम लोग का ही सेवा है कुछ नंबर है। लेकिन तो
Yes, 200.
Well, 207, my lord.
Ah,
My lord, I am praying for upgradation.
why?
My lord, your lordship was hard, pleased to heard this matter, and when the order was about to be passed, my lord, it appears that stamp duty was deficit.
Ah,
And my lord, I cannot, my lord, have financial assistance from the bank or for the non-availability of title deed.
Hmm.
My lord, I have made payment everything. The respondent are not registering and executing the deed. That is why it is urgent, my lord. If your lordship can accommodate, my lord.
but where is the time?
I know your lordship can, my lord.
22nd को कर दो.
My lord, in respect of item number 3,
Crores persons of the Indian are unemployed. Crores of the Indians are unemployed.
We have applied for under section 7. Neither state of India giving me work, nor they are giving me according to the act, section 7. They are giving me my lord remuneration.
এখন অর্ডার দিয়ে দেবে উইদাউট ব্রিফ
My family is a payroll of my family. You know, kindly take up this matter as your office already. Kindly 558 of your office.
Come after vacation, I will hear. Before vacation, there is no time.
item number 541, my lord.
Are you given undertaking that you will work during the vacation? I will take all the other. I will take the matter. Yes. Okay. Okay. Then when the schedule is fixed, I will take the matter. Then you mention. Yes.
High Court order option was conducted.
Okay. Come. Only matter of the 20 days. Come after 20. Okay. Please wait for the 20.
My lord,
Yes.
my lord, I am paying indulgence.
Relax, sir. I appreciate your anxiety, but kindly see the situation of the court. If all within this 5 days, if I fix all the matter, the urgent matter, no matter will be taken up.
Yeah, all have matters.
Okay. Go and give the speech to the parliament, the assembly. Not before this court. Please mind the language. This speech is not acceptable before this court. I will not take up your matter before this court. Yes.
My lord, item number 541.
If you want to give such type of the speech here, please go out from the court.
My lord, item number 541, my lord.
Yes.
For upgradation, my lord. Upgradation, my lord.
No upgradation up till
My lord,
before
this is a
vacation.
motion. My lord,
Only if any urgent matter is there.
Lord,
Extension of
Lord, may I have your lordship's?
No.
Lord, may I have your lordship's kind leave to mention one very urgent motion, my lord.
What is urgency?
My lord, urgency is that, my lord, it is against an MSMED award which has been passed in the second day of arbitration. Without any signature, the awards have been given in violation of section 35, and the judicial function.
Why here?
My lord, because, my lord, principles of natural justice involved and jurisdiction. They have
award. Go to the MSCT.
Yeah, they have not served me the served copy. They have not even served me the served copy. They have delegated their power to the charter accountant.
You are challenging the MSCT award.
Lord, I will satisfy your lordship on several cases. Kindly, yes. I am suffering, and there is an execution, my lord. There is an
motion.
Lord, let it at least included in the list.
My lord. It was in the list due to changes of determination.
Let it at least included in the list because my lord, it was supposed to appear on 3rd of December. It is not yet appearing, my lord. Only inclusion.
The matter is fixed tomorrow. This is very urgent. because of the, my technical bits have been cancelled in respect of 4 tenders, that is more than 4 crores involved. With an illogical clause violating the government GFR rules 2017 and financial bid also opened.
When the tender was open? When the tender was open?
Tender was opened here, last month, but financial bid already opened and they are proceeded for awarding final order. That will
When
be
it was intimated to you, you are not qualified.
just
When it was intimated to you, you are not qualified.
4-5 days before.
Yes.
4-5 days before, immediately I have submitted the writ. So matter before the final decision. No matter it is listed tomorrow.
So
And
it is listed tomorrow, it will be listed.
It may be taken under the head to be mentioned for very urgency. Otherwise,
Tomorrow under what heading it will be listed?
under
What heading it will be listed tomorrow?
new vision.
New motion. Let it be remain.
My lord, may I be permitted?
Not be under the head to be mentioned.
Tomorrow it is there already in the list. Let us see. Yes.
My lord, remission matter, my lord,
My request.
remission matter, my lord.
What matter?
Remission matter.
Remission.
22 years, 6 months in the custody, my lord.
Ah.
It is listed in the daily supplementary list, but number is 423 and 427, my lord. Kindly. my lord.
Come after vacation. Come after vacation. I will take the matter. Come after vacation.
My matter be only included in that. Only for inclusion.
Upgradation come after vacation.
Only for inclusion, my lord.
Come after vacation, upgradation will teach.
My lord, inclusion only.
Also inclusion. Maybe even after paying entire amount in a auction, my lord, not handing over the possession, my lord. And my lord, there are chances of my lord encroachment of the land, my lord. That is the urgent.
Who are you?
But I am the successful purchaser, my lord.
Ah.
I have paid more than 4 crores.
Ah.
And my lord, SEBI has written several letters to the state government
Ah.
that you hand over the possession. My lord, the state government is not doing anything, my lord. My lord, there is a high chance that the land will be grabbed by the
How
encroachers.
you have purchased?
No, no, e-auction, my lord. I am the successful tenderer. Successful bidder, my lord. I have paid entire money.
So what is the urgency?
No, urgency is, my lord, the land is being grabbed by the encroachers, my lord, and the state government is not taking any steps. SEBI has written several letters that to the DM that you will take immediate steps so that the land can be handed over, my lord. So item number 314, my lord, any day, my lord.
Item number?
314, my lord, of today's list, my lord. Any day, my lord, before the vacation.
Not before vacation, it is not possible.
My lord, may I be permitted to mention one matter, my lord? Lordship was pleased to pass an interim order which will expire on 19, my lord. The matter is appearing in the list 253. It may not be taken.
Give tomorrow to be mentioned for extension of.
Only for inclusion, my lord, may I? Only for inclusion. Lord, can you hand over the seats to the inclusion?
Extension of interim order, give the list to my court officer.
Lord, inclusion.
Extension. Inclusion says new motion, may we hand over the
Extension of interim.
New motion, my lord, new motion.
This is extreme urgent, your lordship. Granted leave for other matters. Monday is fixed. Dada, please. Your lordship fixed 2 matters on Monday. EWS category registration. My lord, I will be seeking the list. My lord, leave to move on Monday.
What is the matter fixed on Monday?
Monday for EWS category registration, application made, my lord, by 30th. If this registration is not done, my credential, my lord, my eligibility will go. I have been selected.
So when you applied for the EWS category,
in the month of May.
when you applied for the certificate, when you applied for the post for the admission,
May 24, it has been, my lord, published last week that I have been selected. But instead of providing this certificate, I will be debarred. My lord, for that, your lordship.
That's why EWS certificate when you applied for.
In the month of May.
So why you have not come before that? Why you
Because,
come
my
in the
lord,
last?
my lord, because after being successful, my lord, this is, my lord, extreme urgent. Monday, your lordship has fixed 2 matters.
Monday. Leave is granted to open the affidavit and be listed on Monday as urgent motion.
Lordship. Keep them.
For what? For what?
Because of the urgency, otherwise I will be suffered.
What is the urgency?
They are illegally awarded the contract going to be finalized. But I will
It is already in the list. Then,
Tomorrow,
yes,
mention under to be mentioned.
no, to be mentioned, I will not.
May I
take.
have my lord's time? New motion inclusion.
Listed on 12, my lord.
Huh?
New motion for inclusion, my lord. It has not been listed. My lord, new motion.
New motion for inclusion.
If it is list, new motion, it will included also. I don't think before vacation it will be taken up for hearing. Why you persons are so wasting the time of the court for the last 10 minutes? If any urgency is there, please mention if urgency. If the court satisfied there is an urgency, only it will be taken.
May I have inclusion under this new motion?
Come after vacation. Yes, call the list. Yes, come after vacation. That's why I'm telling you, come after vacation. Even pre-opening day you come, I will take him. Sure.
May I permit electricity correction, my lord? Upgradation, my lord.
From the and I don't think it's
What? Correct.
Those members who again trying to take it back to the industry double check your lordship. I will just to my health and
So what you have prayed for?
on 21st of this month, there the president has been given unofficial members are conducting an incident where they will just issue the check and will pay the contractor from the common fund, your lordship. And this is against the bylaws. I have prayed for the appointment of the competent officials consider a direction.
21st, before 21st, I don't think.
Lordship,
May I will.
Lordship, may I be permitted to,
21 तारीख को रखा ये
Lordship, may,
19th को रखो देखो.
Lordship, may I be
have your
permitted to
lordship
seek leave?
19 is Friday.
Lordship, may I be permitted to seek leave before your lordship and move this matter urgently, my lord?
What is
The-
urgency?
The urgency is that, my lord, the petitioner has been granted a conviction which has been completed, my lord, by the first week of November. Till date, my lord, he has not been released from
For
the
what section? Under which section?
Foreigners Act, my lord. For
Foreigners Act.
yes, my lord.
So there are so many matters. It is because there is where the foreigner will go after release.
My lord, he will.
You have made out any search because whether there is any provision made out by the state government for
My
putting
lord,
the-
he is not been released from.
Correct. That's why you made the research after the release of the foreigners from the correctional home where he will put. Is there in provision in the state government?
My lord,
Tell me. Have you gone through the new act? As per the new act, the state government has to make a provision for the putting the foreigners in the government accommodation and the restriction of their movement. But whether the state government has made any notification and made any provision, without that the court cannot.
May I have
Research on that and come. I will.
May I have your lordship leave?
What has happened, the court authority, state officer has evicted me without natural due process of law or even citing me. They have cited an old lessee in this matter, whereas I am in possession of the property for the last 35 years.
Whether notice on the public premises is issued.
Lordship, not on me, not on me. Absolutely an order which was passed behind my back. I have challenged that, right, Lord. And not only that, Lordship, this is a commercial property on which I am carrying on business. And my doors are locked, my entire raw materials are inside it, and some of them are also.
When it was done?
Lordship,
When you have been evicted or the notice was eviction was issued?
October.
Then?
October thereafter I have come.
Hmm.
Because I sent them a notice initially.
Hmm.
I for demand of justice, and after a lapse of 10 days, I have filed my writ petition.
Hmm.
Lordship, it has already been filed.
Hmm.
Lordship, it has not come up in the list. Lordship.
Your lordship's leave.
Your lordship, I crave leave. Your lordship, I crave
Have
leave.
your
to file
lordship
this before your lordship on an urgent basis, your lordship.
What's the urgency?
The urgency is that the petitioner and his wife
is going to adopt the baby through IVF, your lordship, but the requirement is that the maximum age limit for the husband is 55 years and the age limit for the wife is 51 years. But your lordship, the age limit of the husband has crossed by 9 months, your lordship. However, it is stated in the High Court's judgment, your lordship, that only the wife's age is relevant, your lordship. That is why of the urgency.
Which court has held that the only age of the wife is irrelevant? Which court has held? 21G said so. 21G says so. Only the
Sure
wife.
about the case, your lordship.
And you know the State Union of India has prepared an appeal against the order passed by the coordinate bench of this court. Have you knowledge? Then come on 17C, 17 other matters are there.
May I have your lordship leave to file? May I have your lordship leave to file?
See, you all persons are wasting the time of the other, this court also and the other advocates also. I am not taking any matter as urgent basis. You mention I will sit till up to 2. I am taking all mentioning matter. You have wasting the time of this court and wasting the time of the other advocates whose matters are listed today.
Your lordship may
May I
kindly
have-
I
permit me
don't
to
think if you mention, I will take also. The court is not in a position to take the matters before vacation. Within 7 days, how many matters can be taken? Already 20 matters. Every day is fixed for the urgent motion.
Your lordship may kindly
Come
permit
after
me to
vacation, I
mention
will
a
see.
matter.
Well, may I have your lordship?
Come after
Your
vacation.
lordship may
because
kindly
come
permit me
after
to mention a matter. Your lordship for non.
Your lordship.
I will adjust all of you.
Well, may I have your lordship leave to file a review without certified copy, my lord?
Please come after vacation. I will adjust you because there will be a
You-
time. Then I will adjust all of you.
Your lordship
Lord,
may
may I
kindly
have your
permit me
lordship
to
leave to
mention a
file a
matter.
matter
Your
without-
lordship, I am for the petitioner, my lords. This matter is listed in the today's list as 512, my lords. This is for non-prosecution, your lordship.
Tomorrow record for application.
Well, may I have your lordship leave to file a matter without certified copy?
Yes. Not getting pension. Since when? Since when he retired? 60? 69 he retired. And now we are on 2025. There is an urgency. After 40 years, correct. I am not telling you are not entitled, but where is the urgency? You wait for the so many years. Please wait for a month. Wait for 20 days. Come after vacation. Only due motion में कर दो.
May I have your lordship leave to file?
Sir, the very urgent, my lord, without electricity, my lord, let it be in the upgradation list, my lord, we are suffering.
Come after vacation.
Electricity.
May I leave, may I? May I leave your permission, my lord?
Well, may I have your lordship?
For the last 4 years, I have performed a contract with the railways admitted people of India. Railway comes up with a statement that I don't have. From the paucity of funds, I cannot give it to people. So I'm only paying for income. Let it be taken up as per your lordship.
New motion.
May I leave your permission on mentioning on matter, my lord? Item number 406 is come up as a listed motion. It's a playground. Playground created a serious breach of peace. Only have added your lordship any date.
New motion.
May I have your lordship?
Lordship,
May I have your lordship?
on the last occasion, I have also mentioned lordship, one electricity matter, lordship, for urgent motion, only one lordship. Without electricity.
May I have your
that
lordship
start
leave
is
to
big.
file
20 days.
this review application?
Matter, lordship, I am-
My lord, may I have your lordship leave to file this review application without certified copy because I am a candidate who have applied under EWS category.
Non-prosecution. Yes.
My lord, I have applied under EWS.
Which order?
My lord, your lordship's order on 10th December, my lord, your lordship did not allow to pass, my lord, EWS certificate to give the SDM the order to give this EWS certificate. My lord, I have been called for verification, my lord. My lord, state respondent submitted that verification already initiated. My lord, in case of 9-10 category, no verification process has been initiated yet. My lord, I lordship leave, my lord, kindly give, my lord, to file a review application without certified copy. My lord, just yesterday we have received the server copy of the order, my lord. My lord, I intend to file a review application of that, my lord.
Or kindly allow me to file this
What's
without
urgency?
Well, urgency is they will initiate the verification process is this week, my lord, because Supreme Court had specifically directed.
Krishna is allowed to file review application without the certified copy of the order, liberty to file the same at the time of hearing.
Lordship, may I kindly to mention as an urgent motion, I have filed a writ petition 2 weeks before. Lordship, it is not appearing. The urgency is that I am a successful tenderer. My tender has been cancelled and I have supplied the goods worth ₹4 crore. I am not being able to pay my employees and everyone. Lordship, kindly
What is the prayer?
So for cancellation of the termination notice and for disbursement.
Come after vacation. Come after.
Lordship, kindly considers, Lordship.
Yes, yes, call the list.
Lordship,
Call the list.
Item number 360. My lord, extreme urgent matter, my lord, item.
No urgency is there. Come after vacation, I will take them. Yes.
My lord, only problem is.
Lordship, I'm mentioning for non-prosecution, Lordship.
Non-prosecution, give the. Yes.
My lord, may I mention a matter?
I have to mention one item, my lord, 366. My lord, the petitioner paid for the correction of the date of birth on the Aadhaar card. Aadhaar Seva Kendra has been repeatedly requested. They have not, my lord, done the correction. So, my lord, I am not getting the KYC or the gas other facilities.
Come after vacation, I will hear.
My lord,
My lord, may I mention a matter?
What is your application?
Item number 320 of the.
Ah.
Today's lordship, the petitioner's lordship referred the RTI application lordship. Thereafter, using the information, and there the matter was stated by Honorable Justice Amita Sinha lordship, directing them to file the affidavit. Lordship. They didn't file any affidavit. Lordship, kindly take.
Okay, you do one thing. You inform the other side, and I will take up. Okay, come after vacation.
135 of today's list.
5th, I will take the matter.
My lord, item number 135 of today's list. Only problem is this is a writ petition filed by the wife for the cancellation of the passport of the husband. I am for the husband, and due to this writ petition, his passport is not renewed. He is a seller, and he cannot join his duties. Kindly,
Where is working?
Sorry,
where is working?
He is working in a shipping company, and due to his passport, since his passport is not renewed, he cannot join. He is paying
When he has sign off. He has sign off from the ship.
A long time back.
Then sign
my
off
lord.
is only for the 3 months. We long time back. How you can go?
My lord,
It is item number 135. Any date, my lord. Kindly.
Vacation come.
My lord, may I mention a matter for urgent determination?
What?
The highway authority will remove my encroachment on 23rd, 12/25.
When the notice was issued?
4th of December.
4th of December. When is the date of eviction? What is the date of the eviction? No. Yes, call the list. Nothing. Come after vacation, madam. I will see. Yes, call the list.
I'm for the respondent.
My lord, I'm for the petitioner. I'm for the petitioner, my lord.
I'm from the Union of India, my lord.
The respondents are directed to consider the representation of the petition for initiation of revival and rehabilitation process with respect of the loan accounts of the petition in accordance with the Reserve Bank of India framework for revival or rehabilitation of MSMEs notification dated 17 March 2016 and to make an appropriate take appropriate decision in accordance with law. Till the final decision is taken, all the notices and all these things has been kept in abeyance.
Deeply obliged. Deeply obliged. Deeply obliged.
Yes, next.
Appearing for extension of interim order, you know. This was last. Okay. Achha. I think Mr. Banerjee is appearing virtually.
Yes, for the last extended on 25th August.
Which for the other side? I am for
No,
the
we want an extension of the interim order. Milord can bring.
I think there is a issue.
It's been
Mr.
extended.
Banerjee, your network seems to be a little feeble. It's not very audible.
I'm sorry, then will you just... I'm so sorry, Milord. This is, Milord, our application for extension of the interim order, which has been subsisting from time to time, which has been extended from time to time.
Yes. Yes, what is the submission?
Yes, my lord.
The matter is listed as to be mentioned for extension of interim order. In view of the submission made by the parties, the interim order is extended till 23rd of January 2026 or until further order, whichever is earlier.
Every month also.
But have they filed affidavit?
But with Mr. Banerjee's leave, if I may pray for one thing, they haven't filed affidavit for eons. So instead of January, if we could, otherwise every month we have to come back and trouble your lordship.
You have not filed affidavit?
No, not
Filed the
yet, my lord.
affidavit.
Kindly extend the time for. Kindly keeps it till March and let them do all of that in the meantime, Lord.
Not March.
So February.
Till 6th of February 2026 or until further order, whichever is earlier. In the meantime, the parties are directed to exchange their affidavits. Please the matter on 6th of February 2025.
Grateful, my lord.
Great.
It's item number 2. Next.
My lord, I am led by Mr. Anand Banerjee, my lord, due to unavoidable circumstances, my lord, is not available. My lord, however, the interim order is about to expire on the 19th of December.
Which was the respondent?
I'm particular added respondent.
Yes.
The issue is not with regard to whether a property which is outside the the project area can be included without amalgamation. There's a report filed by the states will suggest that yes, amalgamation is necessary. Now the interim order is that till this amalgamation is being not done, the formation of the association will not be done. That is the interim order.
So amalgamation is done.
The
Affidavits filed.
Yes, ma'am.
The matter is listed as affidavits filed. Affidavit is there.
Yes, ma'am.
Report, exception to the report, everything is not.
The matter is listed as to be mentioned for extension of the interim order. It is submitted that the state authorities have filed the report and the petitioner have filed the exception to the same report. In view of the above, let the matter appear on 27th of January 2026 under the heading adjourn motion. The interim order extended till 27th of January 2026 or until further order, whichever is earlier. Next.
Bearing in mind, since if your lordship kindly has a look at the last order, we had mentioned this because of what is here. Well, the dated 2nd of September 2025. Well, the report was directed to be filed. I'll tell you, lordship, what just a brief conspectus in 15 seconds. There is a suo motu extension of my contract after the respondent issues a letter to me saying that for force majeure reasons, the contract stands discharged. Then they extend it by themselves and then they terminate it. That termination I put under challenge here. Court directed them to file a report. That report came. In that report, they actually annexed a tender from which it shows that the contract stood discharged because of force majeure reasons, because of the flood and the entire road that I was making was inundated. Court directed them to file an affidavit. Because there was a termination, divorce, the entire thing. Court said, are you going to take any steps? They said, no, as of now, we are not taking any steps. So the order, if your lordship sees, at paragraph 4, the order of 2nd of September 2024, be it recorded that the learned counsel for the state has submitted before the court that as on date, no decision has been taken to take any coercive steps against the petitioner, relying on the order of termination. And before that, there were directions for filing affidavits. As usual, my lord, no affidavit has come. My only apprehension is that this was there, which is why the court did not pass the injunction. My learned friend will make a similar statement that taking advantage of their default in not filing, they will not go ahead and issue or do something coercive against me.
My lord, in this matter, I am led by Additional Advocate General, my lord. My lord, my affidavit is ready. I can file by tomorrow, my lord. By tomorrow, I can file it. It's ready, my lord.
Then he has to file the reply. So what about the interim order?
My lord, we are not taking any steps. As of now, we have not taken, my lord.
I have one more request, my lord. If your lordship looks at one particular page number, admitted
Moreover, my lord, this we will take the point of maintainability of the writ petition at the time of hearing itself, my lord. Today, your lordship is not hearing or entering into the merit of the writ petition. So you're not taking that point, my lord. We have that point also, my lord.
I'll just show one particular document, my lord. Kindly wait. Please have a look at page 87 of the writ petition once. My lord, if the respondent is fair, then to this prayer, they really should not have a problem. Page 87, please have a look at. This is their document.
Perhaps your lordship is not entering into the merit. So
No, I'm not arguing on merits at all. I'm not arguing on one thing.
See, I am only, he will file the affidavit, you file the
by
reply.
tomorrow itself,
No, that's all.
It's
Because
ready, my
there
lord.
is an admitted amount which they are supposed to pay to me. If that could be discussed.
The matrix listed has to be mentioned for extension of the interim order. Then at counsel for the respondent submitted, we will file the affidavit in opposition by tomorrow. Counsel for the place for time to file the affidavit. That affidavit in opposition is filed by 19th of December 2025. Reply, if any, is filed by 14th of January 2026. Please the matter on 21st of January 2026. The interim order is extended till 21st of January. No, not a full. It is a full. That the Learned Counsel for the respondent submit that the respondents have not taken any decision to take any coercive steps against the petitioner. This court open trust till the next date of hearing. The respondents will not take any coercive steps against them.
Well, there was no specific interim order. That was
very good.
Well, and we have, well, prepared. There are some typographical errors, so we have not filed it.
That's why extended till 19. You filed
Yes, I have it.
Great.
It's not there, but we on usual course we have not done this.
Yes, next.
My lord, I beg to appear on the petitioner, my lord. My lord, my application was dismissed for default on 25/6/2025. Since I could not be present before the honorable court when the matter was called on, as the learned advocate was present before arguing another matter. So therefore, my lord, I pray before lordship, which has been explained at para 4. Lordship, kindly.
What is the writ petition?
Yes, my lord. Writ petition is, my lord, I am the owner of the property in concern, and the Directorate of Employment is my tenant. My lord, they have taken up a policy which is at page. Lordship kindly comes to page 65, wherein they have taken the policy decision that they will vacate the private property wherein they are tenant. In spite of taking this decision on 17th of February 2022, they have not vacated the premises in question. And Lordship, they have asked for a cooperation from the block development officer. Till that, the block development officer has not extended that cooperation, for which I understand they are not able to vacate the premises. If your Lordship kindly directs them to act in terms of their own order.
Where is the order? Where is which?
Lordship kindly comes to page 65 and page 66. Page 65, Lordship, middle portion. In view of this, the Authority of Labour Department instructed to initiate drives to relocate the offices which are housed at private premises to government premises. In this context, you are requested to explore availability of suitable government premises where your offices may be shifted. Help of local administration like district magistrate, SDO or local bodies may be obtained in this regard. A report should be communicated to this end within 1 month, informing the outcome of your effort. Secondly, the offices of district in charge and employment exchange located in district headquarters should be preferably accommodated in same and single premises. These arrangements may be cost effective and also help to utilize the manpower and other resources. Hence, districts in charge whose offices are housed in private premises or not accommodated in employment exchange premises are requested to explore the possibility to shift their offices to the premises of employment exchange located at district headquarters. Now, Lordship kindly comes to the next page at page 66, wherein the concerned tenant, that is the district employment exchange, has written to the block development officer pursuant to the same memo, wherein asking for cooperation. Lordship kindly sees the memo dated 29/6/22, which is at page 66.
Yes.
The body is, I would like to inform you that Director of Employment West Bengal have been passed an order to change this office accommodation shifted from private building to government building. Copy of this order has been attached here, and I am humbly requesting you to help to comply this order. In spite of this communication, there is no help, no steps by the respondent authorities to shift their tenancy from my property to the government premises. And on one hand, my lord, they are not paying any rent. On the other hand, they have occupied my property in concern.
Yes. Which, yes.
My lord, this is a policy decision, so we are expeditiously trying to imply this decision, my lord. But however, this order, but we will try to imply with this order. But there is a civil suit pending regarding rent dispute is there, my lord. If any order is passed today, that should not affect that civil suit. That should civil should go independently, and their claims are as per their instructions. Our own policy decision, we will expeditiously try to. We are in process.
This
We
is
will try to.
this is the policy decision. They will vacate. You have already filed a civil suit. You go and get the.
They have already there
What the court will do?
Also kindly appreciate on one hand.
It cannot pass an order of eviction.
Or they have themselves admitted that they will be.
Correct. You take the benefit in the civil suit. What the writ court will do?
That, my lord, I appreciate, my lord. I will
Yes.
do that, my lord.
I am dismissing this with the liberty to take all the points before the civil court.
Lordship, only one thing, Lordship, very humbly submitting. Let them act in terms of their own policy decision.
You already, when you file this civil suit.
I have filed the suit. I have mentioned about the suit and I have disclosed everything in this writ petition.
Correct. No. When you file the suit.
Yes. Lordship, I have filed the suit in the year. I have purchased the property in 2009 and I filed the suit in the year. Lordship, kindly comes to paragraph 5 in 2016.
21. You filed the suit.
2016.
Yes.
Paragraph 5. On one hand, Lordship, they have taken a policy decision that they will be vacating.
Correct.
On one hand, they are not vacating it.
Sir,
and on the other hand, they are not.
correct. I am totally agree with you. You take all this benefit in the civil suit. What the writ court will do?
The civil suit takes years to come to a conclusion.
You take a step before the civil suit.
What I am suggesting, my lord, we will comply as expeditiously as possible. And if by this order they should not take the rents or mains profit from the civil suit, let them give them liberty. After we shift back, they will withdraw their civil suit.
So you mean to say you are ready to vacate?
We will, because it is a policy decision, we will try to do it as expeditiously possible. But if there is any technicalities or some problems, we cannot stipulate a particular time that within this time we will be able. We are trying to imply our own policy decisions.
Who put you in the penal advocate? Who had put you in the penal advocate? You know what you are making a submission. Strange. How the panel has been prepared by the state. This is the way to represent the state. Have you instruction to make such submission? The petitioner has filed the present application being CAN number 1 of 2025, praying for recalling of the order dated 25th of June 2025, wherein this court has dismissed the writ petition on the ground of non-appearance of the petitioner on call. Counsel for the petitioner submitted the writ petition was dismissed for default on 25th of June 2025, and immediately the petitioner has filed the present application on 11th of July 2025 for restoration. He further submitted that the matter was, when the matter was called, common learner advocate on record could not present before this court as he was engaged in other court. And when the advocate reached to the court, by that time the court already passed an order for dismissal. Consider the submission made by the counsel for the petition. This court find that the petition has shown sufficient cause for non-appearance before the court when the matter is called. Accordingly, order dated 25th of June 2025 is recalled. WPA 14319 of 2024 is restored in its original position, in its original file. Full stop. CAN number 2020 disposed of. The writ petition is taken up for hearing with the consent of both the parties. This court find that the petitioner has filed the present writ application with the prayer upon the respondents to comply with the letter issued by the Director of Employment, West Bengal, dated 17 February 2022, and the Employment Officer, and the letter dated 29th of June 2022, issued by the Employment Officer to the Block Development Officer. The Employment Office,
Yes,
the
my
Labor Department,
Labor Department, Employment Office.
the Labor Department, the Directorate of Employment from a Government of West Bengal is running their office in the premises of the petitioner. And the Directorate of Employment West Bengal has taken a decision for shifting of the office to the government accommodation. Accordingly, the same was forwarded to the Employment Officer. The Employment Officer has forwarded a set to the Block Development Officer requesting for making necessary arrangement for shifting of the office of the Directorate of Employment of West Bengal to government accommodation, but till date the office has not been shifted. Learned advocate appearing for the state submits that the petitioner has already initiated a civil suit against the respondents, and the civil suit is pending for adjudication. He submits that if any order is passed in the present date application, the same will affect the civil suit. This court finds that the petitioner also disclosed in the writ petition with regard to the pendency of the suit filed by the petitioner against the employment officer in charge. Considering the above, this court finds that the authorities have already taken an administrative decision for shifting of the office of the Directorate of Employment, Government of West Bengal, from the private premises to the government premises, but that has not been implemented till date. Accordingly, the authority is directed to file a report on 8th of January 2026 with regard to what steps has been taken by the authority with regard in terms of the memorandum number 4A-MISC/2018/661-749 capital A, dated 17th February 2022, issued by the OSD and EO, Directorate of Employment, West Bengal, and the communication made by the Employment Officer to the Block Development Officer, dated 29 June 2022. Let the report be filed. क्या बोला डेट दिया ऊपर डेट दिया let the report be filed on 8 January 2026 after serving the copy to the London Council for the petitioner. This is the matter on 8 January under the heading urgent motion.
My lord has been kind enough to direct the respondent to file a report, my lord. My lord, may it be the report in the form of an affidavit, my lord.
Let come the report. We'll see to that. इसको भेज दो ऑफिस में भेज दो.
Grateful to your lord.
Lordship, I am appearing on behalf of the writ petition.
Lord, I am for the WBSCTCL pursuant to your lordship's direction, my lord. The earlier station manager at the relevant point of time who was there and the present, both of them are present. Now, my lord.
Yes.
Yes, my lord. Before my lord going into the my lord file, your lordships kindly. My lord, before going into the file, your lordships kindly, my lord. My lord, kindly.
Yes.
My lord, before going into the file, your lordships kindly consider, my lord. The husband of the private respondent was the tenant. That is there in the writ petition. This is an admitted position. Now, after the death of the husband, the private respondents applied for electricity connection. My lord, they are not inclined to continue their tenancy. That is their problem. I am not appearing on behalf of the private respondents. Let them take steps. Now, my lord, your lordships kindly direct me to produce the records on what basis we have given connection. Now, your lordship kindly say.
In whose name the connection was there earlier?
Lordship, the
private respondents.
Earlier,
Suniti Maji.
Earlier, the disconnection was made in the name of the late Pushparani Chakraborty,
in which the original meter connection was there.
In which?
In whose name?
In whose name? Pushparani Chakraborty.
Pusparani Chakraborty.
Petitioner number 1 is the son-in-law of late Pushparani Chakraborty, and petitioner number 2 and 3 are the grandsons of late Pushparani Chakraborty.
Correct. So you are enjoying that electricity connection of the Pusparani Chakraborty, which was provided in the name of Pusparani Chakraborty.
Yes, Lordship, that occupants were enjoying the electricity connection of late Pushparani Chakraborty.
Now my question is that the Pusparani Chakraborty died. The meter was still was in the name of the Pusparani.
Was in the name of the.
Who was enjoying the electricity connection, which was
Private respondents.
Private respondents.
Private respondents.
What the private respondents?
4, 5, and 6.
They were enjoying. So
They were.
Devasis and Urmila.
Yes, Lord.
Who are you?
I am the owner.
You are the owner of the property.
Yes, Lordship.
So how this Sunita Maji was how this original owner lady was there in that? See, who is she?
Lordship, the husband of the private respondent number 4 was the tenant of petitioner number 1 in the year 2008 for 2 years. After that, the tenancy expired and they forcibly occupying this portion of the premises in dispute, and the civil suit is possibly running between them. But the crux of this writ petition is by letter dated 22nd of May 2025. I have the translated copy, Lordship. Private respondent number 4 concealed her own identity and misrepresented herself as the predeceased daughter of late Pushparani Chakraborty.
Correct.
Lordship, kindly come to page number 35, annexure P4. Who was the predeceased daughter of late? Page 35.
35
of the writ petition. Kuhili Haldar was the predeceased daughter of late Pushparani Chakraborty.
Yes.
Page P35. Sorry, annexure P4, page 35. This is the death certificate of the predeceased daughter of late Pushparani Chakraborty.
What is her name? Kuldi Haldar.
Kuhili Haldar.
She is the daughter of
late Pushparani Chakraborty, predeceased daughter.
Predeceased daughter of Pusparani.
Yes, Lordship. And the death certificate of Pushparani Chakraborty is.
Yes, page 34.
Yes, Lordship.
Kuldi Haldar.
Page 35.
Mother of the deceased not available. Kindly come to the page 35. Mother of the deceased not available.
Yes, Lordship. Yes.
So how you can say this?
Lordship, kindly come to the gift deed and the sale deed. Here it is.
Okay. Then what has happened? Kuldi Haldar is only the daughter of this.
Of the Pushparani Chakraborty.
She is the only daughter.
She was the only daughter.
Okay.
Predeceased daughter.
Correct. She died.
She died. And the private respondent number 4 appeared before the electricity department.
First, you clear the pictures.
Okay, sir.
This Pusparani Haldar was only one daughter. She was the predeceased to Pusparani. So
Absolutely,
she died without any legal heir.
She died leaving petitioner number 2 and 3.
Who is the petitioner number 2?
Petitioner number 2, Amit Haldar, is the son of grandson of Pushparani Chakraborty. Grandson, petitioner number 2 and 3 are the grandsons of Pushparani Chakraborty. And son of petitioner number 1 and late Kuhili Haldar.
Grandson means Kuhili Haldar's sons and daughters.
Absolutely. Petitioner number 2 and 3.
Petitioner number 2 and 3 are the sons and daughters of the
sons of
the deceased daughter.
Of the predeceased daughter of Pushparani Chakraborty. That is late Kuhili Haldar.
Correct.
Absolutely. Yes. And after that, this is the whole background of this role. And Lordship, kindly come to the response which they have made, page number 60, annexure P13.
Yes.
This will clear all the shadow of doubt. Page number 60.
Correct.
Lordship, kindly come to the second paragraph.
Yes.
This is the main picture, Lordship.
Yes.
Yes.
My lord, since we have received, and actually, my lord, what has happened, the petitioners were not residing over the premises. The private respondents was residing over the premises. Now, my lord, at the intimation of the private respondent that the Pushparani is my mother, and since your lordship knows, my lord, we cannot continue the connection in the name of a dead man. My lord, we have disconnected. If your lordship so desire, we can reconnect, no difficulties. Now, my lord, question is page 60. Immediately after having intimation from the petitioners, we have issued this letter to the private respondents. So it is our bona fideness. We have not done anything wrong. Immediately we have given an intimation. They kindly tell us what has happened. Now, in the meantime, my lord, the main petition is your lordships has directed us on what basis we have effect connection to the private respondents. Now, your lordships kindly see the file. Well, so far disconnection is concerned, if my learned friends is agreeable to take connection, we have no difficulties. That's the different aspect. We will give connection even also.
Lordship, on last occasion, Lordship directed the
see
station
file.
manager to appear
Yes,
in
yes.
person.
Yes, both station manager is here, my lord. My lord, kindly see the my lord, page 1, 2, 3, 4 is the application. 5, well, it's a pencil pagination since it's original documents. First, my lord, the applications. Along with applications, he has, my lord, submitted the documents of Aadhaar card. Then, my lord, the PAN card. Then, my lord, the voter card. Then, my lord, the gas connection documents. Have your lordship got it?
Yes.
Then, my lord, the passbook, xerox of the passbook from the same address. All the documents are, my lord, within the same address. Now, my lord, thereafter he has filed a case 107 CRPC.
Yes. What is the prayer now?
That documents.
Lordship, my prayer is based upon the premise that under what entitlement the West Bengal Electricity Authority disconnected my meter, as well as based on that fabricated application by the private respondent number 4, they have initiated a new connection to the private respondent number 4, and it is apparently visible that there was a collusion between the station manager and the private respondent number 4. My simple prayer is that permanent disconnection of that particular electricity meter, which was initiated by the electricity department to the private respondent number 4.
Who has applied for disconnection of the old meter?
Private respondent number 4.
Please, who has applied for disconnection of the meter connection of the Pushparani?
My lord, the private respondent says, I am the daughter.
Where is that letter?
My lord, he has submitted that letter. Your lordship knows.
Are you not placed in this record?
No. That is there in the writ petition also.
Yes. Where is that?
My lord, that was within the, my lord.
Where is that?
Page. What was the page number? 50. Second. Hey, the very legible.
That's why I want that. Then you
Yes,
not brought that document.
No, my lord,
in your
on.
file.
No, my lord. Actually, what has happened, my lord?
Not brought on
The document.
Registration engineer.
My lord, your lordships, kindly. My lord, actually, what has happened?
I called the original file.
My lord, actually, my lord.
Not actually nothing.
Well,
Why I on the last occasion
Yes,
I
yes,
also
yes.
want that.
My lord,
on
we
that
have no
application.
intention to flout at your lordships. Anything, my lord.
I will pass.
My lord, file.
Where is the police station? Let the
My lord,
468 case be initiated against the
my lord,
station
kindly,
engineer.
your lordships. My lord, file was not available at the relevant point of time. What has
Because you
happened?
are in connivance with the private
No. Because, my lord, everything was computerized nowadays. Your lordship knows. That's why, my lord, the physical file goes.
Where is the engineer?
Well, subsequently.
Call. Where is the engineer?
Well,
Where is the engineer?
My lord, page 56.
I am,
Yes, yes.
you are the engineer. Where is the file when the private respondent applied for disconnection of the old meter of the Pusparani? Where is that file?
Well, that is page 56 of the writ petition.
I want from you.
Yes. Kagoj.
How many years you are having the service?
কতদিন চাকরি করছেন বলুন আপনি কত বছর চাকরি
And why you not produced the document on the basis of which the line was disconnected? Why you have not produced the document on the basis of which the old meter has been disconnected? Why you have not produced?
জজ সাহেব কি বলছেন উত্তর দিন আরে আপনি জজ সাহেবের কথা উত্তর দিন
Let he go to.
My lord,
Let he go to the correctional from here directly in violation of the order.
oh, my lord, your lordship kindly.
What lordship?
We-
This is the
my
third
lord,
time.
my
In
lord,
the last occasion, you
my lord,
have made a blunder before this
my
court,
lord,
not
because
producing this. Now I pass
my lord,
an
that
order
was
for
not
parents. Now you have not
that
produced
was
the document
my
with
lord,
the private
my lord,
respondent.
that's why I'm praying apology because that was not available at the file because
Why it is not available?
my lord, your
When
lord,
it was disconnected.
your
Show,
lordship.
show me when it was disconnected.
Yes. ওই কাগজটা
2024.
Yes. 2024.
24.
Yes, my lord. On 22nd May 24.
Within 1 year, the document has been misplaced.
No, my lord. Actually, nowadays everything was scanned and computerized. That's why, my lord,
So
file.
that will be in the online application.
Yes, yes.
So
that-
where is that?
Well, that was I produced before the lordship on last occasion. That was illegible. That's
You have brought this one, not the application. That's why I wanted to see who has filed an application and what documents he has filed, stating that she is the legal heirs of the Puspa Rani.
yes, yes. That's it. But my lord,
Only if the court want to see.
my lord, your lordship, my lord, kindly. I beg a pardon,
You are a very
lordship.
correspondent.
Yes.
What document
My
you
lord.
placed before the authority for disconnection of the electric connection?
My lord, the document they are relying upon.
Asking only
Not-
one question. I don't want any lecture.
This
You
is-
show me what document you have produced before the authority for disconnection of the meter connection of Puspa Rani, showing that you are the daughter.
My
Show me that only. Or
Private
nothing else.
respondent number 4 did not make this application. This did not make this application. my lord.
Page 60.
Yes, my lord, I have. That is their contention, but the
Ah.
thing is, my lord, the application, my
Authority is telling that which application? What
I'll
application?
kindly look into the signature and everything. Totally visibly distinguishable, my lord. What is there in this application? Kindly look into this application. This is a
What
PAN
is
card
that?
signature. PAN card signature of this.
I don't want. Yeah, have you have you filed an application for disconnection?
No, my lord, no.
Yes.
Now, my lord, my lord and friend saying, my lord, I have nothing to say.
That's why I want.
Yes,
the
yes.
document. Otherwise,
Yes.
your engineer
My
will
lord,
be in
your
trouble.
lordship, my lord, only 56. But this document.
Otherwise, your engineer will be in trouble.
Yes, yes. My lord, that I have understood.
Now, they have taken the stand. They have not applied.
Yes,
For. What the connivance
Yes.
is there?
Now, my lord and friend says, my lord, they have not filed any application. But page 56 is the application. They have submitted.
The signature clearly means that.
That I will see. But first, you will be taken into custody. Your signature will be taken.
Lordship,
by the
this
police
signature is in
authority.
vernacular
Your
language.
signature will be
This
taken.
signature is in vernacular language.
Yes.
This is also in vernacular.
Your signature will be let you be taken into custody. You give the specimen signature to the investigating officer. Let it go to the forensics handwriting expert. Let it come. Then the court will decide.
Distinguishable, my lord. The signature. Both are in.
That's why let the police investigate the matter.
Page 56 is the application.
You immediately made a complaint to the police authority.
My
I want that.
My lord, my lord.
When you file the report.
As your lordship, my lord.
When you file the document here. First, I want the document. When you file the document.
My lord,
Yes.
This.
When she has applied for.
Well, this is at page 56.
I want from you.
My lord, this document is here, my lord. On 22nd May. 22nd May.
Where from you got the Xerox? If you are not having the original.
My
Where from you got the Xerox which when you are not having the original document? Who is that person? Who is keeping all record? Who is that person?
Well, he's the
Who is that person behind you?
But he's also a station manager. Now he is taking charge.
So how you got the Xerox copy? You are not having the original.
Sir, I have the original.
Original?
Yes, sir. Yes,
You are
sir.
having the original?
Yes, sir.
When you will produce?
Sir, as you said.
Tomorrow?
As of tomorrow. Yes, sir.
You are not taking the instruction from
My lord, I have taken instructions, my lord, so far, your lords.
telling just 2 minutes before telling the document is not available.
No, I am not saying.
Sir,
my lord.
I know how the
My lord,
matter is to be
my lord,
tackled.
maybe there may be some, I have never said, my lord,
know
there is no document.
Because-
The file was not available. That's why I'm submission.
So if file is not available means document is not available.
On that relevant
Document
point of
is
time.
with
My lord,
the
both of
officer.
the station manager is here. Your lordship can, my lord, justify my submission
Not
because
to,
they are not able to
not
supply
think
me
this,
the.
this court is full.
No,
Not
your lordship.
think the
No.
court is full.
My lord, your lordship, my lord, can
I will make
confirm, my lord.
such order. You
I am-
will be not in a position to
My
practice.
lord, your lordships kindly consider, my lord. I am here for last 30 years and dealing
Maybe,
electricity
but
matter.
last
I have never,
last two
I have
days
never-
observed
my-
what type of the practice you are doing.
your lordships kindly consider, my lord. I have never tried to, my lord, frustrate the courts and I have never interested. My lord,
Same thing.
your lordships direct me to
Please
produce the record.
Don't submit before this court on the sue of the client.
No. Absolutely not. Absolutely not. Your lordship, my lord, these original documents, your lordship wants, we can produce even
The station manager,
tomorrow, no difficulties.
WBSCDCL of Ganganagar Customer Care Center is present before this court. But he has only produced the file in connection with the application filed by Suniti Maji for grant of electric connection. But he failed to produce the original record in which Sunita Maji has filed an application for disconnection of the meter provided in the name of the Pushpa Rani Chakravarti and the proceeding initiated by the authority for disconnection of the meter of Pushpa Rani Chakravarti. The station manager pressed for a day's time for production of the said record. Let the record be produced on 16 December 2025. List the matter tomorrow at under the same.
16 today.
17.
17.
Not 17, 18. Sorry, then.
But 18th, I have some difficulties, your lordship. Either 16th or 9th.
Okay, 18. Sorry, then. Under the same heading.
My lord, 16th.
18. Today is the 16, 18.
18. My lord, 18th, I have some personal difficulties. Either 19th or your lordship.
19.
I am great.
Please make sure all the documents before the court.
My lord, my lord, officers are there. Whatever document is there, my lord, I have no intention to. I have no intention to, my lord. Anything, my lord, suppress before this court.
Yes, next.
Deeply grateful.
Lord, I am appearing for the writ petitioner. On the last occasion, your lordship was pleased to grant me, my lord, direct me, my lord, to serve a copy of your lordship's order directing the respondent numbers 2 and 4 to file a report. But this is my affidavit of service, my lord, I have served. Lord, this pertains to a leasehold land in Durgapur, which was, my lord, given possession to the writ petitioner pursuant to a possession notice. Well, the difficulty is we are not being able to set up a factory here without the relevant permissions and no objections. So on that
the report is filed.
But I have not received it. But may a copy be served, my lord?
My lord, my lord, I beg to represent the, my lord, respondent number 2. We have received the report, my lord, this intimation on 9th, my lord, December. So, my lord, it is not yet 10 days. So, my lord, it will be ready by today, my lord. May I pray for some judicial grace, my lord?
When you file?
By tomorrow, we can file, lordship.
Sure.
Yes, today it's ready, all officers said.
Then you received them, you served him. So I am fixing
Certainly,
the
lordship.
question.
But kindly keeps it next week, any day, your lordship. My lord.
Only 2 days.
Because, my lord, this pertains to a very public interest matter, my lord, the factory.
Public interest, then go to the division.
No, but not in that sense. Benefit of the public of West Bengal. It's a very unique. So that is a separate issue that they can ventilate elsewhere.
The Leonard
Because of their
Leonard Council appearing for the
Thank you. He is a necessary
It is
party.
good for you. We remain in the.
He's a necessary party, my lord.
Give the copy.
I've
Who
served.
has filed this? The
Report
respondent
filed by
of
R.
number 3 and 4 have filed the report. Have you received the copy?
Yes, my lord.
After serving the copy to the London Council for the petitioner, London Council for the estate prays for a day's time to file report.
Respondent 2, my lord.
Respondent number 2 prays for time
One
to
and
file a report.
Oh, 1 and 2, lordship. 1 and 2.
Respondent number 2, 1 and 2 prays for time to file report. Let the report be filed on 18th. Not sure. 18th. After serving the copy to the London Council for the petitioner, list the matter on 22nd under the same matter.
Not sure.
Excellent.
My lord, item number 11, I am for the petitioner.
Yes.
I think to appear for the state, my lord. My management start, my lord, may I raise a preliminary objection? Lord, the petitioner's prayer is that, my lord, for renewal of his clinical establishment license. My lord, in earlier round of litigation, direction was given upon the authorities to take a decision regarding his renewal. That was rejected in 2024. But that has not been challenged in this writ petition. Again, prayer has been made for renewal of the writ petition.
What is the prayer?
Kindly see, my lord, prayer, second volume, at page, my lord, 64. A number of prayers have been made, but your order has not been challenged.
Renew the clinical establishment license.
Yes.
So earlier it was rejected.
Rejected.
Not rejected, my lord. The direction was passed. Earlier writ petition was also for renewal of the C license and PCP entity license. My lord, my supplementary affidavit, the copy of which I have served already.
Yes.
And page,
Where is the earlier order?
earlier order is that, my lord, at page.
Where is the court order first?
Yes.
Direction of the
314, which is at volume 7. Page 314.
$314.
14.
Yes.
11th portion, 318. Last paragraph.
Disposed of direction respondent authorities to consider the petition prayer renewal of license of affording opportunity of hearing.
Yes.
Yes. Then
Now the order is at page 341. One of the last paragraph, paragraph 5, a recent order was passed by the Health Commissioner 2019. In the said recent order, the commissioner, which had been communicated to the petitioner, some objections were mentioned for rectification of by the proprietor of AIDC for issuance of C license, but the same was not complied or reported by the proprietor despite ample time being given to him. Hence, there is no scope for permission of renewal of the license. In view of the above points, as mentioned, after examination of the relevant government act and rules, the Manus Niyogi, the complainant and the proprietor of AIDC Bhadreshwar may apply afresh for permission to run genetic lab under WBCRR rules as per the requirement choice, and subsequently C license will be issued or rejected based on the report of inspecting authority, and thereafter license, if required, will be issued if C license is approved. So this is the order. He has to apply afresh. Inspection will be held. If it is there, all formalities have been completed, then my lord, fresh license will be issued. And this is the last order by the authority. Now, my lord, petitioner has again prayed for renewal of the CE license. So that has been decided already.
Yes, my lord.
you are applied for as per the page 3.
Yes, my lord.
Where is the application?
That is the crux of the entire writ petition. What my learned friend has raised, my lord, for proper understanding of the issue, let us go back to 1998. When
After this 342, have you applied for?
no, my lord,
Then
because
It was my prayer in the earlier writ petition was also same for renewal of the license.
Correct.
Because this license is depending on two other PPP projects, which is
You had a two option. Either you have to apply for a new license in terms of the order dated 21st of June 2024, or you have to challenge this order.
Yes,
Have
my
to
lord.
challenge this order in this writ petition.
Yes, my
Where
lord.
is the prayer? Where is the prayer for challenging the order? Nothing. Do not challenge that order.
My lord, then permission may be granted. I will add a prayer.
What permission? But have you taken any grounds on that?
My lord,
Where is
that
the
is the
ground?
main ground of our thing.
Where is the ground that the order not considered this, that? Where is that?
My lord, let me give you the crux of the history of the case.
Perhaps I will go first. Let your writ application should be maintainable first. Then I will go to the merit of the matter. Already earlier court has passed an order. In terms of the order, the authorities have passed an order. Kindly come to the page 60. Kindly come to page 60.
60.
Yes, 60. Paragraph 136. Being agreed dissatisfied with the repeated willful, deliberate, wrongful, arbitrary action on part of responding authorities, you not challenge that order. Where is
Lord,
that?
the entire crux of the matter will
where
show
is-
that
where-
this is
you show-
kindly consider that order first. Kindly consider the order first.
Sir, I will consider the order. If you had a two cause of action, either you have to apply a new license in terms of the order passed by the authority, or you can challenge. Now you are telling that admittedly you are not applied for the new. You are telling that the new cannot be applied. It is to be renewed.
Renewed. Yes.
Because renewal, because the other two establishment is to be run in terms of the if a renewal is given. This is the contention. I think so.
Yes.
Correct. So then you challenge, then you file the writ application. In the writ application, neither in the grounds nor in the prayer you challenge any of the grounds taken by the authority by rejecting your claim. So how?
My lord, the problem is it is a calculated and long-term harassment of my client, which is in total, including this order. This order has referred to one report, which is at page paragraph 6, 342. 342, the order part, paragraph 6. In the said reasoned order by the commissioner which had been communicated to the petitioner, some objections were raised, were mentioned for rectification by the proprietor of the AIDC for issuance of CE license. But the same was not complied or reported by the proprietor despite ample time given to him. Now, kindly consider this order, this reasoned order by the commissioner, which is at page 93. It is at volume 2, my lord. Volume 2 of my writ petition.
Yes, 93.
93 is the communication, 94 is the order.
Correct.
Relevant portion is at 95.
Yes.
Now, paragraph 8, my lord. And whereas HOD Department of Biochemistry of Medical College and Hospital, Dr. Tapan Mukhopadhyay informed the DME WB and submitted the report after inspecting the diagnostic clinic, which revealed that the infrastructure was having shortage of space. Then the medical person having postgraduate qualification, MD, from either pathology, biochemistry, microbiology, or medical geneticist was mandatory component as per existing rule to supervise the advanced setup. Hence, this medical person are indispensable for running the diagnostic center.
Correct.
Now, Therefore, considering the whole gamut of the case, the undersigned is of the view that unless and until Sri Manoj Niyogi equips his diagnostic clinic with the above criteria as above, Deputy Dr. Tapan Mukhopadhyay, HOD of Biochemistry, Medical College and Hospital, Calcutta, there is no cogent reason for awarding license and relief to the diagnostics clinic of Manoj Niyogi. So there are basically two criteria that has been referred to in this order. One is shortage of infrastructure. Kindly consider my supplementary affidavit.
No, sir, this order is which date? This order which you.
This is, I'm coming to that.
93 is.
This
of
is order of 2019.
19. When
19.
you challenge this order in the.
This earlier writ application, it has been, direction was given.
Now the 342 is the supersede order of this 2019.
Yes, my lord, but the problem is the link lies there. They have inspired the direction of the.
Okay. See, if as an advisory jurisdiction, if you want to continue, I don't think you will get anything. If you want to rectify your withdrawal, you file, I will give the liberty. That will be better, I think. It will be
If
better.
my lord is raising this question, let me have the liberty.
Not by pressure, you take your own decision. Because you are not challenged that order.
Yes, my lord.
The counsel for the petitioner submit that in terms of the earlier order passed by this court in the earlier litigation, the authority has passed an order on 21st of June 2024, but inadvertently the petitioner has not challenged the order. Accordingly, prays for withdrawal of the present writ application with the liberty to file a fresh. In view of the submission made by the counsel for the petitioner, WPA 21817 of 2024 is dismissed as withdrawn, liberty to file a fresh.
Did you request?
Next.
Reply. Yeah. Malad, the reply been submitted, Malad, because the opposition was being filed. Thereafter, we are filing this reply, Malad.
এটা बंद कर दो उड़ता है बंद कर yes
Malad, I'm a school teacher, Malad. I have taken a loan of a service loan from a cooperative bank, Malad. The name is Adhampur Kharidpur Somavai Krishi Samiti. Malad, they are being giving loans on the agriculture. So that day, what they had done out from the opposition, I got to know the service loan was not being provided. The loan for a house loan was being granted to me, Malad. That was a loan I applied for a 7 lakhs, Malad. They disbursed out 6 lakhs into that. I was paying the EMI, Malad, 15,300 from the day onwards when the loan started with. Thereafter, I had requested, they granted the amount, exactly the interest and the principal, the entire interest and the interest that came out to 10,000. So I start paying, Malad. So in June 2021, they raised out a demand upon me to give out 25,000 monthly EMI. So I said, how could I give out? I did not give an agreement to me. And even things are there, how the rate of interest has been going on. So in that case, they then issued out a letter to me in June 2021. Your total amount is something, the principal is 1,21,000 and interest it calculated to 2,34,000. Both the inputs, my lord. Later on, after 1.5 years, they came out with that the principal went down to 3 lakhs And the interest taking in the component that went down to 5.50 lakhs in something like that. After 3 months later, my lord, an advocate letter comes to me that went down to, my lord, 9 lakhs, my lord. The principal went down to 6
down
lakhs
or went up?
up, my lord. 6,75,000. So taking down the interest inputs, it came out to something around 9,75,000. Then they what had done out, they started a certificate proceeding, my lord. Certificate proceeding soon thereafter only. And in that they attached out my salary account, where they demanded 18,438 per month till the recovery under the West Bengal
What is the
public.
salary?
The salary was something 66 lakhs. I have taken
66 lakhs.
66,000, my lord. 66,000, my lord. One more loan I have taken from the mother cooperative bank, my lord, of there only itself, where already I took down 50 lakhs. I have been willfully paying 47,000 rupees a month. That is, in that case, there are no dispute in regard to that. But in this case, my lord,
So what you have read before this?
my lord, I am asking the certificate proceeding should not have been allowed, my lord, because that is altogether what the interest they are charging, even how the principal went down to double, my lord, within 3 months, my lord.
Go for the mediation. Go for the mediation, settle it.
I am ready to settle, my lord.
Yes, I am sending the matter to the. Yes.
My lord, decree has been passed against him by the certificate officer. He did not appear. Whatever he is telling there is not borne by the records. His application was for 7 lakhs for house building. This society is capable of giving that. My lord, that is in page, his application is in page 15. In page, in our reply, my lord. Then,
my lord, 15, just a second, if my learned friend allows me to have it. But at the top it is written service loan abedon. I went out for a service loan, my lord.
Service loan means based on service, that is security of service, and nothing more than that.
Yes.
Yes, my lord.
What can be done?
My lord, the certificate for them, what the rate of interest they have charged on the principal went out in the 3 months, the double principal was been given into that, my lord.
He must,
how could it be, my lord, without my hearing, my lord, without giving an opportunity to me, my lord?
Yes.
Yes, he was given opportunity. He did not appear before the certificate officer. He was given a number of letters. That is in my reply, but he has never replied to that. He did not appear before the certificate officer. And now because now he's feeling the pinch. He's now come with that. That is not bad. Let him show how the society has miscalculated or wrongly calculated the amount. It is also not a fact that he was not given copies of loan ledger. My lord, may come to page 47. That was issued.
47 of affidavit?
No, of my affidavit in opposition. They are whatever he had paid till the date of issue, that means 19th February 2020. Yes, November 19 opening balance and December, that is on the 19/11/2019 to 2025.
Principal, he has taken the 7 lakh.
Yes, my lord, he had paid only, he had taken loan of rupees 7 lakhs.
Correct.
Yes, he is telling about 6 lakhs because under his instructions, we transferred 6 lakhs to his another account in another bank. And this 1 lakh he took and deposited 70,000 rupees as security out of that money.
Where is the certificate order?
My lord, the certificate order is in page Barker.
My lord, I'll show some more papers in regard to the writ, my lord. Page number 33 can be taken of my writ, my lord. First, the certificate in my writ is 42 page. And whereas 33 I should start with, my lord. The letter which they had issued me, my lord, that is a letter of 10th of September 2021.
Just
yes, my lord.
yeah, look at this addressing the court.
My lord,
I will come to you.
My lord, I come to page 55 of my affidavit in opposition. That is the certificate proceedings that was initiated for rupees 10,05,831 on 28th day of February 2024. Then, my lord, a notice was issued to him by the certificate officer on the same on 29th February, and This is the acknowledgement that he had received. The post office memos are there and delivery orders are there. Then, my lord, this is the order. The certificate date, prayer for recovery of certificate date, a certificate officer. That is the prayer to certificate officer.
53.
Yes, prayer. That is the prayer.
No, that is the page 53 of the award. Award
No,
is
no, no. Page 53 is page.
the award.
No, my lord. Page 50.
Your affidavit in opposition, page 53 is the award.
Yes,
19 December 2023. That is the award.
Yes, my lord.
55 is the.
55.
No, page 55 is the demand.
Now 53. Kindly come to the page 53 of your affidavit.
Yes, my lord.
That is the award.
That is the award.
Expertise.
That is the award. Expertise, because it didn't appear.
Assistant Registrar Cooperative Society.
Yes.
Yes.
His
What,
certificate.
how the writ petition is maintainable here?
My lord,
Against the award?
my lord, the copy which they have been saying, they have sent it to me.
No, I am only asking, once the authority has passed an award, you have not appeared whatever. How the writ petition is maintainable?
My lord, because the natural.
Under the cooperative, it is the appealable.
My lord,
No, my lord, this here he had to appeal before the district magistrate.
That's why appealable. It is the appealable order.
Yes, it's not
my lord, altogether a violation of natural justice has been done. But kindly,
You're not
my lord,
appealable.
kindly take to page number 33 of my writ petition, my lord. It's a letter that has been issued, my lord, a letter on.
And the award is dated which date?
That is, my lord, on 19th December 2023, my lord.
23. And when you file the writ application?
My lord.
25.
25.
My lord, kindly page number 33 can be
Yes, I
taken.
am.
My lord, natural justice, my lord. It's a letter issued on 10th of September 2021, my lord.
Correct.
Why they say out the total amount which is been there, my lord? The principal amount is 1,25,000.
That's correct. You satisfied this court. First of all, the bank has initiated the proceedings for recovery of the amount. Notice was issued, you have not appeared. Then the ex parte order was passed on 19th of December 2023. You have not challenged. After the 2 years, you filed the writ petition. How the writ petition is maintained?
My lord, later on I came to know, my lord.
Okay.
Later when I came to know, my lord, I came out with the
to him
writ,
on the same day.
my lord, what they say out, my lord, what they have been showing the postal receipt, the
Yes, the
letter
postal
never been
receipts is there.
received by us, my
You
lord.
take all the plea before the appellate authority. If good. I am dismissing this.
My lord, but it's all together, my lord, within 3 months, the things get out to double, my lord.
What can be? You
No, no.
What the court will do? You have obtained the loan. You are not paid. They have initiated
My lord, the
proceeding.
loan
You
should
not
have been
appeared
paid, my
before the
lord. I
authority.
had asked out them to settle the matter on a one time, my lord. But if they go on within 3 months, my lord, the principal goes out from 3 lakh,
My lord,
3
they
lakhs to
not
6
have a
lakh
principal.
70,000, my lord.
Principal
With
was not
3
3
months,
lakhs.
the
That was
amount goes out from 3 lakhs to 6 lakh 75,000.
6
Can
lakhs
it
was
be
the
done, or
due.
my lord?
When I
It's very
filed the case, it was
unimaginable
6 lakh
how the
75,000 was there.
cooperative has worked out on a what
My
rate
lord,
of
my lord,
interest they
is
worked
trying to
out.
twist the matter.
That never been disclosed into that, my lord.
It's twist the matter. 3 lakhs was the demand at that point
But
of
I
time.
can
But
show
it,
from their
as
own
it didn't
papers.
pay,
It's
the
not
entire
my
loan was
paper,
called
my lord.
back.
By the what they have issued the letters to me, from their letters it can be illustrated, my lord. The
No.
double the amount went out into that, my lord.
So how? This is the only one loan, 7 lakh. This is the only.
Well, 6 lakhs were disbursed, my lord.
One
What-
say 7 lakh was distressed. That I will show also.
My lord, page number 30.
The petitioner has filed the present application. The present application. Praying for.
Check then, you know.
Praying for challenging the award passed by the Assistant Registrar of Cooperative Societies, Paschim Medinipur Range, dated 19 December 2023, wherein it was directed to the petitioner to pay the principal amount of rupees 6,75,364 and interest of rupees 3,13,067 calculated up to 18th of December 2023, cost of rupees 6,000, total amounting to rupees 9,94,431, and further interest at the rate of 14% per annum from 19 December 2023 till the final realization of the said amount. Full stop. This full stop. Counsel for the petition submitted. The petitioner has obtained the loan of personal loan of rupees 7 lakh from the Adampur has illegally charged the interest over the loan amount.
The amount due at that point of time.
Due to which the petitioner was not able to pay the said amount. He further submit the petitioner is ready to settle the dispute, but the bank is claiming the total amount of 9,94,431 along with interest. Learned counsel appearing for the, you are for the bank?
My lord, I am for the society. Respondent number 2 and 3.
For the respondent number 1 and 2?
Yes, 2 and 3, my lord.
2 and 3. 2 and 3. Submits that the petitioner has obtained loan of rupees 7 lakh and he failed to pay the said amount. Accordingly, proceedings have been initiated by the bank. Notices have been issued to the petitioner. In spite of receipt of the notice, the petitioner failed to appear before the Assistant Registrar of Cooperative Societies. And finding no other alternative, on 19th of December 2023, the Assistant Registrar of Cooperative Society, Paschim Medinipur Range, had passed the award. Ex parte. He further submitted that the award passed by the Assistant Registrar of Cooperative Society, Paschim Medinipur, is appealable order, and the petitioner has filed the present date application in the month of January 2025. That is after the period of more than 1.5 years. So, about 2 years. About 2 years. Good. He submitted the writ petition had the learned counsel for the respective parties peruse the matter. This court find that the petitioner the Assistant Registrar of Cooperative Society has already passed an award on 19th of December 2023. This court also find that prior to the award, several notices have been issued to the petitioner, but the petitioner failed to appear legally. In fact, the award passed by the Assistant Registrar of Cooperative Societies, Paschim Medinipur Range, is an appealable, but the petitioner failed to prefer any appeal and has filed the petition after the period of 2 years. Considering the above, this court find that the writ petition is not maintainable. Accordingly, the writ petition is dismissed. However, it is made clear that the dismissal of the writ petition will not prevent the petitioner for taking appropriate steps in accordance with the
Malad, a leave should be granted. That is, if I have to go for an appellate.
That's leave.
But the limitation should be Malad taken.
Take the before the authority. The court can.
But Malad, altogether, I have come out with a rate because Malad, for 3 lakhs within 3 months, is get out to 6,75,000.
Why you not appear before the authority? Yes, call the net.
This matter, I beg to appear on behalf of the without any this matter, the application was done.
Yeah?
Petitioner goes.
Who is for the petitioner?
I am for the petition.
You are not issued the notice by application.
Notice issue.
Am I the audience? Because of me,
me I don't know.
Yes, what is the urgency
yes,
here?
yes. Urgency it is filed earlier.
Huh?
It is filed earlier. It is auction case, which was floated by the Barakpur cantonment. Inviting the public to participate in the auction. So my contention is this, I also participate through online. But it was rejected on technical ground without having any reason.
disclosing any reason. This is the first point. And secondly, my lord, they initiated the proceeding auction proceedings without my lord carrying out the order passed provisions of this my lord act, which was specifically stated that Dum cantonment has got no legal right to my lord to initiate the auction. It is the auction to be initiated by the district magistrate if two municipality covers the waterways. According to their bylaws, it has been stated that it is West Bengal, it is covered by the Bengal Ferries. Bengal Ferries Act, it is applicable if two waterways covers.
What you prayed for?
I am quashing entire proceedings to be quashed.
Entire proceeding is to be caused.
Yes.
Then they have to file affidavit. Then they have to file an affidavit.
They going to the civil court.
This is
This is the order of the civil.
no civil court. It is.
See the page 4 where
It is my lord civil court. My lord, I want to my lord participate.
technically they
I want to participate. It is separate case. It is totally separate case. I have come. They are not party there.
This is the tender process of October 2024. Correct. Award work has been awarded. The tenure was completed. You were unsuccessful bidder.
No. I am not unsuccessful.
No, you are not unsuccessful.
Yes.
As per the authority, you are the unsuccessful bidder. The award work was not awarded to you. Correct. So, subsequently, you file the civil suit. What do you file the civil suit?
Yes. File the civil suit to participate in this auction.
Participate in the tender process.
But they are not party there. They are not party there.
Okay, whatever it means, but so against whom you filed the civil?
That is my only executive cantonment.
Cantonment.
Only cantonment.
Okay, so that
so my cantonment board,
what was the prayer in the civil suit?
Prayer in the civil suit only to participate.
Only to participate. But that has been
that has been cancelled. I made application before this my lord High Court and this Honorable High Court. This matter is pending.
Which against this appeal?
Against this.
Okay, no problem. Whatever it is. So now what you are paying here?
I am praying my lord to initiate which was proceedings was initiated. The auction proceedings which was initiated is bad in law and illegal. So therefore, they are proceedings. No, it has not been decided.
They have raised the.
No, it has not been decided.
Has been decided.
It has not been decided.
Page 4, my lord.
Your lordship kindly come. Your lordship kindly come.
Kindly come. Yes, kindly come to the decree. Decision with reason. Kindly come to that. The Cantonment Road, Barrackpur issued a notice so and so for re-auction for grant of right to collect charges from the passenger ferrying between so and so. Correct. In the notice so.
Notice it was notice issued to only to participation. Participation was cancelled, which was challenged. I have not challenged here the participation of the auction. That is my lord page. I have indicated page 50.
For permanent.
Yes, kindly come to page 6.
Page 6.
Page 6 first.
Konta.
Page 6 of the decree.
No, judgment amar kache.
Page 6 of the decree. Have you the decree? Page 6. Kindly come to the page 6.
Page 6.
Yes.
The miss appeal and the same is dismissed.
No. First line.
Yes.
First line. Kindly come to the page 5, last paragraph. Page 5, last paragraph. So it appears from the
data written by the plaintiff. Defendant did not have a requisite qualification to participate, which is sufficient to disqualify him to participate the e-auction of Cantonment Board, subsection 1 of 61.
Yes.
This has been challenged.
Read further.
No act or proceedings of the board or any committee of the board shall be invalid by reason any of the existence of the vacancy of the board of committee. As such, it cannot be said the Barrackpur cantonment is not in existence and the board cannot enter into an agreement until and unless the constitution of the board is complete.
Then
it is only issue.
Yes.
But this issue, what is my issue?
Paragraph 5,
1 minute,
page 5, detailed, it has been.
Yes, Padma.
1 minute.
I appeared
What
in
is,
the
what
suit,
is my
madam. I
issue?
appeared in the suit.
My issue is here, your lordship kindly Municipality
You
Act
are prayed
first.
for, kindly come to the prayer portion.
My lord. Prayer portion. In the circumstances, most humbly praise that your lordships edit in the nature of mandamus, the concerned respondent authority withdraw, recall, or resign the auction dated such and subsequent notification such and the 1 minute. And the selection of the private respondent, Tapan Banerjee as the highest bidder in the ferrying respondent number such to pass further to quash and set aside the entire process of the auction.
This after participating in that sentence.
No, I have not participated.
Please,
My lord.
let understand. So you are praying for quashing of the e-auction process, correct? Which has been awarded to the private respondent and subsequently it was amended. Now you are telling that is to be quashed, the total process. That work was awarded. What was the tenure of the work?
5 years.
5 years.
5 years.
From which year?
1st April, 5 years which is pending before this honorable. This, I filed this application.
5 years.
This,
April 2025.
that may be. Well, I am, your lordship, my lord, kindly come to my lord, the section. Come to month to the section and my lord, the provision. That is my lord, what Bengal Ferries Act said. What Bengal Ferries Act, Bengal Ferries Act. And my Municipality Act 138. They have my lord, taken my lord, less money.
Sir.
And my lord, it is depriving the entire.
Okay, whatever
Yes,
it
yes.
may be.
138, your lordship kindly.
Okay.
138.
So what you want now?
I am just justified that he has got any authority to conduct the auction or not.
Okay, let the file affidavit.
This particular issue was thoroughly.
Yes.
Take all the thing.
Tell all this.
And I am kindly keep the point of maintainability open because I have supported with judgment of the Supreme Court.
Petitioner has
Maintainability point may be kept.
Mentally point may be open.
The petitioner has prayed for withdrawal plus recall plus resign of the e-auction dated 30th October 2024 and the subsequent notification / correction dated 6th December 2024 by selecting the private respondent number 5 in respect of the ferrying passenger between Dhobighat, Barakpur and Jugal Adhya Ferryghat, Srirampur.
No.
Srirampur. The Learned Counsel for the respondents submit that the tender process, the petitioner has participated in the tender process, but the petitioner is not successful to get the tender and the private respondent has been awarded the work. The petitioner has already filed a suit before the Learned Civil Judge before the Learned Civil Court against the Chief Executive Officer, Barakpur Cantonment Board, but the Learned Court of Civil Judge, Additional District Judge, First Court Barakpur has dismissed the suit filed by the petitioner. It is the appeal.
It is the appeal. Against the appeal matter, I have filed my revision application which is pending. It is not been. Only interim order refused.
Civil suit being TS number 8051 of 2024.
It is not merit of the case. Interim order refused.
Against the Chief Executive Officer Barakpur.
Why you are saying it has been merit of the case?
And in this suit, the petitioner has prayed for interim order. The interim order was rejected. Being agreed with the said interim order, the petitioner has prepared an appeal before the district judge. The district judge has also rejected the appeal. Now the petitioner has prepared a revision application before this court and the same is pending. Counsel for the respondent submit that the work has already been awarded and it is valid up to 5 years and nothing remains in the present application. Counsel for the petitioner submit that he has challenged the total process of the total tender process and as such the matter is to be heard on merit. In view of Counsel for the respondents have raised the point of mentality. The mentality is kept open. The respondents are directed to file appeal in opposition within 4 weeks. Reply, if any, they are to be filed within 2 weeks thereafter. Please the matter on 11th of February 2026.
Right. Well, the mentality point is
I appear.
Yes.
I'm from the state. I'm from the state.
What is your prayer, sir? Award of national consumers. So why be the writ application? National type. So notice not served. You are appearing for whom?
So I'm appearing for state. I'm paying for not today.
You are appearing for?
State. Well, senior is not available today, my lord.
From my here, that tomorrow is the date for execution. Only give me that little protection for a day, and thereafter any date
Before the state forum?
before the state forum. I have nothing to say because I find that the affidavit of service, my lord, is not sufficient to show that yes, I have given sufficient time.
What is the deficiency?
Yes. Now, my lord, actually, the dispute is the complainants, my lord, filed a flat. Complainants filed a, my lord, purchased a flat. Now, my lord, it appears that their grievance is that there is deficiency of service. The time within which you are required to give the flat, that was not done. And thereafter they made other prayers. Now, the first court, that is the state forum, that passed an order which your lordship will be pleased to find that at page 58.
58 to 61, the first order.
The agreement.
You know, the 58 means upper portion. Kindly see, there is two, I cannot do anything.
I remember when I was junior.
Yes.
And my senior was arguing the matter before the division bench. There was correction like this only. There was correction in the pagination. And Justice B.P. Banerjee was presiding over the bench. So he has said something to my senior. My senior had taken this file and put the file on my face.
Milord, I must be very candid to my lords that so far as my senior was concerned, Milord, Milord is no more. He is also a person of that nature and temperament. And I now also, Milord, possibly I am also aging. Therefore, Milord, I also sometimes feel that these sort of things, that is the difference of the pagination, it leads to more confusions.
Correct.
It leads to more confusions because the time of the court has to be saved. Kindly see the order of the State Consumer Disputes Redressal Forum. This has been passed on 16th of August 2019.
The petitioner has filed the present writ application challenging the order passed by the learned National Consumer Dispute Redressal Commission, New Delhi, in first appeal number, the State Commission of Calcutta.
No.
State Commission order?
No, this is Milord. Milord, I find Milord New Delhi.
No, State Commission also New Delhi.
State Commission is Calcutta.
Yes, that's why, because otherwise the rate will
This
not.
is at 11 a Mirza Ghalib Street.
Redressal Commission, New Delhi, in first appeal number 1954 of 2019, dated 16th August 2019. No, 16. What is the date of the
execution?
Redressal Commission order.
National Commissions.
Dated
Page 259. Page-
25th September 24.
No, page 259 is the
Order date টা চাইছেন এই যে 25th
and this has been delivered, this judgment has been delivered on 25th of September 2024.
dated 25th of September 2024. Full stop. Full stop. The petitioner has filed affidavit of service, but it is found that the notice has not been sought. Only the learned advocate appearing for the state is present. Counsel for the petitioner informed this court that the respondents private respondent have filed the execution proceeding before the
Milord, my learned junior has obtained the order. I should show to my lords. একটু Joseph কেটে দিয়ে দেবেন। Tomorrow is the date.
क्या बोला? Application case before the State Dispute Redressal Commission, West Bengal, being execution application number SC/19/EA/151/2019 and tomorrow is the date fixed before the learned before the state forum. Police. The learned counsel for the petition has also relied upon the judgment in the case of Universal Sompo General Insurance Company Limited versus Suresh Chand Jain and another, reported in 2024 with volume 9 SCC 148, wherein the Supreme Court has held that have filed petitioner has to first go before the jurisdictional high court, either by way of writ application under Article 226 of the Constitution of India, or by invoking the supervisory jurisdiction of jurisdictional high court under Article 227 of the Constitution of Police. Of course, after the High Court adjudicates and passes a final order, it always open for either of the parties to thereafter go before the Honorable Supreme Court by filing an SLP. Police. Considering the judgment relied by the petitioner, the petitioner consider the judgment relied by the petitioner. Full stop. Though the private respondent is not appearing, but the London State Forum has fixed the case of hearing of the execution case on 17/12/2025. Accordingly, for the time being, execution proceeding initiated by the private respondents is straight till 8th of January 2026. Or until further order, whichever is earlier, full stop. The petition is directed to communicate this order and to file affidavit of service on.
I'm grateful to my lord, extremely grateful. May I get an urgent so that I can communicate?
You will
Otherwise,
get the order today evening itself. Today evening we'll get in the website.
you get football.
My lord, I want CSC, my lord, this matter part.
My lord, 10th of December 2025. My lord was pleased to direct me, my lord, to effect service on the private respondents and file affidavit of service. My lord, this is my affidavit of service. They were not appearing. There is already a report by the distribution licensee, which is on record, my lord.
May I submit, my lord?
My lord, please take up, my lord, 2C and 2D of the report.
Report dated?
Report is dated 4th July 2025.
It's a single page report, may not have submitted on the other day.
2C and 2D.
Not have got a copy. It is leading.
Yes, it is there.
CSC service cable at the premises is in order. The main switch of Shantanu Shah is the petitioner before my lord, was found in covered condition with padlock and in-off condition, because of which he is not getting supply in spite of his meter being in live condition. My lord, what is happening, my lord? This meter, electricity meter, my meter is located in my tenant's portion, against whom an eviction suit is going on. He has put up a padlock and switched it off. My lord, the suggestion, very fair suggestion, I should say, during inspection, a common position was identified by the undersigned near the main gate, which is technically suitable for shifting of service, subject to some renovation work which is to be done by the occupiers of the premises and upon compliance of necessary formalities, including payment of requisite charges. My lord, I'm ready to do the renovation work and put in the requisite charges so far as shifting is concerned.
My lord, as your lordship knows, my lord, the shifting of service needs a further inspection, and the place where the common meter box will be placed, admittedly it needs to be renovated. And my lord, thereafter, subject to compliance, my lord, we are ready and agreeable to shift the service line along with all the 3 or 4 live meters. Now, my lord, the only one question is that, my lord, that without the consent of the concerned consumers, in general, we are not supposed to shift. But my lord, since he is the owner of the premises, and if your lordship so directs, we are ready and agreeable to go ahead with the shifting. But my lord, only 2-3 things, my lord. My first point is the space where the common meter box will be shifted needs to be renovated. My lord, the payments are to be made, and my lord, a consent, just a consent from the other consumers to shift. They might not be paying. The consent is required, my lord. And my lord, let there be also a direction for police help if required.
My lord, I'll just highlight paragraph 4 of my lord's order, which is dated 10th of December 2025.
And my lord,
It is
kindly direct the petitioner.
It is made clear that on the date fixed, if the private respondents, in spite of receipt of notice, will not appear, appropriate order will be passed.
And my lord, only one thing, my lord, that kindly direct the petitioner to apply an application online for this shifting. For this shifting of service. And we
But
will subject to
please-
compliance. we'll
Please
do that.
fix a date and time, my lord. I'll go to their office and from my.
Online, my lord, it is not question of going.
No, I will pass an order.
My lord, I don't know how to apply online.
Within a week, you
Yes.
send the online application.
My lord.
Yes.
To the
Your client
authority.
knows.
Authority on receipt of the application will make inspection within a week
My
there.
lord.
Yes.
And thereafter,
By notifying the date to the petitioner, and after the inspection, the authority will take appropriate steps for compliance of all formalities by you.
Yes.
and my lord, only one more thing, my lord. In terms of clause 7(2) of regulation 55, my lord, all the internal wirings and the affixing of the
On
meter
compliance
box.
of all formalities.
My lord, my lord, my lord, my
To
lord.
inspect,
My lord,
if
my lord.
the wiring is
On the compliance of all required formalities.
all
And upon all the
including payment
due
of the
payments.
charges.
My lord, my lord. Dispose of courier note. Dispose of. Huh? Dispose of.
The petitioner has filed the present writ application, praying for a direction upon the respondent's authority that we see as the limited for providing for installation of the electric meter in respect of consumer number 28033241005 in any other alternate location of the premises number 55G Beleghata Main Road under Police Station Beleghata, Kolkata. Police. This court has called for the report from the CSC Limited, and accordingly on 4th of July 2025, the senior engineer CSC Limited has submitted the report, which reads as follows. Yeah, no? These two. Concerning the report, it is found that the CSC is ready to provide the electric meter of the petitioner, subject to the
Shifting of the service
shifting
line.
of the service line of the petitioner.
To a common meter box position.
Shifting of the service line of the petitioner, as well as
But
the
the
common
existing-
box of the common meter box, subject to the conditions as mentioned above. As mentioned. Full stop. In view of the above, this could find that no purpose should be full stop. On the earlier occasion, also the private respondent has not appeared. Accordingly, this court has directed the petitioner to serve the notice upon the private respondent and to file affidavit of service. In compliance with the order passed by this court dated 10th of December 2012, the petitioner has served the notice upon the private respondent, but in spite of service of notice, none appears on behalf of the private respondent. Thus, this court has no other alternative but to dispose of the present writ application in the absence of the private respondent. Full stop. The petitioner is directed to compliance all the formalities for getting the service line connection in the premises of the petitioner. Within how many days it will take for making all wiring and all these things?
But first I have to apply online. Thereafter the inspection happens.
The petition is directed to apply for the service line connection.
Shifting of the for the shifting of the existing service line.
Shifting of the existing service line before the CSC within a week from date.
My lord.
On online procedure. Online procedure.
My lord, online
Through
procedure.
online procedure. Full stop. On receipt of the request of the petitioner by the CSC authority, within a week from the date of receipt, the CSC authority shall inspect the premises of the petitioner by notifying the date and time to the petitioner, and the petitioner shall available at the premises at the time of inspection by the CSC authorities. Full stop. After completion of the if the CSC authorities find that if any formality is to be completed by the petitioner for getting the service line shifted, the petitioner shall complete all the formalities within a week thereafter. And to inform the CSC authorities. Full stop. On getting on, if the CSC
And
authorities.
thereafter, after inspection, we are supposed to issue a offer letter.
Full stop. That's why if the CSC authorities find that the petitioner has complied all the formalities, the CSC authorities shall issue the formal
Offer letter.
to the petitioner, and the petitioner shall submit the required fee in the to the CSC authorities. Note, and on receipt of the fee, the CSC authority shall shift the service line as well as the existing meter.
Subject to compliance of all the required formalities.
The place identified by the CSC authorities subject to compliance of all formalities. Full stop. It is made clear that if at the time of inspection and shifting of service line and the meter board position, if any of the person, including the private respondent, raise any objection or restrain the authorities for shifting the service line connection and the present meter board connection, the concerned police authority, that is
Respondent number 6.
the respondent number 6 shall provide
Officer in charge, Beliaghata Police Station.
the respondent number 6, that is the officer in charge, Beliaghata Police Station, shall provide appropriate police protection to the CSC officials to shift the service line connection as well as the present meter board connection as per the identified place. And if any charge is to be paid with regard to the police protection, the charge shall be paid by the petitioner.
Shifting as also inspection. Because during
Common service position,
Only meter board.
Only the existing service line, and he has to construct
the meter board, the lock, what is that?
There will be a meter board where all the 4 meters will be affixed afresh.
Okay.
And a new service line will be placed to provide electricity to that particular meter board.
New service line, not the meter box portion. New service line. Okay.
New slash
shifting of the service.
Existing.
Shifting.
Of the existing service line.
Much obliged.
Millard, item number 16, I beg to appear on behalf of the petitioner. Millard will seize the last order. Millard, this matter was directed to appear yesterday on 15th. Since it did not appear, Millard, we had mentioned this. Now, Millard, I am being led by Mr. Sabyasachi Chaudhary. Millard, he is indisposed today and tomorrow. So, Millard, kindly fixes, Millard, if at your lordship's convenience, on 18th or 19th, Millard, as per the convenience of my.
What is the urgency?
Millard, the urgency is that, Millard, an illegal lookout circular has been issued against me. Now, Millard, I am not being allowed to travel outside, my lord. While I'm complying with the investigation, no complaint is filed and complete.
Who has restrained you?
Millard, the lookout circular, Millard, I've shown, Millard.
Circular is issued.
Yes, my lord. I'd gone to the airport, Millard. I was returned back, Millard. I was not allowed to leave, my lord. Twice I've tried, Millard, twice.
Let him fix on 19th. We will give the seal envelope.
As per the prayer made by the parties, let the matter appear on 19th of December under the same heading.
Millard, let it maintain its position in the list.
At the same heading. Next.
Deeply obliged, my lord.
Millard, I am appearing for petitions.
17 inch matter appearing for the respondent number 1 to 3, my lord.
My lord, I am appearing for respondent number 4 onwards, my lord.
Last question, lordship, file a report.
My lord, my junior is there. She will hand over the report before your lordship.
Reported একটা copy. Reported copy.
Yeah.
The reported copy.
Okay.
My lord, on 23rd April, e-tender was issued through e-tender portal, my lord. And after opening of the financial bid on 16th May 2025, we were decided to give the order to the H1 bidder, the petitioner herein, my lord. But after getting a complaint representation from another participating bidder, namely Smart Food, this representation raised specific objections and sought re-verification of the technical documents, my lord. Paragraph number 3.
Yes, madam.
Your Lordship, so they filed the report. I will need to file the exceptions to the report, Your Lordships. And kind.
Exception. There are so many discrepancies. That's why you have not been allowed to further proceed with the tender process. So they have opened the tender.
Your Lordships, I laid by the advocate Satyajit Sinha Roy. I laid by the advocate Satyajit Sinha Roy, Your Lordships, and he's could not appear today.
On your prayer, the matter is taken as the urgent motion, and you are not appearing.
My lord, I am praying for the Passover, my lord.
Not Passover. This court neither Passover not adjournment. If your matter is in the list of urgent motion, either you have to argue or go to the next month. I already made it clear because
Lordships, if the
morning half an hour you are wasting the time of the court for urgent motion. When the matter is coming on the urgent motion, you are asking for the Passover or adjournment.
I will receive the report, Your Lordships.
Okay, give the report.
My lord, please come to the paragraph number 6 of my report, my lord. Bottom of the first page.
I have gone through. Give the copy.
I have one copy only.
Huh?
I have got one copy only.
Get the Xerox and give.
Yeah, I'll do.
Who has filed this to both? Who has filed this report? Report filed by whom?
Report
filed by the state.
Report filed by the state, my lord.
The respondents have filed the report.
On to
After serving the copy to the learned counsel for the petition, the petition placed for time
1
to
to
go
3.
through the report. Accordingly, case is
4
adjourned.
to 7, my lord.
Let the matter appear in the let the matter appear on 6th of January 2026. Next.
Deeply obliged, my lord.
Deeply obliged.
Yes.
My lord, I am appearing on behalf of the petitioner, my lord. I have served the last order of the my lord's order.
I am for
to the
WBS.
respondent. East Kolkata Wetland Management Authority. They have to file a report.
Chief Officer of the East Kolkata Wetland Authority within a week after serving the copy. Have you filed the report?
Yes,
We have not received any.
received it very recently, Your Lordship, yesterday. So that is why I'm handing over copies, one to the electricity and one to the petitioners.
No?
Yes, report.
We,
I don't know what is the report.
Your Lordship, because we categorically state in our report that this area falls within the East Kolkata wetland. And since this is an application for new electricity connection, so it cannot be given.
My lord, according to the schedule of
You go through?
yes, my.
Go through, come back. Or you want to argue today itself?
No, my lord. I have to go through that. Well, kindly fix a date if an exception is filed.
The EKWMA. EKWMA, East Kolkata Wetland Management, has filed a report after serving the copy to the petitioner as well as WBSC DCL. Let the report be kept in the record. Counsel for the petitioner prays for time to go through the report. According to the case adjourned, let the matter appear on 7 January.
7 January. Grateful, Your Lordship.
Good.
Under same heading.
May I please, Your Lordship? My lord.
19, my lord, your lordship.
This is the matter, my lord.
Respondent, my lord. Last occasion matter was heard at length, my lord. Ultimately, the learned advocate for the petitioner prayed for an adjournment.
My lord, this is possibly, my lord, incorrect. My lord, by that time I conclude, my lord, the lunch hour commences, my lord. If your lordship was pleased to ask me to come back, my lord, I am yet to conclude. If I may take your lordship to the facts which I have narrated on the earlier occasion, my lord. If your lordship be pleased to recollect, my lord, this is the matter where the tender, my EMD was forfeited on the ground that I have given a wrong quotation at the time of bidding. 2 crores has been inadvertently gone down in place of 20 lakhs, my lord. Now, my lord, MSTC The auctioning agency has raised their case on the fact that under clause 14(1) of the tender document, my bid was cancelled and the EMD was forfeited. Now, my lord, the first question about, if I'm allowed to ask this question to myself, what is the locus of MSTC in
The EMD is submitted.
my
What
lord?
was the EMD?
My lord,
What is the amount of?
my lord, 23 lakhs odd, my lord. My lord, the first question, my lord, to address your lordship, what is the locus of MSTC? But with deepest of respect, MSTC is only a auctioning agency. The forfeiture, the cancellation of the tender process and the subsequent forfeiture of the bid amount, my EMD amount, is at behest of the port authority and not at the MSTC, my lord. So far as so the role of MSTC, once the bid is completed or once the tender is auction process is completed, the bid, the stand of MSTC stood concluded over there.
You are only the cases that you have 20 lakhs, which has come as 10 extra.
0 extra. Now subsequent.
That's why you are not able to take the work order, and it has been.
My lord, the work order not issued, my lord. That was my case, my lord.
Yes, sir.
My lord, on 20, when
ready for the 20 lakhs.
No, he has withdrawn.
My lord,
He may
on
be exempted for the last bid. That is withdrawn.
my lord, 20 lakhs, when I put it inadvertently 2 crore in place of 20 lakhs, I immediately wrote an email saying, kindly do not consider my last bid. I sought for an exoneration or an exemption from that bid amount, my lord. Last bid. Despite that, my lord, the respondent authority went on cancelling the entire e-auction process and subsequently forfeited my amount, my lord. My lord, now to that effect, my lord, if I may place, there is a RTI. In the RTI, because when I was not aware, like on what ground my EMD was forfeited, I have made an RTI application, my lord, which your lordship will find, and the reply to
Not the issue, my lord. This
my lord,
issue has been
kindly allow
decided.
me to place.
I have given an order to my lord friend in the last occasion also. Kindly see that order thereafter, whatever he
My lord, I have not been favored with the order on last occasion.
He has taken the number of your WP number.
Can you, if Mr. Jain would be kind enough to serve
In the last occasion.
my lord, in that event, I do not have the order.
Then yes,
Lord, my junior, my lord, my junior is saying.
There, my lord. WP number 519 of 2017. Yes. The coordinate page. The exact issue. Exact issue.
My lord, 20, I'll rely on one single judgment, my lord, though it's a bit lengthy, my lord. I will narrate the entire incident which exactly matches my case over here, my lord. My lord,
Gone through the judgment passed by.
my lord, I'm not versed with the judgment which Mr. Jaina is placing, my lord.
That is the same also.
My lord, kindly be of your
my
lord.
Extra zero was put there.
My lord, subsequent thereto, my lord, kindly see the conduct of the authority, my lord. My lord, if for my pleasure, my lord, if your lordship be kind to take page 188, the RTI reply, my lord.
188.
188 at volume 2, my lord. My lord, it's my mistake. The RTI query reply starts from page 184.
Correct. Yes,
My lord, the question and thereafter answer in that manner, my lord. The first question is the ground and reason based on which the EMD. My lord, the question is at page 184. In the bold portion, the question was indicated.
Where is that?
The grounds and reason based on which the EMD of Technomines Private Limited was forfeited despite no LOA or FOA being issued. That is the question. 184.
Yes.
My lord, in reply to that, as per clause 14(1), which my learned senior friend has relied on earlier occasion, withdrawal of the bids attracts forfeiture of EMD. The petitioner submitted the highest bid in e-auction on such and such date. Later on that day, an email was received from such and such email ID with their registered email ID, such and such in CC, copy 2, expressing unwillingness to honor the quoted bid. This was treated as withdrawal. Now, my lord, I'll take your lordship to the particular content of the email. That email has been treated as a withdrawal on my part from the bid amount. My lord, secondly, my lord, the second question, a copy of the relevant internal file noting correspondence of minutes of the meeting which led to the decision of forfeiture of our EMD. My lord, in this regard, they have relied on a tender committee minutes which is attached. My lord, I'll just come to that tender committee meeting, my lord. Thereafter, my lord, so far as question number 3, answer to the question number 3, immediate thereof, certified copy of the order or communication or notification through which the tender was cancelled. Reply they're giving, the tender was considered discharged. My lord, I do not know what this language constitutes.
Where from your reading?
My lord, on the same page, page 184, answer to question number 3.
Certified copy of the order communication notification through which the tender was cancelled.
Cancelled. My lord, the reply, it states the tender was considered discharged following the withdrawal of the bid by Techno E-Mines. My lord, so far as withdrawal is concerned, I have never withdrawn from the bid. And there cannot be any process of discharge within the parameters or within the leaps and bounds of the tender document. My lord, so far as fourth is concerned, because this fourth answers what has fallen from your lordship on last occasion. My lord, there are two bidders at the relevant point in time. A list of other bidders, a question was passed, and the reply there are two states, apart from Techno E-Mines, who were H1 and then backed out, the other bidder, namely such and such, had participated in the said tender, as there were neither H1 nor they have had not withdrawn their bid, their EMD was not refunded. So, my lord, their case at that point in time, since I have quoted an abnormal amount of 2 CR, they withdraw from the bid. But the RTI reply stated otherwise. They have not withdrawn from the bid. I have quoted an amount of 2 CR. Subsequent thereto, I have been declared as H1 bidder as per their document. I am relying on their document. Now, my lord, so far answer to question number 3, as I have appraised your lordship regarding the tender committee minutes. My lord, the tender committee minutes, your lordship will find that starting from page 188, the relevant portion is at page 189. My lord, the first paragraph talks about the factual aspects, and thereafter, my lord, Roman 3 at the middle of page 189. After completion of auction, email of Techno E-Mines dated 16th of February 2024 was received, in which the bidder mentioned they want to quote a maximum value of 20,701,000, but instead had mistakenly submitted 2,07,001 against the above mentioned bid and not the considered last bid.
From your reading.
My lord, Roman 3, page 189 at the middle portion, immediately after the tabular statement, my lord.
Yes.
The second line was received, in which the bidder mentioned they wanted to quote a maximum value of 2 CR, but instead that mistakenly bid amount was gone down as 2 CR against the above mentioned bid and not to consider the last bid. My lord, kindly see the language. It's their documents. It's the tender committee minutes which is considered in my submission, which has been put forth before them, and I am only seeking an exemption that kindly do not consider. My lord, to wildest of dream, it cannot be imagined that it can be construed as a withdrawal of the bid. My lord, immediately thereof, in reply, MSTC, the auctioning agency, through email dated 17th of February 2024, has mentioned different step of auctions. Once the bids are submitted by digital signature in the court of law, my lord, I do not know what is the role of court of law comes in between. The same becomes non-repudiable, and MSTC has no role to play in such a situation. My lord, thereafter, in the next page, the observation under the heading observation, which starts at page 189 under C, Roman 3 at page 190, MSTC in their email submitted stepwise auction process and finally opined that once the bids are submitted by digital signature in the court of law, same thing, the same becomes non-repudiable and MSTC has no role to play in such a situation. TC, Roman 4, that is the tender committee, also observed from the email of MSTC that there is a system of showing warning message when quoted price was 5 times or more than the floor price of auction, and also there is an option to cancel the bid at the point in time if the bidder felt necessary. My lord, they are saying it's a preventive measures which the MSTC has put forward in an event. If I put an abnormal amount, which I have done, so there will be a warning, there will be a pop-up message in the display of my computer, of my system. There will be a warning, there will be an alert which will show that you are putting this an abnormal price, whether you kindly confirm this thing. But my case is, this alert, this system has never come down when I have put that figure. My lord, thereafter, my lord, the tender committee is also considering in the same paragraph, in spite of warning message, Techno E-Mines, that petitioner didn't cancel the bid amount and accepted the bid as 2 CR by signing digitally. TC is of the opinion that the bidder has submitted the auction bid consciously after getting due alert signal from MSTC during e-auction and thereafter tried to withdraw the bid. That is their case, my lord. Now, my lord, I, being one of the participants in the tender process, I am not privy. I am saying my case is that pop-up or the alert message
Correct. Your conscious that mistake.
that was never displayed. So what I am on, my lord, right now, at least the logbook which I have asked for, particularly from MSTC, my lord, that the logbook may be supplied, which will give a clear picture as to whether the alert has been shown or not. If the alert has been shown, if the MSTC can satisfy this honorable court that the alert has been shown and there is a case that despite having proper knowledge, I went and considered and participated in the bid and give the amount.
Sir, whether that can be in the writ proceeding or you go.
My lord, to that, my lord,
to the civil court, claim
my lord,
the amount.
my lord, to that, my lord, I am relying on a recent judgment of Supreme Court, my lord. It's 2024. 15 SCC, my lord. I'm handing over a copy. It's a bit lengthy one. This covers my entire case, my lord. My lord, this judgment, my lord, precisely talks about 4 different components. First is regarding maintainability of the writ petition, which my learned friend as of now has not raised. If it has fallen from your lordship, whether writ court can enter upon such kind of a dispute, I'll appraise your lordship. For in this regard, my lord, paragraph 41 onwards of this particular judgment, my lord. My lord, prior to your lordship moving to 41, my lord, if your lordship be pleased to come the issues which have been framed by the Supreme Court, my lord, which is at page 489 of the judgment. Yes. Under the paragraph F, my lord. Points for determination under paragraph 34. 34.1. What is the scope of judicial review of the state action of the state in the matters relating to contract tender dispute under its jurisdiction? So 34, page 489. Thereafter 34.2, whether the action on the part of the respondent hearing cancelling the tender, vide its noted dated such and such, was amenable to the writ jurisdiction of the High Court. If so, whether the said action could be termed to be as arbitrary or unfair and in consequence of violation of Article 14. My lord, to that effect, my lord, it starts on page 40, paragraph 41, my lord. My lord, 41 onwards, the Supreme Court has considered the evaluation of the law since 1970, and when for the first time the Supreme Court has intervened in a writ jurisdiction in relation to a matter of a contract or a tender, because prior to 1991 ABL International, your lordship is aware of that the writ court was not reluctant to enter into a merits of the writ matter so far as contractual disputes are concerned. The 1991 onwards, the scenario started changing, and my lord, if your lordship be pleased to come to directly paragraph 57, my lord. My lord, rather 56. The law on the subject, my lord, this is at page 500, my lord.
Yes.
The law on the subject with which we are dealing was laid down exhaustively by the court in its decision in Joshi Technologies versus Union of India, and the position was summarized as under. The position thus stood summarized, my lord, 69.1. The court may not examine the issue unless the action has public law character attached to it. Whenever a particular mode of settlement of dispute is provided in the contract, High Court would refuse to exercise its discretion under 226 and relegate the party to the said mode of settlement, particularly when the settlement of disputes is to be resorted. Over here, my lord, there is no alternative dispute resolution clause, no mechanism for me to going and agitate my grievances in some other forum.
No, that is correct. See, with regard to the tender, yes, if there is an arbitrary, whatever, that is not dispute that the tender, writ petition cannot be maintainable with regard to tender matter. Every day tender matters are coming and we are deciding this. Now here only the question that there is no dispute with regard to you have deposited the quoted of 20 crore.
2 crores, my lord.
Correct. Now, subsequently, when you came to know there was a mistake, immediately you have made a request, but that has not been considered and it was recalled and EMD has been forfeited. Only 2 tenders were there, so that's why only 1 tender was there. And you have withdrawn that. That's why you are the highest bidder as per the 2 crore you have quoted, but subsequently you have withdrawn. Your EMD has been forfeited. Correct. Now, your only the question is that with regard to this third criteria, at the time of quoting the amount, there will be a reflection in
an alert message.
So if you are giving the 5 times more, then will be a 3 times there was a pop-up and you have to take care of it. In spite of ignoring that, you have deposited the amount that is intentionally you have paid the 5 times more than the tender amount. That is the case they have made out. Now you are telling that the pop-up with regard to MCTC, whatever it may be,
MSTC.
has to bring the record to show whether that on that day it was working or not. Whether that can be done in the writ proceedings by calling the evidence.
My lord, from this judgment itself, my lord.
Yes, show me that the writ court can call
My
the
lord,
evidence.
paragraph 80, page 513, my lord, prior to that. Paragraph 80 at page 513, my lord. My lord, prior to moving or quoting paragraph 80, my lord, if I, with the deepest of respect, my lord, the first thing, I have never withdrawn the bid, my lord. The second is, my lord, even, my lord, let me place this case and it will be easier for me, my lord. My lord, it talks about scrutiny of internal file notings and deliberations of the state. So under what circumstances an internal noting of an authority can be scrutinized by the writ court, my lord? In this regard, paragraph 81, this court in its decision in Bachittar Singh versus State of Punjab held that merely because something was written in the internal files and note sheet does not amount to an order. It at best is an expression of opinion which may be changed, and it only becomes an order when such opinion is formally made into a decision. The relevant observation read as under. Thereafter, the judgment was quoted, my lord. Similarly, my lord, in paragraph 82, in SETI Auto Service Station, this court held that notings in a departmental file are nothing more than an opinion by an officer for internal use and consider of other officials for the final decision making. The relevant observation read as under. It is tried to state that nothing in the department file do not have the sanction of law to be an effective order. A noting by an officer is an expression of his viewpoint on the subject. It is no more than an opinion by an officer for internal use and consideration of the other officials of the department and for the benefit of the final decision making authority. Needless.
That is correct, but here the order has been communicated to you.
My lord, order has been communicated. I join issue.
It is not that they are harping upon the official note.
My lord, I join issue on the fact because tender committee has relied upon the version of MSTC to the saying that a alert or pop-up message was displayed. I choose to ignore and went on participating in the bid, my lord. My lord, with deepest of respect, my lord, if I may humbly submit this, my lord, this cannot be the stand of MSTC, cannot be treated to be a gospel truth before this court until unless MSTC is directed to come up with that logbook. At least give me a copy because it's my tender, it's my EMD which has forfeited at the behest of MSTC.
My lord, if I may, I appear for MSTC, lordship.
You are appearing.
My lord,
yes.
Just one thing, sir, my learned friend.
You file the affidavit stating that.
My lord,
kindly supply his logbook, my lord. That will clarify the picture.
It is not about the logbook, my lord. There are not. This is the pop-up message is not the only check. After they put in the amount in figures, they have to put it in words. So if they put an extra zero, they have to confirm by writing 2 crores. So that they have written it, and that is why they had to go for okay.
Okay, you do one thing. You file a short report giving the total document stating that this he has given the, if he has mentioned the wording also, the question of stating that 10 has been put extra does not arise.
He has to mention it by word. I had submitted the screenshots before the court.
Correct. You give a short affidavit on that day.
And lordship, just one more point. In our, this pop-up will come up in their system.
Correct.
In page 154, our email is there, wherein we immediately wrote to them, saying that kindly furnish us proof. Page 154, lordship. I'll just read it out, lordship. Page 154.
I want to place that.
Yes.
You are requested, this we are writing, Lordship. Sir, you are requested to share screenshots, documentary evidence towards your claim of error message not being displayed. This was never given to us. Till now, there is no screenshot on record from their end saying that no pop-up message was displayed. Not a single screenshot, Lordship. Because this pop-up error message will come up in their system, not ours. So that is why we had asked them for screenshots to prove their case. My lord, I'm covered by judgments also, which I can place those judgments. My learned friend has shown a 2024. I can show a 2025 Supreme Court judgment, Lordship. And my lord, one more point, Lordship, the judgment which my learned friend has shown is not on errors. It's on a totally different point.
No.
My lord, we are showing judgments on errors, on the factual background.
Where in the writ petition you showed that there is no pop-up message has been displayed in your system?
My lord, page.
Which paragraph?
My lord, page
My lord, page 153, my lord.
No, that is your I am averment in the petition. Where you have averred that pop-up has not been come to your screenshot.
My lord, paragraph 10 in my writ petition, and my lord, supported by
paragraph 10.
Paragraph 10 in my writ petition, my lord.
Last.
In case of abnormal price bid to transfer, the author has been quoting the price 1 rupees. You have not stated that. Inadvertently, mistake could not be noticed since the portal did not send the alert by pop-up offer. By way of pop-up.
My lord, the basis, the fulcrum of this statement is incorrect because
In respect of the land and others, bidders are putting such amount, other bidder goes.
Correct.
Similarly, application is there, other application
Yes.
also there. These are happening nowadays.
My lord,
Why
page,
not bidders?
page 2 of the judgment
Lord,
we
a
have shown.
land which has been put to lease for a yearly rent of 17 lakhs, my lord.
Somebody in occupation.
With deepest of respect, my lord, it will be an act of absurdity.
Yes.
Against 17 lakhs, I went on putting 2 CR just to thrash away some other bidders. And in this particular,
Can you see that one exactly?
my lord,
Line by line.
my lord,
Case order.
And my lord, this pop-up message is not just the only check. That is my submission. And we have written another email saying that we are a government company. We are audited time and again. Our systems are audited. My lord will find that in page 155 of the writ petition. We have written
Okay. Anything further?
my lord, two more things, my lord. Page 52, it's part of the NIT, my lord. The notice inviting tender. It talks about selection from drop menu under capital B. In either case, has your lordship found it?
Yes.
In either case, whether for remitting tender fee or EMD, the bidder shall click next button. The pop-up verification page will come up, which will ask for confirmation from the bidder on the
52 which clause?
My lord, under clause 3, selection from drop-down menu, under clause 3, capital B, my lord.
Yes.
My lord, it talks about the modalities.
If the bidder select tender fee amount of
No, my lord, immediate thereof, that your lordship was possibly looking at Roman C. My lord, capital B.
Capital B.
Capital B. In either case, whether for remittance, tender fee, or EMD, the bidder shall click on next button. Then a pop-up verification page will come up, which will ask for confirmation from the bidder on the correctness details ready entered by him in the above 2A, 2B, 2C, B2. If the bidder finds an error, he shall opt for back button to get back on the previous page for making necessary corrections. If the bidder finds the details to be correct, he or she will click on I confirm button. The bidder will then directed to the next page. This is the modalities as per the tender document, my lord. But my lord, what they are harping upon and what the report of the tender committee, the minutes of the tender committee reflects, it talks about a pop-up, about a alert being created, my lord. So there is a distinction. They are deviating from the own stand, my lord.
Now, this is the process they have.
This is the process, my lord. I am on that.
If I just may place just one thing, this is not the process for submitting bids. My lord, kindly sees what it is. In either case, whether for remitting tender fee or EMD, this is not for bids. This is for tender fee or EMD. This is not applicable to it.
In that event, my lord, with deepest of respect, if I may allow to say this, my lord.
Yes, this is
my lord,
different.
MST do not have a vested interest so far my EMD goes, EMD stays or EMD comebacks, my lord. My lord, it's only the port authority which is concerned. They are only concerned being a state, my lord. The port authority being a state, they should be only concerned about whether any financial losses are incurring at my dictates or not, my lord. If that be the situation, my lord, only a small affidavit or a small report be called for, if your lordship, to supply the logbook, because if
Logbook, what logbook? It is already cleared.
my lord,
It is you
my
to
lord,
prove.
it's my lord, I cannot,
In your script,
my lord, they are the one who are operating this entire website, who are operating or conducting this entire process of auction, my lord. My lord, I cannot. They are asking me for strict proof, my lord. When at the time of participating in the tender process, my lord, it is not humanly possible for me to take a screenshot because even I am not aware of this pop-up message will display.
Okay.
My lord, I have only come. My lord, kindly appreciate their documents. That's the tender committee meeting. That is the sole thing which they have relied upon. My lord, only a affidavit at.
This is just browbeating a government company.
What the case will change?
My lord, page
in form of an
157.
affidavit.
Concluded CAV.
Lord,
My lord, kindly appreciate, my lord.
Next.
I have put a respondent, but this was.
I appear for the petitioner. But I will recall this is relating to that challenge to a tender where my proprietary drawings were being used. On the last occasion, the railway sought time to take clear instructions.
Yes.
They said they would discharge. Yes.
This is the instruction. May I hand up copy, Malad?
Malad, apart from, Malad, may we get a copy as well? Huh? Sir, I have to copy.
Which is a.
ঠিক আছে। না না
Yes.
Yes. Malad, I don't know what instructions have been handed over. Copy. Malad, if those two tenders, Malad, of May and September, they've been discharged. Now I have one further relief in the writ petition. This can be recorded and those prayers become infructuous. Malad, our grievance has been resolved. Now Malad will kindly take my writ petition. One last prayer, Malad, we have. Prayer E of my writ petition, Malad, page 32. Yes. Yes. Malad, page 32 if Malad has. Malad, our primary grievance in the writ petition which Mr. Banerjee was addressing, Malad, here. Malad, here was that there was an RDSO approved drawing. That is my drawing. That was on the basis of dual gauge turnouts which contained a certain type of crossing. which I use. That's a heat-treated welded crossings. Admittedly, in their affidavit in opposition as well, which has been filed, they take a stand that we have admittedly changed that specification to a different specification for the same subject matter. The subject matter tender remains the same, but they've changed the specification only for the purpose they only avert to only one instruction of the RDA. So on the basis of which this change has been made from heat treated welded to CMS crossing. No,
Technical,
may I come? I did not interrupt. Malad, this is the prime.
The humble understand this is nothing but arm twisting.
May I try to?
Whatever has been trying to place before your lordship.
If my learned friend is done. My grievance in the writ petition is not simplicity the use of my proprietary drawings. That's a part of it, undoubtedly. Apart from that,
If you want to argue the matter, then I
Yes,
pass an order, file the affidavit in opposition.
affidavits are
You withdraw
exchanged.
the discharge.
Yes, my lord.
You withdraw the discharge.
My lord.
If they are not accepting the discharge, you withdraw the discharge, you continue with
my
the
lord.
tender process with their drawing.
My lord.
With their drawing,
My lord,
and
will
the
kind-
fine affidavit.
kindly do not take me amiss. My lord.
Not
My
to
lord,
play with the court.
I'm not playing with. My lord, will kindly.
One day you are making some submission,
No,
but
no.
the authority has come with a
Yes, my lord.
positive result. Now you are coming with the another relief.
My lord, I
On
apologize.
that day, you are not mentioned that you take the decision on this. Now they have taken the decision for discharge of both the tender. Now you have taken the new point.
It's not, my lord. I apologize. It's my fault, my lord. May I just?
So I am not accepting this. I will allow the authority to
only-
continue with the
My lord, will kindly grant
Kindly not take it amiss, my lord will kindly not take us.
changing the advocate will change the relief. The respondent authorities have already given taken the instruction and filed the instruction in writing, wherein it is mentioned that to avoid any ambiguity.
I apologize, my lord will kindly not take us. My lord will kindly not take us. My lord will give us 1 minute subject to my lord.
What 1 minute? Further what? Since beginning, Mr. Banerjee is arguing that the authority are using your drawing, you issued, they have issued the tender by using your drawing. Now they have withdrawn discharged their tender, in which their drawing has been used. Now what remains further? Whether the court can pass permanent injunction in the writ petition. If you want a permanent injunction, you go to the suit and file a permanent injunction. Yes. In future, anticipation, how the court can pass an order, madam? You are the senior most of the member. You are the senior. In the writ petition, in the anticipation, the court can pass any order. You have taken the point, but since beginning, you are only concerned with concentration with regard to using of your drawing by the authority in their tender document. So that this court satisfied that, pass an order of injunction and directed the authorities to file the report. Now they have filed the report. Yes, due to some to future any ambiguity, they will not continue with the tender process. That purpose would be served. What purpose remain? Can in the anticipation in the writ court with the permanent injunction can be passed, restraining the authority not to use your drawing. If you are having any anticipation, you go to the civil court and get the order of injunction there.
If my learned friend does something like that.
Well, that the writ court will not.
The respondents have filed a report stating that to avoid any ambiguity or future contractual complications, the railway administration has decided to discharge both the tenders being NIT numbers 612454771C and 612454449B. Full stop. Considering the instruction, considering the decision taken by the authority, this court find that the authorities have already discharged both the NITs. Thus, there is nothing remains in the present writ application. The writ nothing remains in the present writ application. Full stop. Learned counsel for the petitioners submit that they have apprehension that in future also the authority can use the drawing of the petitioner in the future tender.
They have not even participated in the tender, my lord. But they endless praise them.
Drawing
And the item which the petitions of have been. My lord, object to that, it is not a deliberation, my lord.
and I am not,
Very well.
only their submission has been
Very
recorded. And the item which have been, the petition has been, where you mention that? Where you mention it?
Yes.
Yeah, counsel for the counsel for the petition submit that in future the respondent shall not use the drawing of the petitioner and not to include the not to include your not to exclude the component type heat treated welded within bracket HTW crossing in any tender. Full stop. This court find that in this the petition has filed the present its application challenging the tender issued by the authorities, and now the authorities have withdrawn this tender. The apprehension of the petitioner cannot be decided in the present writ application. Accordingly, the writ petition is withdrawn. As the authorities have withdrawn the tender, discharged both the tender, and thus this court has no opportunity to go into the merit of the case.
So detailed.
But I understand their Indian matter that okay.
कल ना 32 आर्टिकल नंबर 32 कल जो है adjourn मोशन में टॉप में रखो।
Yes.
By the resolution number 7. Said that the conduct of the PSI is over validity of sector 89 of the Act, and we need to support the commission when on the previous time has already submitted to number of reasons. But after reviewing the started another, came to the conclusion that yes, my knowledge then after the PSI is regulating and yet we like to work against according to mother. We saw the notice to the response number 7.
Yes, yes. Yes.
Non-compliant, you are compliant. If you get to compliant, requirements and submit compliant because of it, it's all the evidence. Action taken in the matter by you. In case of non-sufficient, your unsatisfactory. Your license may be suspended under section 30. State if you operate some regulators. The act made after giving the concert operator are reasonable opportunity because suspend any license from all working of the activities for which license has been granted under this chapter after recording of re-treatment of uses for the suspension. If there is that the operator has failed to comply with the condition, it is the intention not under section 32. And after failing to judge now we have to carry it of section 9. Now the PSI is undertaking makers to take steps during the meeting for the meeting that and trademark used by the operator. Whether we use non-compliant of the commissions of at the level.
So as per your submission, you have already taken a step so that that brand cannot be used. So what I propose, they have given the time, so I am fixing on the next last week of January. In the meantime, they will take if they have consider. Otherwise, we'll see to that. So that will be better because 15 days time. 15 days, then opportunity of hearing and all this. Correct. That's what I am fixing. Okay. So I am fixing on 27 January, and you file the report on that day. What steps has been taken on this? Whether any steps has been taken, you file the report. Further report. The learned counsel appearing for the response number. You are for the 5 and 6 has submitted a report informing that the central licensing authority has already taken appropriate steps for desist from using this brand name and the pictorial representation which mislead the consumers. Full stop. As the authority has already taken any steps accordingly, for the time being the case is adjourned. Let the matter appear on 27th of January 2026 for filing a report by the respondent number 4 and 5. Take your 5 and 6. 5 and 6. 5 and 6. The report submitted by the respondent number 4 and 5 and 6 we kept in the record. Take what further, whether it has been deleted or not, whatever it is, then the repetition can be. Correct. No, you have issued the notice. The notice be kept in the record and not report. Need to notice issued for improvement notice dated 15 December 2020. Thank you. But attack kori dena. Yes.
But even my client is there, and the other brother is also here.
She is present in person.
Yes.
Where is she? क्या नाम है माता जी आपका? हिंदी जानती है? हिंदी जानती है
आप हिंदी
पूछ रहे हो के नाम?
हिंदी
हिंदी जानती हैं आप?
हाँ हिंदी जानती हूँ।
क्या 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 है आपका? क्या बोलना क्या है? बोलिए।
हमको ये बोलना है कि हमको बच्चा लोग ने घर से निकाल दिया
हाँ।
और पहले भी मेरे में हो चुका है, तो मेरे को राय चाहिए कि ये लोग मेरे साथ ऐसा क्यों करते हैं। ये बोलते हैं कि मैं आ जाओ, मैं तेरे को अच्छा से रखूंगा, तो मेरे को क्या विश्वास होगा कि मैं इनके पास रह जाऊं? मैं वहां पर रहना नहीं चाहती हूँ।
आप वो नहीं रहना चाहती?
हाँ।
फिर अगर वो खाली क्यों, आप जो कोर्ट से जो है अथॉरिटी से ऑर्डर लिया उनको खाली कराने के लिए, फिर क्या होगा? अगर वो खाली भी कर देंगे, आप वहाँ नहीं रहेंगे, उनका बिजनेस नहीं रहेगा, फिर कैसे हो चलेगा?
भाड़ा दे दूंगी मैं, मेरे को तो बेटी को फिर मिलेगा, मेरे से तो होगा नहीं। देखिए
अगर आप मेरा बात अगर सुनेंगे तो मैं एक सजेशन देता हूँ। ये जरूरी नहीं है कि आप उसको एक्सेप्ट करें। मेरा सजेशन है कि वो जो घर है उसमें रूम है आपका, पहले तो वहाँ रहती थी ना आप?
हाँ, वहाँ तो खाली रूम ही है और तो मेरे किचन को बाथरूम मेरे पास है नहीं, तो
ठीक है मैं बताता हूँ। अगर आप
उसमें जाने नहीं देते हैं, ताला बंद कर देते हैं।
ठीक है मैं बोलता हूँ, अगर रूम है आपका, किचन टॉयलेट आपका पूरा फैसिलिटीज का साथ अगर आपका बंदोबस्त करते हैं आपको रहने के लिए, ठीक है, प्लस वो महीना का जो आपका मेंटेनेंस है, जो भी है पैसा है, ऑर्डर है, वो आपको देंगे, तो आपको कोई प्रॉब्लम है? और हम केस डिस्पोज अप नहीं करेंगे, हम इसको 3-4 महीना के लिए पेंडिंग रखेंगे। हम उनको डायरेक्शन देंगे कि जो है आपको रहने लायक का घर, रूम जो है, किचन आपका जो भी है, वॉशरूम वगैरह बना के आपका रहने के लिए, आप वहाँ आइए, रहिए।
मैं नहीं रह सकती मैं।
नहीं मैं बोलता हूँ तो 3 महीने तक इसको रखूंगा, फिर आप बोलेंगे आप सेटिस्फाइड है, हाँ उन लोग तंग नहीं करते रहते, फिर मैं डिस्पोज अप करूंगा। अगर आप बोलते हैं नहीं है तो फिर आपका क्या सजेशन है, फिर आप बोलिए, उस हिसाब से मैं सोचता हूँ अगर कर सकता है तो। क्योंकि देखिए फैमिली मैटर्स है, माँ बेटों का आपस का अच्छा नहीं लगता कोर्ट में। अभी हम यहाँ कोर्ट करेंगे, फिर आगे जाएंगे, सुप्रीम कोर्ट जाएंगे, अच्छा नहीं लगता ना। ये हम बेटा माँ लड़ रहे हैं, अच्छा नहीं। इसीलिए आप सोचिए आपको आप क्या चाहती है, क्योंकि आप तो जो केस डाली थी मजिस्ट्रेट साहब के सामने, उसमें खाली करने के लिए और अपना मेंटेनेंस के लिए डाली थी। मजिस्ट्रेट साहब ने तो ऑर्डर कर दिया, ठीक है उन लोग खाली करेंगे, जब तक खाली नहीं करेंगे पैसा देने के लिए। अगर वो आप बोलते आप वहां नहीं रहेंगे, अगर समझ लीजिए वो खाली भी कर देंगे, उनका तो बिजनेस चल रहा है, ठीक है?
तो ठीक है, मेरे को भाड़ा दे दो।
वही तो आप बोलिए, इसीलिए आपका क्या बोलना है, आप क्या चाहती है वो बोलिए, फिर मैं उनसे बात करूंगा, हिसाब से फिर मैं कोर्ट में वो हिसाब से आप क्या क्या चाहते हैं, आपका क्या डिमांड है वो बताइए।
मेरे को ये चाहते, मेरे को खर्चा मिलना चाहिए,
ठीक है,
मेरा दवाई पानी का और सब खर्चा मेरे को मिलना चाहिए।
आप कितना खर्चा एक्सपेक्ट करती है, आप कितना खर्चा महीना का आपको कितना चाहिए वो बोलिए।
50,000।
50,000 तो हमारा भी खर्चा नहीं होता, अब सोच समझ
दवाई दवाई पानी
दवाई
खर्चा
वगैरह वो दवाई वगैरह का तो होगा, वो तो बेटे हैं उनको करना है, और आपको अच्छे से रहना है उनके लिए भी करना है। एक आप नॉमिनल जो आपका खर्चा बताइए, जो जो दवाई वगैरह का है, और पर्ची आप दीजिए, उन लोग ला के देंगे और पैसा उन लोग बेयर करेंगे, वो बेयर करेंगे। और पैसा दवाई का आपका जो है मेडिकल का, वो चिंता मत करिए, मैं कोर्ट से ऑर्डर कर दूंगा, वो उन लोग को करना है। रहने का आपका जो खाने पीने का मेंटेनेंस का आप कितना, और वो घर जो है उन लोग आपका रहने लायक बना के देंगे, और वो आपको तंग नहीं करेंगे, ये मैं इतना कर सकता हूँ, आप सोचिए।
तो नहीं हो इतना, नहीं तो मेरा खर्चा बंदवाइए।
हाँ
नहीं हो ये तो मामूली काम नहीं है बंदोबस्त करना, तो इतना दिन तो मेरा खर्चा बंदवाइए।
वही तो आप बोले कितना खर्चा, देखिए 50,000 तो बहुत ज्यादा है।
5,000 कम कर दीजिए।
What I have seen the breakup a lot. What he says is that she cannot be a liability on a nephew and niece for all time. So naturally she needs a maid. And this is the breakup that was given to me. I'm handing over a copy. She has been living till now in the house of her siblings. No rented apartment.
I think this is more than what she had prayed for in the.
She had prayed for 30,000
See,
plus medical.
So with regard to the bedroom and bathroom, so if they will provide, she will come here. She will come here and reside in the house, because her main prayer is that she may be allowed to reside in the house. Her prayer before the magistrate, before the authority, it is she want the house because the sons have captured the house. She have been ousted. So now the court has passed the authority has passed an order for eviction. So now the one son is running the business in the ground floor.
It has been rented out. It's not a business it's a rented go down. He's getting rent from it.
Okay, whatever it may be. One floor is, if they will provide the house and it's a suitable house, so can she reside here?
आप मतलब खड़गपुर में मिदनापुर में रह जाएंगे, मिदनापुर में रह पाएंगे? He says she does not feel secure staying in the house in Midnapur unless it is vacated. The option is to stay in Orissa. She prefers that.
See, this is a third floor building,
three-storied building. Yes.
Ground floor is rented out for the business purpose, whatever it is. This first floor, who is residing?
My client is residing.
And
Lord, she was residing with my client in that particular floor.
Okay. So there is a room and attached bathroom and all.
No attached bathroom, and even the washroom was locked.
Okay, they will provide. If the court will pass
The only
limitation of the building was
the washroom was locked, and she had to bathe even in winters on the terrace.
Okay, court will pass an order. She should get all the amenities in the room, which will be provided by the sons. So she cannot be debarred from any of the facilities. And with regard the maid, okay, maid 10,000. I don't think the fooding and maintenance they will give. Both the sons will give the 25,000, no problem. And medicines already, whatever the medicine, they will give the prescription, they will purchase and give to the mother.
Yes.
25,000 maintenance for residence.
The client, the medicine cost is not that much.
Correct. That's it.
Manad, what has been narrated in the writ petition is a story. Manad, she feels insecure.
I am not going into any of the allegations either in the writ petition or affidavit, whatever it is.
She does not get the security, Manad. That feeling is there that she'll be maltreated again.
So I will pass an order. If she will be, the police station is there. They will look after this. If any misbehavior be done by the mother.
Not only misbehavior, even humiliation. Just like a ping pong ball, she was.
So that she don't want to reside in the house.
घर में रहने चाहेंगे मिदनापुर में?
आप वो रहने आपका जो
है अपना घर है, हाँ उधर रहने चाहेंगे? Such is the animosity amongst the parties that this is the condition.
तो आप कहाँ रहना चाहती हैं? हाँ?
But this is the entire thing. She has now spoken the mind, and this is the gist of the matter.
That is the gist of the matter exactly. Why is this so?
And Lord,
भटक में कहाँ रहती है? किसके बेटी के पास रहती है?
with the sister.
बहन के पास।
आप अपने बहन के पास रहती
हाँ।
है? बहन का अपना घर है?
हाँ।
सिस्टर, आपका सिस्टर का घर है?
हाँ।
अच्छा, तो वहां में फिर आपका खाना खर्चा और जो सर्वेंट का खर्चा चाहिए,
हाँ।
उसके लिए 50,000 चाहिए आपका, तो वो तो आपका अपना।
No, that included the first item, 15,000 for that rented apartment.
हाँ।
If she is to stay on with her siblings, naturally that is not required. But the brother did not have the space, so she could not stay in her brother's house. Only the one of her sisters, Malad, in Cuttack, had that space to accommodate her.
तो ठीक है, तो 15,000 is to be minus, deleted, then 10, 15 and 25,000.
That is what she is getting as of now. My client
25,000 is what she is
for the
getting, and she had asked for 30,000 for plus medical. That was what she had asked for.
Okay, 30,000.
That was the prayer before the learned tribunal, and the tribunal, instead of granting that, asked them to vacate.
That is the bone of contention.
If she is not interested to reside in the house, question of vacating.
It is not a question, my lord, with the utmost humility I say so, of her interest, of her choice. Circumstances have led her to believe that she will.
That's why he called her. See, we cannot say the son go out, mother come in. There is a triple.
That cannot never be an ultimate solution.
It's a solution. Correct. That's why he called her. If she wanted to reside in the house of her husband, the court may pass an order so that both the sons can make a proper arrangement for her residence in the house itself. House itself.
अगर बेटा लोग आपके लिए इंतजाम करता है एक तो फ्लोर में अलग से,
तो करने के लिए उतना दिन तो
हाँ नेचुरली,
हाँ इतना दिन तो खर्चा बनवाइए।
वो तो जैसा आप देंगे ही। अगर एक तो फ्लोर में आपके लिए सेपरेट किचन बाथरूम रूम वो इंतजाम होता, उसमें 2 महीना लगेगा हो सकता। My lord is understanding what is playing through.
आप सुनिए, अगर आप बोलेंगे कि आप यहाँ पे ये वाले घर में रहेंगे, ठीक है, तो मैं एक स्पेशल ऑफिसर अपॉइंट करूंगा। आप पहले बताएंगे आपको कितना, एक रूम बैठक चाहिए, आपको बेडरूम चाहिए, किचन और टॉयलेट चाहिए, ठीक है ना? ये तो चाहिए आपको, एक बैठक रूम चाहिए, आपको एक बेडरूम चाहिए, किचन और टॉयलेट चाहिए। वो हिसाब से मैं एक ऑफिसर अपॉइंट करूंगा, इन लोग दोनों को बोलेंगे प्रोविजन कर दीजिए आपके लिए। अगर वो प्रोविजन करते हैं तो आप वहाँ रहेंगे, तो आप वहाँ रहिए, प्लस मेंटेनेंस जो भी है 25,000 रुपया 20,000 रुपया जो भी है मेंटेनेंस आपको देंगे, प्लस जो मेंटेनेंस का जो आपका बिल का खर्चा, मेडिकल का खर्चा, वो आप बिल दे दीजिए, आपका बेटा लाके दवाई आपको दे देगा। बेटे तो यही है, कोई प्रॉब्लम नहीं।
That is as a trial, my lord, this will be
Correct.
What falls from. हाँ वो तो देंगे, हाँ उसीलिए तो पैसा बढ़ा रही है।
तो बोल रहा हूँ ना, ठीक है, आपको तो एक घर में काम करने वाली चाहिए है, उसका जो तनख्वाह सब मिला के जो मैं देखूंगा, उनसे भी बात कर लूंगा। ये पहले आप बताइए, अपना सजेशन बताइए, फिर मैं उनसे बात करूंगा।
अगर अलग से इंतजाम होता ऑन द फर्स्ट फ्लोर,
आपके पास 2 ऑप्शन है। आप बोलती है आप ये वाले घर में नहीं रहेंगे, आप अपनी बहन के पास रहेंगे, तो फिर आप अगर बहन के पास भी रहेंगे तो फिर आपको जो रहने वाला खर्चा, तो किराया जो 15,000 रुपया मिले वो तो आप नहीं ले सकती हैं। बहन के रहेंगे, फिर आपका जो मंथली खर्चा है वो आपको हम कोर्ट बोल देंगे, इन लोग देंगे। अगर आप बोलेंगे नहीं हम यहाँ रहता है, फिर वो आपको हिसाब से रहने का आप कैसा चाहिए, वो आप स्पेशल ऑफिसर में अपॉइंट करूंगा, आपके साथ जाएंगे, आपके बेटे जाएंगे, आप बताएंगे, उस हिसाब से उनसे पूछेंगे, अगर देने सकते हैं तो आपको रखेंगे, प्लस आपको जो मेंटेनेंस जो है आपका खाने पीने का, आपको जो है मेड सर्वेंट का और दवाई जो है, दोनों बच्चे को आप बिल दे दीजिए, उन लोग जो है खरीद के दे देंगे। दोनों ऊपर नीचे रहते हैं, कोई दूर तो नहीं है।
नहीं, उसके लिए तो उसके लिए आपको प्रोडक्शन मिलेगा।
अम्मा जी ये जो पुराना बात हो गया, पुराना बात ठीक है, मुझे इसीलिए मैंने कहा जो पुराना बात हो गया, आप उसको लेके चलेंगे तो आप कभी सेटलमेंट नहीं होगा। पुराना बात हो गया, खत्म करिए। आप सोचिए, आप अपना हिसाब से अपने बच्चों का साथ एक अपना लाइफ बिताना चाहती है, ये नहीं बोलते कि आप उनको देखा वाली। ठीक, अभी आप क्या बोलती है, या तो सोच क्या, आप क्या सोच के, या तो सोच के आएंगे, बोलो सोच के आएंगे। आप अगर आप बहन का यहाँ रहना, आप एक बात बताइए, उस हिसाब से मैं केस डिस्पोज ऑफ करूंगा। मैं ये नहीं चाहता हूँ कि आपका फैमिली डिस्प्यूट पूरा सालों साल चलता रहे। आपका एज इतना हो गया।
My lord will kindly pass this matter over. My lord, I'll speak to her. I'll speak to her and persuade her, whichever she prefers. I'll convey to my lord.
Yes.
Kindly passes it over for the next matter, my lord, instead of wasting my lord's time.
Okay, I will take it 245.
We'll come back to my lord.
245. Sit together and
Yes.
pass over. Yes, call the matter.
I appear for the respondents, my lord.
Lord, I appear for the respondent number 5, my lord, in item 21.
Petition.
Yes.
My lordship, here is for the unreasonable, unfair and arbitrary decision of the respondent in cancelling and terminating my tender.
Your tender is cancelled.
Yes. And
When?
They have sent a letter.
Where is the cancellation order?
It's on CAN 1.
Can আছে কি?
Yes.
दादा can আছে?
Yes.
नहीं आया.
My
Can
lord,
is
my lord, we have not been served with a copy of any CAN application, my lord.
We have served, my lord.
It is served.
Affidavit service.
Lordship, in this matter, I appear for respondent number 4, my lord.
You are appearing for?
Respondent number 124, my lord.
And I am for the respondent number 5.
Okay. So you have not received the CAN?
No, my lord.
But the affidavit of service shows that it delivered. It is delivered on 28th October, 30th October. But CAN is not here. CAN is not here, sir. CAN has not come.
Here is the one CAN application, but I don't have.
You have a copy?
Yes, my lord, but this is the only copy I have.
Can you have
So what you want?
My lord, to cancel the, to squash the order of the termination they have passed. Because it is totally arbitrary and unjustified. When
But a work order is issued.
Uh,
Work order is issued.
Yes, my lord. Yeah, we are working and.
No. You are working. You are during the pendency of the work order was cancelled.
My lord, no. From the day one, we have been we have given a work order. We are been working. After they have given a so-called notice, and there is a in the contract itself there is no clause of termination. Only penalty charges they can claim, but they have arbitrarily cancelled the.
So there is no arbitration clause in the agreement.
No.
There is no arbitration.
There is they have unreasonably cancelled the agreement without there is any clause in the tender. And
Clauses are there.
no, they can show
This there.
and there is a penalty charges for any kind of discrepancy. But
Who has cancelled?
they have cancelled.
Respondent number?
Respondent number
5, my lord.
5.
It has been cancelled by respondent number.
Respondent number 5.
Respondent number 4.
4. Continental Marine Department.
And it has been pursued by respondent number 5.
Respondent number 5 is the
Government e-marketplace, my lord.
How they can pursue?
The respondent number 4 has cancelled.
What was the tender? What is the nature of the work?
The nature of the work is to supply manpower. And my lord, the manpower is still working over there. Then how, if the manpower is still working in the place, then how can the tender get cancelled?
Whose man? Your man's.
The same man which I have supplied at day one.
They might have been engaged by the other contractor.
I have, my lord, I have already applied that I want to change the work order, change the manpower, but they haven't replied to that.
That's why your workmen have been utilized by the other work.
Yes, my lord, they are putting some allegation which is in collusion with the
then it's a required report.
Yes, my lord, it's up.
Or affidavit. Let them file the affidavit.
Yes, my lord, yeah. And my lord, till then, my lord, kindly give a stay to the.
No.
I am
but-
giving short time. This court find that the writ petition is to be disposed of only after exchange of affidavit. Accordingly, the respondents are directed to file their affidavit in opposition by 8th of January 2026. Reply, if any, by 16th of January 2026. List the matter on 20th January 2026.
My lord, after that, I have asked for payment and they have replied the cancellation. And when I ask the queries, then these two things cannot go simultaneously. One is security with us. The second is the manpower.
Forfeiture.
No, security is with them, and the manpower is working at the office. Then how can the tender get cancelled? They
Okay.
haven't-
Now you come with a reply. Yes, next.
Grateful, my lord.
So this is the matter according to which I was directed to take instruction in connection with registration of a marriage under the Hindu Marriage Act, not by the DSR 2, pursuant to your lordship's order, my lord, on 8th of December, this communication was sent from the department, from the Register General of Marriage to, my lord, the district sub-register 1 at Alipur. And today in the morning, I have received a telephone instruction that, my lord, today training is being conducted so that this marriage part is being done. And, my lord, it is expected that after this training, if the petitioner applies online, his marriage will be registered. Since till date in Chetla, there is no official Hindu marriage officer. This is the communication.
But
on
here
8th
the problem is that the one is the foreign national. No.
Both are Indian national, but
Both
No marriage officer is posted in.
Hindu marriage officer. They require a Hindu marriage
Hindu
officer.
marriage
So, my lord, after this communication sent on 8th of December, today I have been told that today only training is being conducted to the
So
DSR 1.
So I am fixing a matter.
My lord, after 4 weeks. So in the meantime, my lord, kindly
No,
direct.
I am fixing not 4 weeks. I am fixing on 13th of January.
My lord, in the meantime, there are certain holidays. There are certain holidays.
In the government also there is a holiday.
There are certain holidays. My lord,
it will be a made.
as far as the holidays are concerned, my lord, the government is very, what to say, lenient. So, my
Okay.
lord,
Okay, I am fixing on 27 January.
my lord. And in the meantime,
In
my
the
lord,
meantime, you take steps, file the
lord,
report on that day. If it is
my lord,
done.
in the meantime, the petitioner needs to apply online.
No, but if the online has to be open.
My lord, my lord, I have been assured that after today, he will get the access through the portal, and the my lord, DSR 1, 24 South, will do the needful so that his marriage get registered.
What I may suggest, if the matter come up
No, I am adjourning the matter, but as per the submission made by the
Let that be
learned counsel,
recorded.
if the portal is open, you are free to apply on online portal.
I do not have instruction in so obviously, Mother, because I do not know the procedure insofar as the registration which has been organized for by the.
Nothing, no procedure. I am telling here, sitting here in.
After the order of the court, what remains?
I am telling the procedure of the marriage. Can I explain here, sitting here?
But my lord, it's. But I have been assured twice that after today, the petitioner will get the access to the portal.
So I am
and things will be taken care of so that the marriage is registered.
I am adjourning the matter till 27. In the meantime, if the portal is open, you are free to apply online, and the respondent authorities are
will do the needful so that the marriage
gets
get registered.
Applied and to file the report on 27.
My lord.
Correct.
My lord.
Learned counsel.
My lord, one thing is very important. In the earlier occasion, both of our names were wrongly printed. My name was printed as Showman, and his name was also wrongly printed. So, my lord,
give the correct name.
The correct name taken.
The learned counsel appearing for the state submit that after the order passed by this court dated 4th of December 2025 was communicated to the learned district sub registrar 1 Alipur Alipur. And on receipt of the said order, said communication, the Office of the District Sub-Registrar 1 Alipur has informed the Learned Council for the State that the the portal for applying for registration under the Hindu Marriage Act will be open shortly. In view of the above, the petitioner is liberty to
And my lord, things will be done
in
so
view
that his marriage
and
gets
submit
registered.
that
Necessary steps will be taken.
Portal will open shortly, and the training process is going on with regard to the marriage officer. Training of the marriage officer has been started.
My lord.
Training of the marriage officers have been
No. Training of the DSR 1 is
Yes.
being conducted so that he can go for registration of the marriage.
Training of the DSR 1 has also
South South
is also conducted, and he submitted if the petitioner apply on online portal, the authorities will take appropriate steps in accordance with law. In view of the above, the petitioner is at liberty. In view of the above, if the online portal is open, the petitioner is at liberty to apply for marriage registration on online portal. And if the petition applied for the marriage registration, the authorities will take steps in accordance with law for registration of the marriage of the petitioner. Full stop. Let the matter appear on 27th of January 2025 under the same 2026 under the same heading, and on the said date the authority shall file report.
The adjunctive 27
January.
And my lord, the report that I have submitted, let that be kept.
Report be kept with the record submitted by the petitioner. The respondent be kept with.
And my lord, the names may be kindly.
And counsel for the state submit that in the order dated 4th of December 2012, the name of
Shuman Ghosh has been printed as Shouben.
In the order dated 4th December 2012, the advocates appearing for the respondents have been wrongly recorded as Somen Ghosh instead of Suman Ghosh, and Sudipto Maiti instead of Sudip Kumar Moiti. Accordingly, in the order dated 4th December 2024, appearance of the respondent state be treated as Suman Ghosh and Sudipto Kumar Maiti for the state. Sudip Kumar.
Grateful, my lord. The matter to come up on 27.
27 and the same heading.
Grateful, my lord.
वो नाम दिया है ना?
I'm having full prayer before your lordship. Closure of LOC and quashing of LOC.
Your Lordship, I am appearing for the respondents, Your Lordship. In this matter, Your Lordship had directed us to, we had furnished that there are 3 LOCs against the petitioner.
Yes.
And Your Lordship, on the last occasion, directed us to furnish the details of the LOC from the originating agency. Your Lordship, we have sought for those informations. So I was praying for this week's time to place on record those documents.
Have you received? You received?
Your Lordship, I have just received the information that these are the LOCs which are pending against them, but not the details of the documents that Your Lordship had asked for. All the details have not been received.
When 22nd, can you?
24th, Your Lordship, I was praying.
4th.
Was the last day, my lord?
Last day it is not.
23rd, Your Lordship.
But I leave it to your lordship, my lord.
As per prayer made by the counsel for the respondent, the case is adjourned. Let the matter appear on 23rd of December 2024. The respondents are directed to comply with the order passed by this court dated 27/11/20.
Most of
Same prayer for item 24, Your Lordship. 23 and 24 are similar.
23, 24 same, huh?
Obliged, Your Lordship.
24 is over.
Same order. Same. Lordship, I am for the petitioner, Lordship. This is a TBDB service as per Lordship direction, sub notice to the authority concerned. Lordship, my learned friend is appearing on behalf of the company limited, Lordship. Lordship, petitioner made an application before the authority concerned for the connection of the electric connection of the commercial line, Lordship. 440 volt is required. Because of that reason, Lordship,
What is required?
440 volt, that is the
440 volt.
440 volt of 6 kilowatt. That is the commercial. It's come under the jurisdiction of commercial, Lordship. Application was made on February 2025.
Yes.
Thereafter, Lordship, inspection was done. Report was submitted. As per the report, Lordship, quotation was issued. Petitioner was directed to deposit the 34,000 something. Petitioner deposited that. In spite of that, authority did not turn up. Petitioner made a representation there. I served a legal notice. After getting the legal notice, installation of pole is there, Lordship. That has been done after getting the legal notice. In spite of that, they did not give any electric connection in favor of the petitioner. Petitioner came before Honorable High Court, filed this writ application. That writ application was served before the station manager Goghat. Goghat station manager replied to other person that in which way petitioner will get the electric connection. I will see that. This is the issue, Lordship. Pole was initiated, placed, and one pole was shifted to the land of the other people. He lodged a case under section 163 of BNSS before the Arambagh court, Lordship, and that order was passed, restrain the opposite party to not to do any. The order is with me, Lordship.
What is the contention?
Since he has partially admitted the fact, but this is a question, we are not standing on the way in giving the connection. It is an admitted fact, we have made an inspections. Secondly, we have already installed the poles. And your Lordship knows that it is a high tension line, so specific technical issues are there, pole has to be instituted and transformer is to be made. Now, on that basis, we have done that. But after making the partial work, we have found the stringent objections from some persons, your Lordship. And we have already intimated to the petitioner as well as the objection letter issued by the private parties, Lordship, though they are not a parties to this writ petition, Lordship.
After
this is to may I place it?
Okay, you do one thing. These persons who have objected before the authority, you made them a party and issued the notice to them. I am fixing the date.
Lordship.
File affidavit, they are coming.
That I do. I will do. As per the Lordship direction, I will do. But Lordship, after filing the writ petition, that was served. Thereafter, this story has been created. Kindly, what is in the complaint they written is the 11,000 kV load Sangjojoner the name of the petitioner that it is in my Lordship. This is the order, though it is in Bengali. Lordship, it is clearly written that the petitioner trying to take 11,000
Which paper you are referring? Which paper you are referring?
Yeah, after getting the copy of the court bill, Lordship. This is the order. I
have already given to your Lordship. Next page.
This is the allegation.
Okay, what? That's why let them made a party, serve notice. If they will come, I will hear in person here also if the advocates are appearing. If they will not come, I will pass a appropriate order.
But kindly record that we have got no objections. We are not standing on but we are getting the objection and the way leave is necessary.
The
short date is to be given because that Lordship
party
to korbo ami kore service kore dicchi kalke kore dicchi ajke ami add kore dicchi
direction upon the respondent authorities for providing new
আচ্ছা আপনি যে পার্টি করতে বললেন
Counsel for the respondent submit that the respondents are ready, have already inspected the premises, have also erected some of the poles for providing the electric connection in the premise of the petitioner, but there are objections from the neighbors due to which the electric connection could not be provided. An advocate appearing for the respondent has handed over the copy of the complaint submitted by the neighbors dated 13/11/2025. Considering the above, this court is of the view the persons who have objected for grant of electric connection to the petitioner, they should be made party to the instant writ application. Accordingly, the petitioner is directed to made the persons who have objected before the WBSCDCL.
WBSCDCL, Lordship.
DCL for grant of electric connection to the petitioner. Within a period of, when you will add this person, within a week?
Lordship, as per the document which I have collected from the court below, one name is Bhoirav De and
Wait,
Ramchandra De.
When you made the party, within a week?
Today I will.
Within, by 19th of December 2025. And the petitioner is directed to serve notice upon all the added respondents and to file the affidavit of service on the next date fixed. This is the matter on 7th January.
7 January. Lordship, one thing I want to say, that is the only one name is Bhoirav De whose full address is given here. But other people whose name is reflected in the objection letter is nothing is there. In which way I will
any address?
No, I have received this letter with this address only. This is the available address, Lordship. Who lodged the complaint against, lodged the case.
Okay, whose address is there? You made the party.
No, only one address name, Lordship.
Made whatever it is. Under the same name.
I am deeply observed.
Next, call the passive matter.
এটা দিদি না ওটা আমি লিখে
Number 7 and 8.
ওটা দিদি না একটু অ্যাড করে দিই হ্যাঁ অ্যাড করব সার্ভিস করব after adding Lordship I will serve the petition to the added respondent
By 19 the petition is directed and the department is directed to amend the petition is directed to amend the contract and to serve the copy to the private respondent, the added respondents.
Today I am adding this law.
Yes.
I've spoken with my client. He's absolutely rigid that she's not in a position to return to Midnapur unless she feels insecure and also humiliated. So the only other option is Orissa. But there, my lord, be that as it may, my lord, either a rented space in Khurda, where it's cheaper than Cuttack, one sister stays there. And the other things are set out in the table.
Yes.
She feels her life is in jeopardy in Midnapur.
Okay. So then for that you require the 50,000.
This I leave it to my lord. I will not bargain with my lord. My sons are well off. There's no question about the affluence of my younger son, who is enjoying the rent from the ground floor. He also has other business. There's the fixed deposit proceeds, which nobody knows where it is, but Haryana rental income. And the elder son also has a cattle feed shop in a place called Kiranitala. So the pretense of the elder son that he has already this year or last year, there was a lavish wedding of one of his daughters.
Yes.
Lordship will kindly consider that that has been handed over. Because she will consider that she is getting a maintenance of 25,000 from both the brothers, 15,000 and 10,000. That will take care of the item number 2 and item number 3. Medical expenses in actuals, my lord, there is no issues with regard to that, my lord. We are ready and willing to pay whatever the expenses are. We will pay. They will provide the bill, my lord. The contentious issue is the rent, my lord. She is welcome. My lord, Lordship can appoint a special officer who can go and inspect.
I can appoint, but she's not ready to.
She is not ready. My lord,
if she's staying with her sister, somebody has to provide her electricity, water bills and all that. It is not the law that the sibling will continue to do so indefinitely.
So she will be residing in the house of the sister.
Yes.
She will be residing in the house of the sister. Correct. So if she is residing in the house of the sister, so
either in Cuttack, but one of her brother-in-laws is now very aged. Maybe Khurda, a rented room or something.
Who?
Khurda is near Puri.
No, she wanted to reside in the rented room in Khurda.
That is also amongst her options. Instead of being a liability for all time with.
No, then in that case, see, if she is residing in the house of her sister, so this rent. And okay, she has to be one male attendant with her because she's not been dependent upon the sister. then you consider the rent.
But the question, if mother requires a rent and leaves alone, but the very purpose of she being looked after, Lord, that is frustrated. The purpose is, Lord, that they want to appropriate the rent from
Who's
my client.
frustrating that? Sons.
So, Lord, she's welcome to reside with my client.
Not after the
instead of
experience that
staying
she
with
has
the
had.
sister at Calcutta.
How can a mother, Malad, in the
entire
normal
thing is that she is-
circumstances, feel insecure to go back to her sons? She cannot,
And she
Malad,
was all
forget
through
the
with the
past.
sons. She was all through with the sons.
I leave it to my lord. I'll not bargain, but this is the hard reality. She is not in a position to return to.
No, I can pass an order if the both the party come to a settlement. The court cannot impose the condition if it is not settled.
I even persuaded her to try to agree to coming back to Midnapur for a limited time, see her experience, narrate that to my lord. And then, my lord, there are decisions. Then after that, there's no question of not vacating if the sons behave badly and all that. But she has that, not even that feeling of security in her.
So what the other son is doing?
The other son is, Lord,
A cattle feed shop, my lord, in Kiranitala, close to where the house is. The locality is Kiranitala. And his elder son is now working, grandson.
So if how much amount you can pay?
But we'll continue paying what that has been directed by this honorable court, that 15,000 rupees and the 10,000 by the other son.
No, if she is not coming and you are using that, she is not coming. So some you can increase so that the matter can be solved for all. Take the instruction.
Pay the rent from the godown to the mother, that's all. It's the mother's house.
घर में आएगा तो फिर भी तो आपको देना पड़ेगा. It's either here or there. You sort it out.
Okay, not I am fixing another date. No problem. You take instruction. This is the because now she has made up her mind. She will not come here. Not with regard to the only.
That is another point of concern because, Lord, there are other reasons, Lord.
So
We
that, now only the concern with regard to the 15,000 of the monthly rent.
Lord.
That is the only concern here.
And this reimbursement of medical bills, Malad, that is also an issue unless there's somebody in between. But the advocate records of the respective sides have to be the special officer. Every time submitting the bills.
Not at all. Just send it to us. Let us not complicate things. We are here to simplify.
WhatsApp message. You send it by Google Pay.
Let it be paid by the younger son then, because again the
Just
splitting.
let her give us the prescription. We'll send the medicine by courier or whatever means.
So that I will.
And also the doctor's fees and Malad, the pathological tests and all that.
If that's so urgency, naturally the sons has to. That cannot be. If she is admitted or she is going to hospital, that naturally the sons has to take care of it. This is with regard to a permanent solution. With regard to the medical emergency, naturally, if she is in a serious condition or she has to go or any operation, naturally the sons has to do that.
Even Malad, she has come here, she stayed in a hotel overnight. All those I have to submit to her. My learned friends.
They will take care of it. That already there.
She's accompanied by the sister, and the sister has come, and there are other issues. I'm not
no
taking
problem.
You take
She has herself told the court that she is not in a position to.
You again consider you inform.
Yeah.
Only with regard to the 15,000, if you are residing, not interested to come the house and 15,000, you consider that. And how soon, how far you can increase the 25 to above. That you can increase so that once for all this can be
No,
settled.
I am paying 15. The other son is paying 10.
How much rent you are getting from there? What is the business of the
No,
client?
I'm using it. I've not annexed the trade license.
There's a go down.
So you are using.
We are using it. And it started at the time of my father.
And what? He's only giving the 10,000.
Yes.
So how you can increase further?
That I'll talk with my client,
So I am
but not
fixing-
much. But the only thing is that our concern is that we pay money and somebody else utilizes it.
There was the allegation of money
if it is
being
possible. Otherwise, I will decide.
money
on
being
that.
withdrawn from the ATM. That was my fees. Who will pay for that? Not my adversary. Unfortunately, my sons are now my adversaries. The allegation, the totally unfounded allegation of money being withdrawn from where the legal fees come
the
from.
court is not going on at this stage. This court is not.
Those
going on
allegations are
proceedings.
made only to create prejudice.
That's why this court has called the lady in person so that the matter can, this court can hear person in person.
Even I didn't expect her to be so rigid, but she has suffered. She has a story to tell.
The petitioner in WP number, see the petition WPA number 10504 of 2025 is present in person, and she has stated that she is not ready to reside with the sons at their house, at their school. Learned counsel for the sons prays for time to take appropriate instruction. Accordingly, case is adjourned. Let the matter appear. When? After vacation? Before vacation? Mr. Banerjee, when can be fixed? Before vacation? After vacation?
But as your lordship pleases, my lord, it is.
Let it be finished, my lord. Otherwise, again, our memory will.
On 22nd.
22nd. Much obliged. But it is fixed at 2 o'clock. Lord, do we come at 2
Time
o'clock?
cannot be fixed as an urgent motion. It can be.
If your lordship desires my client to be here, my lord, that's the reason I was.
No, you only know the. I heard it. You take instruction how much if they wanted to pay and it's ready. Then I'll pass order. Otherwise, you hear the matter on merit.
Lots.
I'll forward the my lord, travel expenses.
Yes.
ওই তো প্রথম পিটিশন পুষ্পা শর্মা আমার ক্লায়েন্ট
Yes.
Well, I had a talk with my learned friend. He has informed me, and I may inform that your lordship as well, that it's under process because your lordship, the land losers, they want. If in the meantime, let them file the report. In the meantime, let them expedite the process.
2 days I can't, but of course in course of time it will be expected. But I am seeking 2 more days to file the report in the court. That's my stand on record. Then
So serve the report by 19th.
Yes, by this.
If your lordship keeps it on 19th, because after that, nobody will come to court.
As per the prayer made by the counsel for the respondent, let the matter appear on 19th. Next.
But I'm for the petitioner. Well, one order was passed by the matter Clinical Establishment Regulatory Commission, my lord, that some amount has to be paid to the patient. My lord, the fact is, a 27-year-old person has been admitted with the abdomen pain, and he was finally operated on 26th April 2024 for gallbladder operation. After which, in normal case, there are only 2 days stay in the hospital for gallbladder operation, laparoscopic operation. But this patient was, admitted for 1 more days. So 29th, he was released in stable condition. After that, on 2nd May, he was readmitted with post-operative complications. The whole thing is on that post-operative complications. Thereafter, several times, he was admitted, and the council, and after being cured, he filed a petition before the commission saying that he has been harassed by the hospital and all the bills has to be refunded, This order, is with
for whom?
I'm for the petitioner,
For the private. You are challenging the order?
Yes, my lord.
Which
Because
order? Where is the order?
Order is at page 13, my lord. The order is without jurisdiction because medical negligence, cannot be dealt with by the commission. May I read? The order dated 12/12/2024.
Refund 3,68,000.
Lordship, this is the bill for subsequent visit.
Liberty to approach the appropriate authority on the issue of medical negligence. Lordship. So what for the bill, the amount is to be.
My lord, that is my question also. My lord, they are saying that this is not a case of medical negligence. Then why they have imposed
this order? Committee.
My lord, the commission, the clinical establishment commission. My lord, kindly see the jurisdiction of the commission, my lord. Commission is, well, I am covered by the division bench judgment of this court and the, my lord, landmark judge of, my lord, Jacob Matthew versus State of Punjab, the three benches judges bench of Supreme Court, my lord. It is held, my lord. Let's kindly see the jurisdiction of the commission. Section 38 of the Act, my lord. Number 1, powers and functions of the West Bengal Clinical Establishment Regulatory Commission. The commission shall monitor and functioning of clinical establishment, regulate and supervise functions of the clinical establishment as prescribed, examine and consider complaints filed manually or electronically through an online system in matters related to patient care service, deviation from declared fees and charges, refusal of supply of copy of medical records and allied matters, and alleged irrational and unethical trade practice alleged before the commission by aggrieved patient parties against the clinical establishment, and other issues of notice and hearing both the parties, adjudicate, compensate and pass such other orders as deemed appropriate thereafter, my lord, provided that any complaint of medical negligence against medical professionals will be dealt with by the respective state medical councils. So it is excluded, my lord. My lord, they have transgressed their jurisdiction, my lord.
Provided that complaint of medical negligence.
Lordship.
What is the, where is the complaint? What the complaint they have made?
My lord, we have not supplied with the complaint, my lord. We have not issued any notice. Only an email.
Not appeared here.
No, my lord.
Before the commission, no hearing was done.
No, my lord. Only a, my lord, email was given to us, my lord.
Who is appearing for the commission?
My lord, I have not made the commission as a party. I have challenged the order of the commission because commission is a court, my lord, at that point of time.
You are appearing for? Who is appearing for the 1, 2 and 3? State nobody is there. Have you served the notice?
Yes, my lord. I have, this is the evidence. At the earliest occasion, my lord, they have appeared, my lord.
Who has appeared?
My lord, there is an order. The state and the private respondent, number 4, both appeared.
Okay, issue the notice to the state. I am fixing another date.
My lord, then kindly see the order of, my lord, page number 18, my lord.
Yes, I gone through. 3,68,000.
Yes, my lord, and the page number 18, my lord, they are saying that unless the order amount is paid, my lord, the license of the hospital will be cancelled, my lord. My lord, that order may be stayed, my lord, in the meantime.
No, already kindly see there on the last one. Meantime, the respondent will compel the petition to deposit the money in terms of the order.
That was up to Monday, my lord. That may be extended, my lord. Lordship.
As none appears on behalf of the state respondent, this court is of the view the presence of the state respondents are necessary. Accordingly, case is adjourned. In the meantime, this court hope and trust that the court. In the meantime, the respondent. Full stop. In the meantime, the respondents are restrained from giving any effect or further effect to the impugned order dated 12/12/2024 till the next date of hearing. The petition is directed to communicate this order to the state respondents. Please the matter on 8th of January.
Lordship. May I take back the book, my lord?
Take the book.
Lordship. ওই হ্যাঁ যেটা ছিল আগের বার জয়ন্ত মিত্র পিটিশন
Which one?
well, 90 and 91 challenging violation of the Revocation Act. Well, regarding those incentive schemes, well, we find Lordship is, my lord, has kept one original side matter. Well, my lord, same act, my lord, the Revocation Act is under challenge. Item number 5 of today's Villa Corporation matter. Well, since, my lord, there are numerous, my lord, appellate side writs also, my lord, challenging the same. Well, it was Lordship's. Mr. Banerjee is there.
Well, we are also challenged it, my lord, that writ petition, my lord, they can all perhaps, my lord, be taken together, my lord.
But
It's
you are
just-
you are in appellate side.
I know, but my lord, the issue is the same. My lord, it can be tagged, my lord, either, my lord, this can be tagged with that, or, my lord, the appellate side can be tagged, my lord, with the original side. Perhaps, my lord, that would be better, my lord, than.
But I don't think this today the matter will be taken up. If it is taken, I will take care of it. What is the
Very
number?
well.
List of those matters. I am appearing with Mr. Banerjee in items 90 and 91. But there are other matters also. I have identified those also. With the leave of Mr. Banerjee.
1991.
Yes.
Okay. If it is reached, I will take care of it.
Grateful, ma'am.
Then we can be heard, my lord, any other day, my lord.
Thank
you. And one more liberty I was seeking, my lord, in respect of, my lord, an original side matter where interim order is due to expire on 18th. If it is not taken up, my lord, if it can be extended.
18th.
18th.
Item number?
69. Very unlikely, my lord. But it can retain its position. Lordship kindly extends the interim order.
Yeah, record and where is the order?
69. 69 indeed and unlikely. I'm maintaining upon notice.
So the matter is listed as item number 69. But the learned counsel for the petition submit that interim order is till 18th of December 2025 and prayed for extension of interim order. In view of the submission made by the counsel for the petitioner, interim order is extended till 23rd of January 2026 or until further order, whichever is earlier. Let the matter remain in the list.
Very great.
Item number 30, the Lordship this ballot. Item, maybe some precedent may be given tomorrow.
Item number?
Item number 30, ballot. Some precedent may be given tomorrow.
Tomorrow? I don't know. What is the urgency?
It was that matter where the
Huh?
closure of a hotel in closure of a hotel in India is closed by the termination. That matter.
So you will lose the Christmas party and the New Year party.
Want to continue with that matter. And this is the peak season manner plus after the Jagannath temple manner the tourist flow has increased for last 1 year.
Why you have violated the rules?
Well, there was a change in partnership for new partners came in, but still during the pendency of the rate we have paid the entire money also without prejudice.
Item number?
30.
30 उसको देखो आइटम नंबर 30 का टाइम होगा तो परसों कोर्ट एप्लीकेशन में ऊपर जजमेंट
May I, my lord, have my lord, I need my lord to mention. My lord, I was seeking leave to move this. I'll file this in the department. My lord, if we could move this tomorrow, this electricity matter connection to the bank has been disconnected, my lord, by the CSC at the instructions of the management committee.
interest with 50%.
Whatever, my lord, but here, my lord.
Payment of interest with 50% in.
My lord.
Bank is here. So you deposit with 50%
This
interest.
is not a single due in respect of electricity. It's a management, this maintenance dispute, my lord, for which they have disconnected. My lord, I was seeking because, my lord, from Friday.
Original side.
Original side. We have no connection, my lord, from Friday, my lord. Everything is now online, my lord. The banking business has come to a halt. I've served them yesterday, my lord, the entire writ petition.
So what do you want?
My lord, leave.
Not yet filed.
Leave to move it tomorrow, my lord. If my lord grants that leave.
Court application कब आएगा? Thursday, कल बुध है. Day
But, my
after
lord,
tomorrow.
But, my lord, we are without power from Friday, my lord.
ठीक है उसको कल रख दो. Leave is granted to affirm the affidavit. Please tomorrow. As urgent.
পরে আসবে এটা কিন্তু আমার ফাইলিং বন্ধ হয়ে যাচ্ছে
May I, my lord?
বন্ধ হয়ে যাচ্ছে
May I, my lord, mention, my lord, 2 suits, my lord, commercial suits, which your lordship had, my lord, decreed in my favor, ex parte, my lord, for correction, my lord, in the order, my lord, 10 lakh in one place has been written as 1 lakh. My lord, that has to be corrected. In the other suit, my lord, there is a similar, my lord, typographical, my lord, correction to be done, so that, my lord, thereafter the decrees, my lord, could be drawn up.
To be mentioned for correction.
Yes, I will bring the corrected order also.
May I have mention item 162 in my lord already said already.
This is my lord, my repetition where the RBI, Reserve Bank of India, has rejected my application to surrender my NBFC license. My lord, an NBFC, my lord, under the RBI Act has to maintain a certain net worth fund. I am unable to do that business. I am unable to have that net worth fund. I have applied to surrender my license, which has been rejected by RBI. My lord, now the hearing is even it's been pending for quite some time, my lord. My lord, an exception has been filed by the Reserve Bank of India. We have filed our report. We have filed our affidavit also. So I'm highly teaching my lord to take it up. I'm sorry. Reserve Bank has filed an affidavit. I'm sorry. We had filed our exception to it. My lord, my only grievance is, my lord, towards the end of the year, my lord, if that.
What you want?
My lord, I'm led by Mr. Ratnakar Banerjee. I'm led by Mr. Ratnakar Banerjee. Any date, my lord, next week. If my lord,
Come after vacation.
my lord,
I will fix any date. Before vacation,
my difficulties, my lord, I am unable to maintain that net worth fund. I have
can be done. Tell me.
Next week, any day subject to my lord.
Next week only 3 days. The 24 nobody will be there.
We have not received the exception. But we have some. We have not served. I am saying for the time. I will serve, Marat. Can it now he's saying that I will serve. Marat, my advocate record is not there.
You have not served the copy.
That we have served. Marat, come after vacation. Penalty will be huge, Marat. I am unable to maintain that fund. That is why I want to surrender my NBFC license. If that is not allowed, Marat, the penalty will be imposed on me. I am already been saddled with penalty, Marat. Kindly consider any date, time next week.
Tell me which date I can fix. I have no.
Any date, Marat.
Can't be. My diary is totally packed till 24th. If it is taken also, I don't think it will come before 15.
But Marat will kindly appreciate my predicament. Marat will kindly appreciate my client's predicament, Marat.
एक काम करो तो कोई 10 का अंदर रख दो कोई serial number 10 का अंदर
162 today.
Malad, may I Malad kindly to mention Milad item number 111. Milad, it's a contempt matter. Milad on 26th Milad November. Milad and passed an order when Malad recollect that Milad Mr. Parivesh Shukla had appeared Milad who has showed Milad thumbs up Milad WhatsApp message. Now Milad had directed him to file Milad a compliance affidavit within a week. Milad he had filed after that. Milad anyway Milad will seek Milad an extension. Milad it's not an extension. Milad I'll seek Milad liberty to file the reply. Number one, Milad the difficulty is that Milad the post that he had made prior to Milad passed the order, interim order, that's Milad will decide finally. Though Milad the interim order has now been confirmed by the coordinate bench. Now Milad the issue is that Milad he had made some post also Milad after my lord's order, even Milad after the rule was issued. So Milad that has to be Milad brought down. Those are still there. Now Milad I'm facing difficulty with regard to that. So Milad if Milad fixes
file the supplementary amendment
here after my lord's order of rule.
Now the determination is there, not in the contract.
No, the rule Milad
Rule
after my lord issued a rule, this was my lord.
But the cause of action continue with the suit.
No, that has been confirmed. That has been confirmed.
Correct.
That has been confirmed.
That hasn't come.
Yes.
Subsequent to that also they have
yes
published.
Yes.
So the further cause you go and amend this.
No,
How the
I
contempt of petition.
no Milad what I was suggesting Milad my lord had given me liberty to file a reply. Anyway Milad he has served after that. So Milad I'll Milad bring all the Milad documents Milad with, attached to my reply. Milad can you fix it any day after whatever my lord's diary permits. I am not Milad not in a hurry Milad to do it before vacation or that. Milad kindly Milad gives me leave to Milad file. This was my last order.
Item number
111.
As per the prayer 111. As per the prayer.
I'm mentioning upon notice.
The petitioner. Time to file reply is extended for a further period of 10 days from date.
Let it any day when it can be taken up. Any day. Let
the matter appear on 9th of 9th. 9th में होगा
যেদিন নিতে পারবে সেদিন মানে
যেতে পারবে তো February first week. February first week.
February first week.
Before February first week there is no date. If we want urgency hearing.
No, time fix করে দেবে
No time. I am fixing on 9th. Let you try your luck on 9th.
Very well. Time fix করে দেবো.
Yes, next.
My lord fix a time any day Milad in February. Well, I've taken instruction.
4th February at 3 p.m.
3 p.m. But I've taken that's better option.
The petition is directed to inform the next date of hearing to the learned advocate appearing for the alleged contemners. Yes, next, call the list.
To be read the item number 1. Lord, I appear in this matter not on behalf of the alleged contemner number 3, Lord. Lordship, can you see the order which is passed by your Lordship on last Friday, Lord?
Yes.
So when the matter has appeared as to be mentioned, Lord, my client was not represented when the order was passed, Lord, as I am instructed that my no notice of to be mentioned was given to my client.
Yeah.
Be that as it may, Lord, I wish to file the affidavit, Lord, as Lord, the direction has been given, Lord, insofar as alleged contempt number 1. Can you see the clause number 1? And Milord, clause 3, Milord, should be modified, Milord, insofar as the drawing of the rule is concerned.
Which order you are referring to?
12th of December, Milord, last Friday.
I am appearing for the contemner number 1.
Kindly see the Milord, last order. Milord.
Last order is December 12.
Yes,
Friday order.
last Friday.
Yes.
Milord, I was not represented. Milord.
Correct.
Milord, I used to file affidavit in the matter, Milord.
On behalf of whom?
Contender number 3, Milord.
Yes.
Milord, she is the constituted attorney, Milord. Of Milord, the contender number 1.
Correct. So, but they have not appeared.
Yes, Milord. It did not appear.
Therefore, rule has been issued, Milord. They can answer to the rule.
Yes. No, Milord. I shall file the affidavit in the application for contempt, Milord, as the direction has
Correct.
been given,
Once
Milord,
the-
insofar as
Once the rule has been issued,
Yes.
you have to call.
No, Milord, kindly see the Milord. First, clause 1, Milord. Clause 1. Learned counsel for the alleged contender number 1 pays for time to file affidavit in opposition.
Correct.
Similar direction as I am saying, Milord, since I was not here, Milord, on last Friday.
But they had appeared.
Milord, I could not appear, Milord, as I was not represented, Milord. No notice has been given, Milord. The matter has appeared as to be mentioned. Contempt matter has appeared as to be mentioned, Milord.
Who gave him notice, man? Matter was taken up on Friday. He mentions on Monday. Who gave him notice between Friday and Monday? How is Mr. Ganguly aware all of a sudden?
I was given to understand, Milord, by my client, Milord. She
Same.
has given, Baba bolte dao. She has, Milord, informed by the Milord contempt number 1.
So,
who is the Milord principal, Milord? I am the constituted attorney, Milord. I have only the signing power of the affidavit, Milord.
Milord, what has happened in this matter, Milord, I am appearing for the contemptor number 1. Milord, in the contempt petition, Milord, a very strange, Milord, impleadment has been made. Not only an allegation against me, but against my constituted attorney as well.
Yes,
So, my constituted attorney was not appearing, Milord. Today they are appearing.
Milord, I am a constituted attorney in Kolkata, Milord, and the incident, Milord, which is, Milord, alleged, Milord, the one property sold in Meghalaya. There is one separate constituted attorney.
Milord, constituted attorney is the one, Milord, who's been signing documents.
Okay, now see. Wrong, right. Just a minute, please hear me. Wrongly or rightly, the court has passed an order for
Kindly, Milord, call the order, Milord, or modify the order, Milord.
Yes, call the next meeting.
Item number 2. For extension.
If the party is not able to hear the judge,
No,
then
Milord,
it is very difficult to the
thing
court.
is, Milord, I tell you, Lordship, Milord. Lordship, kindly bear me, Milord, for a minute, Milord. She is the elderly lady, Milord.
Maybe
Milord,
once the court is telling that here the council is not hearing the court.
Appeared as to be mentioned, Milord.
My lord, the
She
matter
was
was
not informed,
appearing
Milord.
for
The
the last
matter has
6 months.
appeared.
My lord, the matter was appearing for the
Being
last
a senior person,
Be kind enough, Milord, to my client, Milord. She was not aware, Milord.
maybe that's why I'm telling. Rightly or wrongly, the court has passed an order of record rule. So what is the next step? Being a senior advocate, tell me.
No, Milord.
By mentioning the matter, can the rule can be recalled?
I tell you, Lordship, Milord.
Either there are 2 ways. As far as my knowledge, only 2 ways for recalling of the rule. Either she has to surrender or to file an application.
Milord, Lordship has given leave, Milord, to contender number 1 to file affidavit, Milord.
Correct.
Yes, Milord.
Because they have appeared.
Yes, Milord. I could not appear, Milord.
Correct. That's why the rule has been issued. If you want the rule is to be suspended, you have to take appropriate steps.
Yes, Milord.
By mentioning the matter, the rule cannot be stopped.
Milord, I could not appear because, Milord, I was prevented by, Milord, I was not given any notice, Milord, the matter has appeared. as
Take all this plea in the application.
Kindly, Milord, do not. Be kind, my lord, to my client, Milord.
My lord, this matter, just because my learned senior friend is making this allegation, this matter is appearing in your lordship's list for the last 5 months.
No, sir. Every day. It was appearing as item number 1.
Yes. Next.
Please, my lords, this is, I'm for the petitioners. My lords, I'm praying for extension of the interim order. If my lords takes the last.
Who is for
order-
the other side?
But Mr. Owen Banerjee appears for the state, Lord.
Ah.
Lord, he is currently engaged in court number 3.
Ah.
My lords, it may
Now,
be.
interim order, what is your submission?
Lord, I do not have any instructions, Lord.
The
My
matter
lord,
is listed as to be mentioned for extension of the interim order. Full stop. This court find that the petition is already enjoying the interim order. Accordingly, the interim order is extended till 21st of January 2026 or until further order. Let the matter remain in the list.
I'm obliged, my lord.
Next.
Lord, I appear for the petitioner, my lord.
Yes.
Lord, the interim order was last extended on 27th of November 2025. My lord.
Yes.
Lord, initially, the interim order was granted in July. My lord, it's a case where the bank has.
What you want? Extension?
Lord, I'm praying for, my lord, extension of interim order.
Maintained in this court, my lord.
Huh?
It is not maintained because respondent is a private company.
Hmm.
And against private company, they filed.
Huh?
Against the private company, they filed this case.
Yes. Okay, I will hear the matter. When? The matter is listed to be mentioned for extension of interim order. Full stop. Landed counsel for the respondent submit that the writ petition filed by the petitioner is not maintainable. Considering the above, this court find that the matter is to be heard. And considering the submission made by the counsel for the petition parties, this court find that the petitioner already enjoying the interim order. The interim order is extended till 22nd of January 2026 or until further order whichever is earlier. Let the matter remain in the list.
Lord, the respondent was called upon to file a report. My lord, I have filed an exception to the report. My lord, may the exception be taken on record. I have already served the respondent.
Exception filed by the petitioner be kept with the record. Next.
Grateful.
It's my application, my lord.
Yes.
My lord, this writ petition challenges, my lord, a purported order of vesting of a property, that is premises number 4, my lord, Kidd Street.
What you have prayed for?
14 Kidd Street, my lord. So, my lord, I am praying for setting aside of that order of, my lord, vesting in the state government, my lord. They have initiated proceedings under section 2G and 3 of the SG Act against me, my lord, and they have purported to hold that the property is vested in the state government because the deceased, my lord, one Annette Emily Apicard, she died, my lord, in 2015 without issue. They say she died intestate. I say she has died testate, my lord. There is a long litigation history in this matter. My lord, PLA application had filed by this, my lord, the executrix of the will being one Nagmana Parveen. May I just give your lordship the facts in a nutshell, my lord? This
Where is the order?
Yes.
Where is the impugn order?
Kindly allow me. Impugn order. Impugn order. What we challenge? No, it's in the report. Allow me one moment, my lord. The physical brief is damaged in the flood, so I'm a little incapacitated today. That is the difficulty. If I can impugn order. এটা হলো 26 December 2018 order. I'll just give your lordship the facts and brief, my lord, prior to that, my lord. Yeah, kindly see page 31, my lord.
Of their opposition.
Of the opposition filed by the state. Page 31 in the opposition, my lord, 23rd July 2019. They have issued notice under section 5 of the SG Act, my lord, saying that whereas first land acquisition collector as competent authority declared the property at 14 Kidd Street as escheated property following due procedures as laid down in relevant sections of the West Bengal Escheats and Forfeitures Act 2012 and rules and forfeitures of immovable property rules. And whereas the collector of stamp revenue, Kolkata, has been duly authorized to take steps to take over possession, management, or administration of the escheated property. Now, the undersigned proposes to take over possession of the property and assume administration or management thereof. But, my lord, I remain in physical possession. Now, my lord, I'll just give you lordship the background in a moment. My lord. One, Annette Mary Emily Apcar, she was, my lord, the owner of this property at 14 Kidd Street. She died, my lord, on the 15th of June 2015, leaving behind, my lord, a registered will of 16th March 2013. Died, my lord, without leaving any issue. Her father's name is important, my lord. Her father's name is Kachik John Avetum. These are Armenian people. Kachik John Avetum died before Annette Mary Emily Apcar. So Annette Mary Emily Apcar admittedly was the owner of 14 Kidd Street at the time of her death. Now, my lord, she has left a registered will of 16th March 2013. That is at page 27, lordship will find, my lord. The executrix in that registered will is the mother of the petitioner, and the petitioner is the sole beneficiary named in the will. Who are the petitioners now, my lord? The petitioner's family have been the loyal servants.
How many children she had?
She had no children.
So how the petitioner?
No, the deceased had no children. The executrix is the petitioner's mother. Yes, only one child, one son. So, my lord, that is why I'm telling your lordship, my lord. The petitioner's father was the driver of the family. The mother was the domestic help of the family since 1958. Then, my lord, the petitioner's family used to live with this Annette Mary Emily Apcar and her family at 14 Kidd Street. When the petitioner's father died, he also continued to live there, and he served as the driver of this Annette Emily Apcar. So, my lord, long-standing family affiliation. So, we have been the loyal servants of the family for a long time. And, my lord, this Annette Mary Emily Apcar admittedly left no issue. So, my lord, in her will, the petitioner's mother is named as the executrix and the petitioner is named as the sole beneficiary. So, my lord, when this Annette Mary Emily Apcar dies in 15 June 2015, yes, she's not even married. She was a spinster. Nagmana Parveen, the petitioner's mother, being the executrix in the will, she files a PLA case. Number is 225 of 2015. My lord, initially there's a certificate saying this is non-contentious because within the period stipulated, my lord, nobody filed a caveat. Thereafter, another gentleman surfaced. His name is Deepak Kumar Agarwal. Deepak Kumar Agarwal also filed a PLA case 126 of 2015 saying no, the will that you are claiming under, that is the registered will of 16th March 2013, is not in fact a legitimate will of Annette Mary Emily Apcar. He said there is a different will that is of 2014. That was subsequent will, unregistered, left by this Annette Mary Emily Apcar. So he claimed under this will and filed a PLA case 126 of 2015. 16. Why he filed this PLA case, my lord, is prior to that, he sought to intervene in my PLA case, 225. Dismissed, saying no caveatable interest.
Not disclose the will. At that time,
No, not disclose the will, so dismissed without any caveatable interest. Then he files his own PLA case. That ultimately, my lord, he proceeds to withdraw because he ultimately concedes he has no case. Thereafter, my lord, the Armenian church, they also file a PLA case. They say, like I told your lordship, the father's name, Kachik John Avetum, father of Annette Mary. They say that this Kachik John Avetum left a will. In his will, undivided 1/3 interest in 14 Kidd Street was left to the church. So they filed a PLA case, also ultimately dismissed.
They filed a caveat.
So, yes, I beg your pardon, my lord. They filed a caveat in my PLA case, 225. Also, my lord ultimately had that there is no question of any vesting. But there is one material order, my lord. The order, my lord, discharging the caveat filed by the Armenian church, that is an order of 12th July 2017, passed in my PLA application, PLA 225 of 2015. That, my lord, records that a coordinate bench of the High Court had passed an order saying the state is entitled to intervene in the PLA case and to contest the same. Why? Because, my lord, the state says there is no valid will, there is no legitimate heir to the property, so it should vest in the state by way of escheat. So the court records this submission of the state and says state is given liberty to contest the PLA proceeding, and the state does so. So the state files one GA for the dismissal of PLA case 225 of 2015 that my client's mother had filed as executrix on the basis of the will of 2013. The state also files an application for dismissal of this Deepak Agarwal's PLA case 126 of 2015. So, my lord, in the state's application, there is an order recording Deepak Agarwal withdraws his PLA case. Now, what happens is, my lord, my mother was a Pardanashin lady. I have told your lordship, we were the domestic help of Annette Mary Emily Apgar. It is in this capacity, because of the close family affiliation, that in her will she had named my client as the sole beneficiary. But my lord, because there is one claim that is raised by the Armenian Church.
Will of whom?
Everybody is claiming under the will of Annette Mary Emily Apgar, save and except the church.
This is the will of Christianity.
I beg your pardon?
Christianity.
Yes, yes. Only the church, my lord, was claiming an interest on the basis of the will of the father, Kachik John Abitur. They are saying that my lord, prior to Emily Apgar acquiring any interest, the property or an undivided 1/3 interest in the property would devolve upon the church. But that has been, my lord, resolved now. The court has said, no, there is no question of any vesting on you. Now, what I'm trying to tell your lordship, my lordship will find from paragraph 33 onwards in my petition, saying that, my lord, ultimately, in the state's application for dismissal of PLA 225 of 2015 filed by the petitioner's mother, my lord, that ultimately came to be withdrawn, because the petitioner's mother said that I am a Pardanashin lady, I do not have the resources, nor do I have the fortitude to contest all these proceedings. One is, my lord, a contest coming from Deepak Agarwal on the basis of some contrived will of 2014. One claim is coming from the church. Then, my lord, there were criminal proceedings initiated by the church, Armenian church, saying that you're forging and fabricating documents which you are relying on in your PLA case, and also you are in wrongful possession of the property. That ultimately, my lord, was converted into an FIR and proceeded against me. So in these circumstances, my lord, this Nagmana Parveen, petitioner's mother, was compelled, my lord, to file an affidavit of 10th June 2017 in PLA case 225, saying she is not inclined to proceed with the case any further. So, my lord, there is an order of this honorable court dated, my lord, 1st December 2017.
PLA dismissed.
PLA dismissed as withdrawn. So both PLA cases are dismissed as withdrawn. Now, my lord, yes. So, my lord, criminal cases were initiated against me, which was really, my lord, the factor which compelled and constrained my mother to withdraw her PLA case. Now, my lord, in this criminal case, FRT has been, my lord, reached in 2021. In the specific date is, my lord, March 2021. Immediately thereafter, my lord, August 2021, the petitioner files a new PLA case before this honorable court. And in that, my lord, order to the Justice Arindam Mukherjee. In this matter, my lord.
Petitioner being this.
No, now the petitioner before your lordship, not Nagmana Parveen. The current petitioner before your lordship has, my lord, filed an application saying Nagmana Parveen has, my lord, said that she will not proceed with the matter. So, my lord, now he has applied not for probate but for letters of administration. Because, my lord, if your lordship is I beg your pardon?
He was the beneficiary.
He is the beneficiary. He is the sole beneficiary. So, my lord, since the executor has withdrawn from the proceeding, being the mother of the petitioner has asked for letters of administration. And in that proceeding, my lord, this order.
Not to alter the position.
Yes. So in the course of this, my lord, when the new PLA case we have filed before this honorable court, saying that the earlier petition, PLA 225, that had been filed by the petitioner's mother as executrix, seeking probate of the 2013 will, she was compelled and constrained to withdraw, my lord, under compelling circumstances. This is not, it was done under duress or coercion or undue influence, my lord. She was not freely consenting to withdrawal of those proceedings. So, my lord, the petitioner's interest in the property does not get extinguished. So, he is entitled to maintain this PLA case. In that proceeding, my lord, we had also disclosed the fact that in the interregnum, the state has initiated proceedings under section 2G and 3 of the SG Act, my lord, saying that the property has vested in the state because there is no heir who is entitled to the property. It is only when they file their affidavit, my lord, in response to my PLA case that I come to know of this, because I am not an heir in intestacy, your lordship will appreciate. I am only an heir claiming through the will that the property will devolve upon me. But since I am not an heir in intestacy, my lord, under the provisions of the SG Act, the state is not required to, my lord, serve notice on me, and they have not. They have come and attached now, my lord, a possession notice at the property, which still remains under my lock and key. So, my lord, at that juncture, we know that the state claims that already the property has vested in them by way of SG. At that juncture, my lord, we file an application in the PLA case, my lord, saying that the state should not be entitled to, my lord, take possession, because I have a right, which I am able to demonstrate before the honorable court. In this conspectus, my lord, at page 306, your lordship will find an order passed by the coordinate bench in my PLA case, that is, my lord, PLA 438 of 2021, my lord, holding that interim order, which was to the effect, it is expected that the party shall not alter the present position till the next date or until further orders which is extended till 17th July 2023 or until further orders, whichever is earlier. So, my lord, status quo was preserved. Thereafter, my lord, coordinate bench in the PLA case passes this order of 2nd August 2023, again saying, my lord, if I may hand it up, my lord.
Subsequent to filing of the writ petition.
This acknowledging, my lord, that the state alleges that the property has vested in it by escheat, but I am in possession of the property, and that I am praying that status quo not be altered. The PLA court, however, my lord, observes that in a PLA proceeding, question of title naturally cannot be gone into. So whether, my lord, there is in fact vesting to the state by escheat or not, that is not a question that can be determined in the PLA proceeding. So, my lord, being fully conversant with that, my lord, and accepting the position that, my lord, issue of title and whether the vesting is valid or not cannot be determined in the PLA case, I proceed to file this writ petition. So, my lord, in the PLA case, there is an order that status quo with regard to the property be maintained, and the matter is adjourned sine die for me to be able to pursue, my lord, this writ petition which challenges the order of vesting in the state. So, my lord, my humble submission here is that the state was all along, my lord, privy to the litigation between the parties here. They had also contested both PLA 225 filed by the petitioner's mother, Nagmana Parveen, on the basis of the 2013 will, and also, my lord, the other PLA proceeding that had been filed by, my lord, Deepak Agarwal. They were also, my lord, aware of the fact that, my lord, the Armenian church was also claiming an interest. So, my lord, the state is aware that there are 3 parties claiming an interest in the property. It is not that this is, my lord, a Lavaris property in that sense, that nobody is claiming any interest in this property. My lord, under compelling circumstances, I was constrained to withdraw my PLA case in 2021, and the Honorable Court held.
Now, what you print that? Challenging the order of the authority.
Yes, now I am challenging the order of vesting, my lord. I am saying that it could not have vested, and, my lord, I was entitled to, my lord, notice and to contest the proceeding because I, my lord, under the will of 2013, which is a registered will, and therefore will, my lord, carry a prima facie presumption of validity that I am the, my lord, I am entitled to, my lord, interest in this property, that this property will devolve on me.
How the writ court can decide that title?
No, writ court will not decide the title, my lord. Kindly.
We are asking for the stay of this question.
Writ court will only decide, my lord, whether I am at all entitled. I kindly see, my lord. Let me place the provision of the SC check. Then I will be able to, my lord, answer the query of the court. If your lordship will kindly take the act. Ache to copy. Allow me one moment, my lord. But I will place the provision, my lord.
State acquisition.
No, sorry.
The SC act, my lord.
আমাকে দেখতে হবে।
One moment, my lord, kindly. আমার marked copy আছে, এক second. Yes, my lord. The lordship will kindly have, my lord. S-sheet is defined under section 2G.
Correct.
My lord, it says, with all its grammatical variations, mean the automatic transfer to the state government of the property of a person who dies intestate without any legal heirs according to his personal law, and in case of an artificial person that your lordship need not be concerned with, my lord. Last 4 lines. Including circumstances mentioned in section 3, such fact being one, that only competent authority will have the power to determine in the manner prescribed. So, my lord, competent authority will determine whether there is any, my lord, lawful heir to the property or not. And then, my lord, section 3, if your lordship will kindly see, notwithstanding anything contained in any other law for the time being in force, where a person dies intestate and without leaving legal heirs according to his personal law, or any corporation, trust, association, or society, or governing body of such corporation, trust, association, or society by whatever name called, recognized by law or capable of owning property, whether in its own name or in the name of any governing body or office bearer by whatever name called, the transfer to the state government of the property of such artificial person on his dissolution, winding up, becoming defunct, whether by operation of law, declaration, or in fact, or has ceased to exist, or is unable to hold the general meeting and reconstitute its new executives and committee consecutively for the last 5 years.
So this,
the property
order dated the impugn order 23 July 2019.
Yes, my lord.
How it has been on simpliciter.
Yes.
Without any notice.
No, my lord. Again, my lord, notice cannot be given to me as per the state because, my lord, I am not an heir.
Published.
Yes.
I think so.
They have affixed on the door. They have affixed on the door, but they have affixed, my lord, that they have already declared me and that they are about to take possession.
They did in 2023.
I think there is no rule in that. How would the property?
Yeah, I'm placing that, my lord.
Committee can proceed with.
Kindly see, my lord, at at page 4, section 4, your lordship will find that.
Inquiry, yes.
The collector, my lord, is to report to the concerned authority, competent authority, as to whether, my lord, there is any such property without any heir.
Who is the competent authority? How is the competent authority is described? Collector. In this act?
Collector.
Competent authority means the authority of the judicial
collector.
department of the state government.
Yes, my lord.
Authorized to function as a competent authority.
Land acquisition, first land acquisition collector will be, my lord.
Can you see the D, competent authority?
Yes, my lord.
Means any person or authority of the judicial department of the state government authorized to perform the function.
Yes, my lord.
So, the impugn order, it is the notice.
My lord will kindly see page
Who was the
302.
state?
Kindly see page 302, my lord. This is
That's
the
a- that's it.
order. My lord, now with regard to the court's query, my lord, as to whether the court in the writ jurisdiction can decide a question of title. I am not, my lord, I have not come for an adjudication of title in this proceeding because, my lord, I am conversant that that cannot be done here. But, my lord, lordship will kindly see one provision. Kindly allow me one moment. Yes, my lord, it is the explanation to section 4. Kindly see that. Whatever interest is sufficient to maintain an application for letters of administration to the estate of the deceased, or obtain winding up or dissolution of a body corporate, including a corporation or a company, or receive share of sale of assets of any artificial person recognized to be capable of owning property on its dissolution, sale, or becoming defunct, shall be held to be an interest sufficient to maintain an objection or representation against such estate or lapse in the preliminary inquiry. So, my lord, I say I have a caveatable interest, my lord. I have an interest sufficient to maintain an application for, my lord, grant of letters of administration. Because, my lord, I am the beneficiary named in a registered will, which again, my lord, must carry a prima facie presumption of validity. So, my lord, this order of vesting could not have been passed without my participation. And, my lord, next that,
So this 31 page, this notice 23rd July 2019.
Lordship.
Prior to that, there is no other proceeding.
No.
This is the notice which
Lordship.
they have decided. of
Yes, my lord.
Possession.
What they have relied in their opposition. Yes, my lord. And the opposition also, that is what is disclosed by the state. So, my lord, this is my interest. If the court is, my lord, satisfied that, my lord, I have sufficient interest to maintain an application for letters of administration, grant of letters of administration, my lord, that in itself is sufficient for me to defend any proceeding under section 2G or 3 of this act. And now, my lord, there is also, the state will also, I apprehend, my lord, take the plea that there is alternative remedy available to me under this act. So, may I show your lordship that provision also, my lord? There is section 4, my lord. There is also a provision for appeal from the order of competent authority. Appeal to be done, my lord, within 30 days from the passing of the order of declaration, or further 30 days for satisfactory reasons to be disclosed. But, my lord, there is a caveat here also that provides, my lord. Yes, section 4, subsection 7, my lord. The decision of the appellate authority shall be final and shall not be interfered with except by the High Court of Calcutta exercising jurisdiction under Article 226 or 227 of the Constitution of India, or the Supreme Court under 136. Also, my lord, there is another non-obstante, there's a bar of jurisdiction contemplated under section 9. That also naturally, my lord, leaves out the supervisory jurisdiction or the writ jurisdiction of the Honorable High Court. So, my lord, my case today is that, my lord, may I just place section 9, my lord? No suit or other proceeding shall lie against the state government or any of its authorities or officers in respect of any act or step or other measure taken under this act, or that is to be decided under this act, except as provided for in this act, provided that nothing in this section shall be held to exclude the jurisdiction of the High Court at Calcutta under Articles 226 or 227 of the Constitution of India, or the Supreme Court under Article 136 of the Constitution of India. My lord, the Supreme Court has also repeatedly said, my lord, that in light of these provisions of the SG Act, my lord, the writ jurisdiction of the High Court is not barred, my lord. The High Court, despite there being an alternative remedy of appeal being available, my lord, can intervene. And here, my lord,
The writ was admitted.
yes.
My lord, this is an obviously good arguable case.
And my lord, the coordinate bench of this honorable court has already, my lord, passed an order holding that I have an arguable case and therefore directing affidavits to be exchanged in this matter. My lord, may I just hand that up? 24th July 2023.
Yes.
So, my lord, my humble case is that I have an interest. I will have to place the document before your lordship, my lord. Your lordship will allow me to come back another day. I'm a little bit handicapped today.
So for my lord, maintainability of the state petition, my lord, kindly have a look my opposition, my lord. I have stated, my lord, he has no locus, my lord. He has no legal errors, any document. My lord, kindly have a look, page number 3 of my affidavit in opposition, my lord. Kindly have a look, para 5A. Subject premises, that is 40, Dr. Mohammed Udansu Road, Kolkata. So was originally the estate of one. I'm seeing my lord, this is my affidavits, my lord. Page 3. Page 3 of my affidavit.
Yes.
3, my lord, paragraph number 5A. Lord, kindly have a subject premises. That is 14 so and so.
No, that is correct. That he has stated the total story.
Yes.
Now the probate process, the PLA is pending before the competent court of law. And you are also a party over there. Correct. You are contesting that. So if he is contesting and you have issued this notice, so what would be effect of that? So if he is claiming the property, so he has no right to challenge this.
Because my lord has seen the section.
If on the basis, kindly come to the explanation of section 4.
Yes.
Kindly come to section 4 of the explanation of the act.
My lord, this is the, my lord, I have explained, my lord, page number 9 of my activities, my lord, I have explained, my lord. My lord, I have explained much. The gist of the reason order. Page number 9.
Yes.
Gist of the reason order passed by on so and so, published in so and so, so and so. Reason order was also sent to collector so and so and officer. A copy of the reason order and my lord section as per section 4(5) so and so. After that, my lord, after completion of this above formalities, the prescribed authority and first land acquisition collector Kolkata informed the principal secretary to the government of West Bengal land and land reforms department of this completion of this proceeding up to section 4 subsection 5 of the said act of 2012. My lord, next code of action, my lord, section 5 of the said act 2012 by office memo number so and so, photocopy of the said memo number annex P7, my lord.
Yes.
Annex P7, my lord, page number 30. Page number 30.
13 o'clock.
My lord, 31. Next page, my lord.
Question when you are participating in my PLA proceeding.
Whereas the first land acquisition collector Kolkata has the competent authority, the property number so and so.
Please, they have not denied in their reply.
Few proceedings are laid down in relevant sections so and so. My lord, and whereas the collector and stamp revenue Kolkata has been duly authorized to take steps to take over position, management, administration of the said property, my lord.
Admit করেছে 11 দেখে যাও pendency of my APL they have taken the position. What were they doing?
That
Yes.
May I just indicate?
Have you gone through the affidavit?
My lord, affidavit, paragraph 11. They have stated, if I just, my lord, 4th line, paragraph 11, page 16. Specifically denied that the petitioner is residing in the premises concerned. In fact, the respondent concerned has taken physical possession of the said premises as long back as on 31st March 2023. Kindly note the date, my lord. As on that date, the current PLA case, that's 448, that was pending.
No, but prior to that, the notice was issued. Paper publication,
Paper publication is done. Yes, my lord, paper publication is done. But that does not extinguish my interest.
That is what I'm telling.
No, not extinguish your, see, challenging the order, if you are telling that you are in possession of the property,
Yes.
you are residing in the property.
Yes.
As per this act, the authorities have complied with the provisions by publication of the notice, by issuing the notice and submitted the report to the competent authority, and competent authorities passed the order.
Correct.
So what's the difficulty?
The difficulty is this. Kindly see the dates of the orders that they are taking, my lord. Until then, they were aware that all these, my lord, PLA.
Correct, yeah, but you could have been appeared before the authority and filed the objection to the authority.
Yes,
see,
paper publication has been missed by me. I tell your lordship that. That is why, my lord, I have not been able to avail of the appeal mechanism in the statute itself. I showed your lordship the provision. So I am not trying to, my lord, dodge that. I am not trying to say, my lord. My lord, it is from the affidavit in opposition that they have filed in PLA 448 of 2021 that they have, my lord, taken these proceedings. That is my categorical averment.
What?
My lord, my averment is that from the affidavit that the state has filed in the PLA case that is currently pending before the coordinate bench, my lord, they have disclosed for the first time this purported vesting in the state
they filed the affidavit in
by
the
way of S-sheet. After 21, my lord, when the
they
PLA
filed
case
the affidavit?
I'll tell your lordship, kindly allow me one.
And when you initiated the PLA?
This current PLA case, my lord, is August 2021.
Then this is 2018. This is 2018.
Yes, they did. They did.
When you have withdrawn, when your mother withdrawn the PLA?
Yes, I'll tell your lordship, my lord, June 2017. 10th June 2017.
After that only they have initiated the proceeding.
Kindly appreciate, my lord. Prior to that, the state has been party to all the litigation that has transpired between the parties. PLA case 225 that has been filed by my mother. PLA 126 that is filed by this Deepak Agarwal. The claim of the Armenian church. So, my lord, so summarily to say that there is in fact no interest, that perhaps, my lord, is not correct.
See, if you are challenging the order, there should be one ground for challenging the order. What is your ground? Your ground is that you already filed the PLA case, state is the party, or the state has filed the objection from where you came to know the order.
My lord,
the order is not a reasoned order, that's why you're challenging.
Lordship.
But the affidavit which they have filed disclosing all the document by complying the provisions of section 4 of the act.
Now, my lord,
So how the court can interfere with that?
My lord, section 4 explanation says, if I have a interest sufficient to maintain an application for letters of administration, I can oppose the proceeding. Now, my lord, the only lacuna on my part is that I have missed the paper publication. I have not gone against the proceeding that they have initiated under section 2G or 3. Now, the legal question that arises for your lordship's kind consideration is, if I have not been able to avail of the challenge mechanism under the statute, that is, my lord, preferring an appeal against the order of the competent authority within 30 days.
You said the appeal, okay, and the court could have been interfere with the order if it
Yes.
is the opportunity of hearing. But the question is that there are several notices have been published, but you are telling that you are in occupation, but the paper publication was made.
There's one fact that is very material, my lord. Paper publication may have been made. I have missed it, but kindly.
Shall I tell why you are not appeared before the authority? Because at that time there was no probate proceeding. That's why you are worrying about to appear before the authority in 2018, because
that perhaps may have been
2017
but,
you have withdrawn, 2021 when you came to know the proceeding, and then again you filed the 2020.
My lord will consider only one fact. My lord will consider only one fact. Appreciate only one thing, my lord. There is a registered will in my favor of 2013. My lord, registration, A, my lord, it carries a presumption of validity. B, my lord, it carries a presumption that all and sundry is aware of the existence of a registered document. Now, my lord, all and sundry here includes the state authority, because they have also themselves participated in PLA 225, where I'm seeking probate of that registered will. So, my lord, that registered will cannot be wished away. Also, my lord, there is no limitation for, my lord, seeking probate or letters of administration. So, my lord, my right there is not extinguished. Kindly appreciate, my lord. Section 4, my lord, proviso says, or the explanation says, if I have an interest sufficient to maintain an application for letters of administration, I can oppose the proceeding. That interest till date is alive. It is not extinguished. Number one, I am claiming on the basis of a registered will, prima facie presumption of validity, presumption that all and sundry is aware of that document, and the state has participated in the PLA proceedings. They are specifically aware.
What is the stage of the PLA?
PLA case is adjourned sine die, my lord, because this adjudication of title is required first.
or adjudication of whether the vesting is valid or not is required first. That is why. That is the status of the PLA case. So my humble submission before your lordship is, state is aware that there is a registered will in my favor. State is also aware that my entitlement to maintain an application for grant of letters of administration is not extinguished. That is still live. And PLA case is pending today. So in these circumstances, whether, my lord, there can be any valid order of vesting under the ST Act. That is the, my lord, question that will arise for your lordship's kind consideration.
Why should not this order be stayed till the probate proceeding is over?
No, my lord, whether
Because already there is a probate proceeding, you are contesting that. Correct. Suppose today the writ petition is dismissed, you taken possession, and tomorrow they prove the will. Yes, he is entitled as a beneficiary of the will. What would be effect of that? What would be effect of that?
first of all, my lord, 2018-19, my lord.
That's correct. I am totally agree with 90% with you. Correct. You have complied with all provision. You have published the notice. You have issued the notice. They have not appeared, and you have submitted the report to the competent authority. Competent authority pass an order. Completely agree with you for the time being, but at the same time, you are contesting the probate application. Probate application in terms of the registered will. Earlier, what was the legal proceeding? Final decision, that is different thing. You are contesting this. So, and now the proceeding has been stayed because of the order passed by you. Unless and until the title is not cleared. Correct. And the probate proceeding, the title cannot be. The probate only has to see with regard to the whether the will is genuine or not. Correct. So my question is that, okay, you have taken, the court is only asking you, or you take instruction. They are in possession, or you are denying whatever it is, as on date, whatever it is. Let this may be kept pending, kept in abeyance. The probate proceeding be proceeded for. If they won the probate proceeding, automatically they have a right to appear before you and to place all the things with regard to the title. If you are accept that yes, you have a title, then automatically the order will be recalled. If they have no title, this order will prevail. Take the instruction on that. Practically, I am telling.
Maybe come back then, my lord.
Correct. Because suppose what will happen in future? The probate case cannot dismiss. Yes,
It will become infructuous then, my lord.
Probate case cannot dismiss. No, this petition has been dismissed. Probate has to be reach its own conclusion with regard to.
And my lord, I'll just tell your lordship one thing, my lord. The escheat rules also says, my lord, even if there is a vesting for a period of 12 years, you cannot sell the property because the, my lord, legislature is aware or conversant that these claims crop up.
That's like the enemy property.
Lordship.
That's like the enemy property.
Lordship.
So take a decision,
Most
take instruction. If it is so, that will be better. So you proceed with that, and you take this also in the probate proceeding. Let the court decide if they able to prove the will. If it proved, the petitioner has argued the matter at length. Full stop. Full stop. The respondent is directed to take instruction whether the impugn order can be remain kept in abeyance till the disposal of the proceeding initiated by the petitioner for grant of letters of administration in which the state is also party. Let the learned advocate appearing for the petition respondent will take decision within a period of 1 week, 2 weeks, within a period of 3 weeks. Leaks the matter on 7 January under the same heading. 6 January under the same heading. PM has to be mentioned. Let he take the instruction.
Sanction for I get sales tax 75% on I set up a project. I set up the project.
Milord, I appear, Milord, for the state in this matter. But here,
Yes.
Milord, challenge why this of a statute is challenged in this proceeding. Milord, similar repetitions have been filed.
That's why.
But
why.
I was pleased.
Mitra, altogether, I think 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. 13 writ petitions are pending. 99, 90, 91 appellate side. Same.
I got a mandate in my favor. Mandate is I appeal for the mandate appeal. Supreme Court dismissed. I filed contempt petition.
Now they are amended. Statute has been amendment. Just all these things. So that's why whether all the writ petition is to be taken in the original side or it is to be taken in the appellate side. So all the question is same.
That's bylaws, housekeeping. I will not enter that. But I don't know what the exact facts are, but it should follow the same.
More or less same.
Here's now. I will make my submission. When you add something thereafter, we can do that.
So what I am telling, I am fixing a specific date of this matter for hearing in this original site. And other matters also be taken on the same day in the list. So all the application can be taken.
Very well.
Yes, Mr.
Very well. Yes.
60 and the same. You are appearing for 84 to 95. Okay, I am fixing in the month of February as a specific date. In the meantime, the parties may come. No, that's a date, and the 2 dates I will fix. 2 dates I will fix in a month. Now, in your case, affidavit is filed. So let it be fixed on. I am passing this order. In this order. In the appellate side, when the matter will be listed, you mention, I will direct. The petitioner has challenged the virus in the West Bengal incentive scheme within bracket obligations in the nature of grant of incentives bracket was Act 2005. It is found that affidavits have been completed. Learned counsels of some of them full stop. It is informed from the bar. There are analogous matters are pending before the appellate site. Full stop. There are other 2 matters being item number 60 and 73. That is WPA number WPO 381 of 2021, 2025, 60 and WPO 577 of 2025. Let all these 2 matters be placed along with the present date application on कौन सा डेट है 2 डेट दे दो है टाइम है दे दो 27th and 29th January at 3 p.m.
Very good. I'm grateful with it.
Interim order is extended till the next date of hearing. Yes. Who is for the respondent? Mr. Ayan Banerjee? Not today. Yes, next.
Yes. I believe that this is I can be there, but I can't be construction. I am only aware of the for which I am any authority or agency will take that only there. Now, the argument surveyor he has stopped this because of the fact that I am that distance. That distance is not an absolute prohibition. That distance is a prohibition for further construction, but not for repair. That has been the judgment. It's page 7. Connection got paragraph 36. In connection with got the concerned statutory provision of the Act. Clause DC, paragraph 36. Page 230.
Yes.
Clause DC of section 2 of the same Act will be the most important part. The definition of construction specifically excludes the following. 1. Reconstruction, repair, and renovation of an existing structure or building. 2. Construction, maintenance, cleansing of drains and draining works and of public latrines. Construction and maintenance of works made for providing supply of water for public, and construction or maintenance extension and for supply and distribution of electricity to the public or for public. Number of comes paragraph 42. One thing is to be noted that clause of section 2 of the same Act itself excludes 4 categories as mentioned here above from the definition of construction. The legislative intent is thus clear that the 4 categories which are excluded from the definition of construction as defined in clause DC of section 2 of the Act should not be treated as a construction whenever the same term is referred to in the statute. The legislative intent is clear that the reconstruction, repair, renovation of the existing buildings has been excluded from the definition. Similarly, the construction maintenance of draining works, public latrines, cleaners, construction maintenance of works meant for providing supply of water to public, construction, etc., for distribution of electricity, which could be assumed to be essential services, including the public at large, have consciously been kept out of the definition of construction. It could be presumed that the legislature was aware that repairs and reconstruction of existing structures or buildings or construction of essential facilities like public latrines, cleaners, water supply, are basic necessities, and as such, should be permitted even in the voluntary. If it is not so interpreted, then section 20C of the same Act would be rendered sure and redundant. It need not be emphasized that an interpretation with a particular provision to be sure redundant or meaningless has to be avoided. Because this is the issue of which are basic facts. I have applied not at least 33 parentheses. People are in the corporation assistant engineer saying that plastering cracks have appeared and therefore I am required to repair my building. It's addressed to one Mr. Puyan Paul, page 33 and 30. I have thereafter engaged a conservation assistant. Thereafter, page 35 and 36, we got so-called notices. Please see page 35. Second paragraph, we indicate that the attention is brought to the provisions of the ancient documents and archaeological sites and events that anticipated those and gazette notifications such as are dated 16 and the ancient monuments and archaeological sites and events amendment and calculation act 2010 promulgated on 30th of March 2010. It is stated that 100 meters from the protected limits in all directions of a protected monument is declared as prohibited area
where no construction and mining work is allowed, and further 200 meters from the point comes the of the point where such construction mining work may be permitted, subject to prior approval by the National Monument Authority. The competent authority and still factor of the survey of Calcutta after submitting details of plan application of such structural mining work. Therefore, you are hereby requested to stop the ongoing repairing work and refrain from any kind of further repairing of the construction. Now, Lord, you have been trying to this notice on 1st of November 2020. That's the page just before the page 34. Here, yes. Page 34 is our letter of reply dated 1st of November 2023. Paragraph 2. With reference to the above letter, we draw your kind attention to the fact that our building House is about 62 years old. Like every able building cases, our building was also facing some health-related impairment and issues like falling of concrete, reinforcement portion, water seepage, etc., which urgently needs to be addressed and repaired. We approach Department of Civil Engineering for seek their expert opinion on the repair of the building. They carried out some tests and submitted the report to the repair methodology. Accordingly, we are executing the repair work. At least note that we are not doing any kind of new construction or alterations. For your perusal, we are executing the report of the after that, the time is
Where is the
November.
where is the report of Jadavpur?
That's at page 28. On site visit at House. Salient observations, first page, bottom, several tracks for observing projected portion, falling from ceiling, air handling unit to the chiller supporting girders and columns and flashing. These problems in the car parking area were observed with the extraction joint of the nothing in the connected area of construction. Additional requirement for this possible replacement of 8 kilometer overhead tanks by a single 50 kilometer tank for which the detailed analysis of the construction requirement. Photographs are given from my lord now to conclude remarks. That's at page 32 of my lord brief color. 28th of June 2020.
Yes.
Paragraph 5. Concluding remarks for the study of the weekend suggests solution by treatment of the technology on destructive evaluation based part 1 and for exploring the possibility of chemical tanks by a system tank. Structure management required part 2.
Yes.
University must be approached the subsequent activity.
So what you prayed for? What you prayed?
Of the notices of claiming stop work, but not unconditional.
Where is the notice?
Yes.
Acha, 35, 36.
And 36. Now they are keeping on saying that because it's within the political interest from the Supreme Court judgment that repair work is permitted. I have no issues if anyone oversees the repair work and ensures that the same is being done properly and in accordance with the technical requirement. And Mr. Ghosh is for the corporation.
Who is for the?
Mr. Sujit Chakraborty appeared on the occasion before last week.
He concluded. You have not seen the speed. Yes.
The only thing is that the construction or the renovation has that they are only in the area of the heritage field. However, if you are to kindly see, it's 35.
Hundred meters from the protected limits.
They were asked to stop the what if there was no emergency from the concerned party. However, there was the they or rate by city. There are the but again they have written to the department that we have spoken his land from the government. But my lord, till then, there is neither any approval from NOC nor any NOC from the department. And neither what they have applied.
Which department? And no,
Because the authority of giving NOC lies with the chairman. There is no such application.
no. Mr. Srijit will. He's very strong. Don't feel he is very weak. Yeah. First or second? There are two flags on that. Yes.
ঠিক আছে তুমি দেখে নাও না Lord, kindly take the next page. National Monument Authority applications. Lord, these applications I'm referring. Lord, they, Lord, kindly see serial number 25. J. Thomas and Company. Lord, kindly take the application date 7th February 2025. Received view. I have seen that.
Yes.
Then kindly will take the next page. November 25, with reference to your letter number so-and-so 1, J. Thomas and Company, Kolkata, has submitted an online application 5th May February 25 for issuance of NOC for repairing outside the building before exterior painting works for the main building. After scrutinizing the online application, it was sent back to the application on 7th February for submission of additional documents information. Screenshot is enclosed. Answer 1. Kindly see the next page.
Yes.
Submitted. Application is pending. Then kindly see the second bottom column, extreme right. With reference to your application, NOC application, this is to inform you that while scrutinizing the documents uploaded by you, some shortfalls have been found. Therefore, kindly look into the following submissions, resubmission of application. Kindly note 1 to 7 points, then 9 affidavit rupees 10, then item number 10, so and so 11 goes on. Kindly come to the last. Please upload section drawing. Please rectify the name of the locality of the repairing site in form 1. So whatever was submitted, that was sent back to them. That information has not been given to your lordships. I'm sure Mr. Banerjee did not have it, otherwise you would have shown it to your lordship. So it's a defective writ petition. Yes, so if the application doesn't survive, wherefore you are here?
Well, I have short submission on this, my lord. And admittedly, it is a heritage building. Now, my lord, they have applied the applications to before that authority. That authority they can apply because of certain reasons. But apart from that, under the act itself, our act, state act, well, any heritage declared heritage building is to be preserved, maintained by the owner or the occupier. If it is not maintained properly, and if it requires certain nature of the works to be done, the first thing it is to be done, it is to be examined by the conservation architect, to be appointed by them. Then the conservation architect, the required works to be intimated to the Heritage Conservation Committee. Then they will consider it and give permission. And with that permission, what more is required by their central authority, my lord, then they may approach. But it has not been approached to us because the the building department initially has nothing to do. Building department has not permitted because of that, the obstruction or objection. That is the reason. But the primary thing, they have to approach to us, the conservation committee. They have to take the permission because the conservation architect to be engaged. They say, because ultimately it is to be preserved and maintained. There is no doubt about that. But first of all, the permission is to be obtained. Then whether it will be permitted or not, the central authority will say.
Okay.
One more information. Just have a look at page 32 of the writ petition. Just have a look at page 32 of the writ petition. It is the petitioner's document which they have produced. Page 32. That's a document. It starts at page 28. Report on site visit. My lord has got that. The conclusion is at page 32. Kindly take the conclusion. For health study of the building and suggest location wise repair, retrofitting methodology, non-destructive evaluation is necessary, part 1, and for exploring the possibility of replacing. Now, if my lord takes up the act,
Replacing 4 10 kilowatt tanks.
Yes.
By the single 50
So
kilowatt.
these are additional constructions. It is not a repair.
No. See, this is tank.
Not the
Is
yes.
The RCC or the
Replacing for 10 lakh tank by a single 50 lakh tanks.
correct.
For 10 lakh tank by a 50 lakh tank, structural analysis is required to part 2 according to latest IS code to consider what's loading condition. The university must be approached with the scope of work defined above so that the subsequent action may be taken after detailed health study and analysis report. Now, can I take the act which is there with my report, with my documents? Can I take the act? First document. It's not paginated. Annexure 2 in the top on the right hand side. It is Annexure 2.
Yes.
Lord, the construction is defined in section 2DC, Delhi, Calcutta.
2DC.
That's construction.
Yes.
Then can you take the other provision, section 20A and 20C.
Declaration of provision area.
Declaration of prohibited area, every area beginning at the limit of the protected area or protected monument as the case may be and extending to a distance of 100 meters. Within 100 admittedly, in all directions shall be the prohibited area. The building is in prohibited area. Now kindly come to 2C, 20C, application for repair and renovation. Any person who owns any structure which existed in a prohibited area before 16th June 1992 or on which had been subsequently constructed with the approval of the Director General desires to carry out any repair or renovation of such building or structure may make an application to the competent authority for carrying out such repair renovation of such. According to them, they made an application on 7th of February. There were 2 so-cause notices issued. First so-cause notice, second so-cause notice. After what we found after issuing the first so-cause notice, they continued with the construction, which prompted us to issue the second so-cause notice, which is the 2023. They waited for 2 years. They made an application, which has been returned to them, made an application for permission. So they are not questioning our authority because they submitted to our jurisdiction. But the application has been returned. They should make another application. And without doing that, they have come to your lordship. So in my humble submission, this is premature. Let them do that in terms of law. And if it is all right, we'll consider it.
So just 2 responses. One first to Mr. Ghosh's. Mr. Ghosh's client has given me permission to make the repair work because Rule 3 sub Rule page 33.
That cannot be acted upon.
There can't be a reply of a reply. The document will speak for itself. Let me see. Document will speak for itself. And mine is not a heritage building. Mr. Ghosh is suffering from one factual error. Mine is not a heritage building. Mine is a perfectly non-heritage building. Had mine been a heritage building, I would have been required to approach the Corporation Heritage Conservation Committee. I am aware of that law.
Yes.
So this is, he says, take permission from the Archaeological Survey of India subject to NOC. You don't need, they say repairing work. I have put in, Milord, an architect group called Sabto, who are in charge of buildings in old British Calcutta, who take up that work. They have done it conscientiously. At that time, they received 2 stop work notices. Today, Mr. Shijit Chakraborty is absolutely right that if the application which we have put in before them shows that we are submitting to their jurisdiction, right? Because the 20B itself says that we are supposed to take their permission, a nod. But that these are not constructions are covered by that Supreme Court judgment, what we are trying to do. 40 KL replaced by 50 KL, superimposed weight will be lesser because this is a syntax tank. Earlier one was a not RCC tank. Therefore, naturally, superimposed weight will be later. That is for the technical persons to see. Any other plaster track repair, etc., are all strictly within the scope of repair. That replacement also comes within repair. My Lord knows if you replace one thing by another, that is repair. That does not amount to reconstruction or addition. Now, Lord, on that we made an application to them. They have shown me, Lord, something to me which was not known to me. The fact that they have returned the application.
This is what has been.
I am humbly submitting this. Lord, in view of their return, here, I will furnish them with additional documents, with rectificatory documents within 7 days. Let them take a decision and place it before the court after.
There's no point in keeping it pending. Let them first apply. Arey Baba. In the next matter also, Mr. Banerjee will brief. There is nothing to worry. Where will the client go?
Adversarial litigation, not this is not a brief deciding application. A court company which has a building wants to repair it. It wants to be in consonance with the law. It's found out that they have returned the application or one or two alleged defects. Let them give this to me today. Within 7 days, I will make good the defects. Let them come up before this honorable court with their response to the application so that once and for all we know whether because of the fact that that building is there, my building will remain unrepaired and collapse on our head, or whether we can proceed further. Otherwise, if a new round starts, then again a fresh application will have to go. That fresh application they will sit on. There is absolutely no logic for this. There's perhaps some ego hurt somewhere. We are ready to even massage egos if it is accordance with law. Kindly not let this thing let Mr. Chakraborty not be adversarial. It's a repair of a building. I am not gaining any brownie points from this.
Yes. Lord, who is getting what I don't know. Who is going to get a massage I don't know. I am not surely for getting a massage. Whether Mr. Banerjee
not required massage. That's
what I say is not what I say is today your lordship is not shown with a new fact by us which they have not produced. Now, my lord, I can produce that with an affidavit or I have handed over the record. This is one. Now, my lord may, subject to lordship kind sanction, dispose of the matter, directing them to make an application. We will consider that. But keeping this pending will enlarge the scope of the matter. My lord, they want, Lord, I tell you, lordship, what is the difficulty? I would not have said anything. But the authorities will be under constant pressure that your lordship is monitoring the progress, which your lordship would not. Lord, the application which was submitted to us, we have returned in time. You have not been available. So you can't today ask the court to monitor it. Dispose it up. Let it not be kept pending. Let them make an application in terms of law. Whatever is there, trust us, we'll decide that. If we fail to decide, your lordship will exercise your lordship jurisdiction. But as of now, kindly do not keep it pending and monitor this, my lord. I don't think it's a case for monitoring.
Application just once, so he's not giving me the copy. That's right. The application. He's not rejected my fresh application.
That's why it has been sent to you. You have
Same back.
Correct. That's why he's telling that is a pre-match.
What are they asking? May I just please? Just one second. Remarks. So he's not rejecting my application.
Correct.
I might reject after you give it to me.
If you have decided, then might as well reject it here. Please.
I might allow also.
Not you, your authority, thankfully. Please upload stop notices / show cause notice issued by ESI if any. So they don't go about their own notices. You are also requested to upload the copy of compilation to the stop notice, show cause notice. In case of repair, renovation, a report from the authorized license submitted by the affidavit
So that's why, Mr. Banerjee, I am disposing of this application. You have filed an application before the authority. Authority have considered your application and found that some documents are required. It has been returned back to you. You are directed to submit all the documents within 2 weeks. On receipt of the document, they will take a decision within 4 weeks thereafter.
They will file a comprehensive application. We'll take a call on that.
Whatever they have asked for,
but
that will be done. Now their
application is with you.
No, we have returned it. My lord, we have,
That's why this
the letter, 25th November letter says, I'm reading it for your lordships.
correct.
One
With
J.
reference to
Thomas
the data
Company,
and following information.
after scrutinizing online application, it was sent back to the applicant. So they have to file a fresh application
same application there
for
are.
submission. So why don't you submit it again?
Additional documents. Why do you want the process to be repeated? What, Lord, what?
But
will
if
be
Mr.
statutory
Banerjee wants to make it cumbersome,
I'm not making.
I was just trying to assist him.
Accepting what has come, Lord, from Mr. Chakraborty is a very fair suggestion. My only thing is, why does he want a fresh application to be filed? An application was returned for the purpose of enclosing additional documents. That will go back, Lord, and let them decide on
But
that application.
if it was in my hand, I would have, my lord, done whatever my learned senior friend asked me to do.
And therefore, it
But
is
the
being-
authorities, my lord knows.
I
My
don't
lord has
understand what the ASI will gain
নতুন
from
করে apply
stopping a
করো না,
citizen
আবার
from
ঝামেলা
making
হবে।
repair. And I don't understand what brownie point Mr. Chakraborty's client will score by stopping a citizen from making
But I
repair.
believe Mr. Banerjee is earning some brownie point by making these submissions repeatedly.
No, I'm
When his
repeating
application
myself.
is disputed, but then kindly decided on merit that this is not maintainable. Let it be decided that this is not maintainable. Nobody is earning here to earn any brownie point. Lord, we'll get a stop.
Your client,
Yes.
not you, you have
Guys,
enough
sit down,
brownie
Lord.
points. Your client is earning brownie points by stopping me from proceeding. Why will I be stopped from proceeding? My lord has
If a respondent doesn't do anything, you say they are not acting. If they do something, you say they are stopping you.
If they have pointed out the shortcomings, I put it in.
Go and make a fresh application.
The petitioner has
Lord, kindly keep
filed
this
an
on record.
application.
Lord, kindly keep this on record to your lordships. My lord. This bunch, keep it on record. আমাকে চিঠি দিয়েছে দেখো সাহেবকে তো দেওয়া হয়েছে বলুন ওকে দেয়ই নি
Petitioner
ওই
has
তোকে
filed an
ইমেল করেছে
application before the to whom you have submitted the application. To Archaeological Survey of India.
পেজ 37 এক সেকেন্ড
No.
কাকে অ্যাপ্লিকেশন করেছো বলছেন জজ সাহেব
Page 37.
Page 37 the application is to be made to the competent authority and regional director. That is not in terms of the act.
The petitioner has made an application to the competent authority and the regional director of Eastern Region, Archaeological Survey of India.
তুমি
for
দেখে নাও ভালো করে দেখে নাও
repair
আমাকে যা পাঠিয়েছে আমি তাই
of
তুলে দিলাম
building
এই যে
situated
দেখো
at 11 RN Mukherjee Road.
এই যে আমি খুব ভয় পাই
Mark
এরা কি
inverted
বলে
comma,
তোমার ডাব্লিউপি নাম্বারও দেয়
Nilhat,
এটাই কি হ্যাঁ
NILHAT, Nilhat
রিজেক্ট
House, inverted comma close, Kolkata, 7000001.
এই ডাব্লিউপি নাম্বার দিয়ে তো
The
হুম
on
আমি কি জানি তো
20 October 2023, the Conservation Assistant of Archaeological Survey of India issued a notice directing the petitioner to stop the construction work. And subsequently, again on 2nd of November 2023, a notice was issued to the petitioner
আমি তো কবে থেকে
intimating that
বলেছি আমার না চারটে মামলা আছে
intimating that requesting the petitioner to stop the ongoing repairing works and refrain from any kind of further repairing of the construction. Being agreed with the said notices, the petitioner has filed the presented application, praying for setting aside and quashing of the said notice and allowing the petitioner to repair the said work, repair the work of the building in question. He submits that the respondent authorities have not allowing the petitioner for repair of the said work as the building in question is situated within the 100-meter distance from the national monument.
কি চলছে দিল্লি যাওয়ার জন্য
And at consent for the petitioner submit that repair will not, the respondent authority cannot stop the repair of the work. Even the building in question is coming within the purview of the national monument. Learned counsel appearing for the petitioner has relied upon the judgment in the case of Arnendu Kumar Das versus State of Odisha and others, reported in 2022, volume 14, SCC 227, and submits that clause 2DC of section 2 of the act would be the legislative intent is thus clear that 4 categories which are excluded for the definition of construction as defined in clause D small c comma bracket D small c small of the section 2 of the act would not be treated as construction. He submit that in the present case also the petitioner is not making any construction. The petitioner is only making the renovation work. He further submitted the petitioner has started the renovation work only after receipt of the report from the department from the Jadavpur University and no objection certificate from the Kolkata Municipal Corporation. Learned Counsel appearing for the Archaeological Survey of India has filed the report and draw the attention of this court and submits that on 25 Learned Counsel appearing for the Archaeological Survey of India has submitted the report and on instructions submits that the application submitted by the petitioner for repair of the building in question was returned back to the petitioner on 7th of February 2025 for submission of additional documents / information. He submits that the petitioner has not submitted the relevant document in terms of the notice dated 25/11/2025, and as such, the writ application filed by the petitioner is premature and liable to be dismissed. Learned Counsel appearing for the considered submission made by the counsel for the respective parties. This court finds that the petitioner has already obtained no objection certificate from the Kolkata Municipal Corporation on 13th of March 2025. And the petitioner has submitted an application before the Archaeological Survey of India for repair of the premises, but the said application was returned to the petitioner for submission of relevant document. Accordingly, the writ petition is disposed of by directing the petitioner to file a fresh application along with the relevant documents, which the relevant document in terms of the letter dated, in terms of the letter dated 25/11/2025, within 2 weeks from the date of this from date, and on receipt of the application, the respondent who is the respondent? Respondent number 2? No. Respondent number 3? Respondent number 4? Okay, good.
The authority to sanction permission is under the Act
5. Regional Director, Eastern Region.
No. Just give me a second, Lord. The competent authority, West Bengal EMSR Act. Competent authority ke party করেছো তো তুমি?
Maybe respondent number 5.
No, Archaeological Survey is not the authority. Competent authority is the authority, Lord. Under the Act, Archaeological Survey is not the authority.
On my claim, Lord, can you add him as a party?
Yeah,
Competent authority, ball.
Just a second. আরে আমিও সব বলে দিলে তো আমার উপরে দোষ চাপাবে লোকে। দাঁড়াও এক সেকেন্ড।
Competent authority means an officer not below the rank of director.
No, Lord, I'll just give you a lordship. It is stated in the Act only. I have seen it. In a hurry, I am not being able to show it to your lordship. Huh? Yes. কত পেজ বলুন তো?
Regional Director, Eastern.
Yes. 5.
क्या बोलना?
Competent
To
authority
the
and the regional
the
director,
competent
Eastern
authority
Region,
that is
Archaeological
before
Survey
the
of India.
regional director within bracket
Director.
Eastern Region, Archaeological Survey of India,
Currency Building.
Currency Building,
1 BBD,
1
Bagh,
BBD
Kolkata.
Bagh, Kolkata 700001.
Who is the competent authority?
On receipt of the application of the petitioner, comma, the respondent number 5 shall take appropriate decision within a period of 4 weeks.
Make it some. Make it some.
He's asking more.
Because 2 বছর ধরে তুমি বসে আছো। Make it 8 weeks at least. বৃষ্টি আসবে তো
Within a
শীতকাল
period of
পড়লো।
within a period of 6 weeks.
এখন বলছে বৃষ্টি আসবে
And
জাস্ট
to
শীতকাল
communicate
পড়লো।
the same to the
যা নয় তাই।
to the petitioner.
হ্যাঁ।
That's all.
I'm not in accordance with law will decide.
This court has not gone into the merit of the matter.
Yes.
Only on the basis of the communication, only on the basis of the letter
Who is the competent authority? আমি কথাটা দেখলাম, লিখে আনলাম জানেন
the
স্যার।
authorities have
জজকে
written
উত্তর
the
বললাম না।
application to the petition. This court
খিদে
has
পেয়ে
passed this
গেছে।
present.
I have a copy of that letter because that's not on record. But please,
You are not given.
that he has not given.
ছবি তুলে নাও।
That he has kept his proceedings just now. Because kindly make it part of the order because my lord relies on that so that I can also
Give the
get a copy.
এগুলো ছবি তুলে নাও না এই তো। Take a photo. Take a photo of this. I'm so grateful to your lordship, my lord.
Your lordship, can you direct him to serve me a copy in the order?
I will have to get a photocopy. Copy করে নাও না।
The learned counsel appearing for the respondent number 5 is directed to serve the copy of the communication dated 25th of November 2025 along with the connected documents to the petitioner.
The petitioner's learned advocate.
To the learned advocate on record of the petitioner by 19th of December. So.
ছবি তুলে তোমাকে স্ক্যান করে নাও।
All electricity matter is there.
The other side is also present, Lord.
Yes, your
Lordship,
objection.
Your Lordship, I have some difficulty tomorrow, Friday.
Your objection for grant of electricity.
Your Lordship, the parties that have been arrayed, individually, advocates have been arrayed.
Lordship, I have been made a
Advocates are
party.
standing over here in the.
It is regarding one of the offices
This
here.
is, the objection is to such a level that, Your Lordship, when the matter is taken up, we will inform Your Lordship.
Then
Watch out.